Hello, hello, hello. Cheers. Check, hello, hello.
Check, check, hello, check, hello. Hello, check, hello, 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 check, hello, check, check, hello, hello, check, hello.
Namaskar. A very good morning to you all. Ladies and gentlemen, on behalf of the Department of Legal Affairs, Ministry of Law and Justice, Government of India, I would like to extend a warm welcome to you all to the first technical session of Conference on India's Progressive Path in the Administration of Criminal Justice System. The topic for this session is Bharatiya Nyaya Sanhita 2023 BNS, the new act replacing the Indian Penal Code 1860. We will delve into an analysis of the main features of BNS its emphasis on gender justice, and a relook at the punishment for offenses under this Act. This technical session is meant to be a platform for deliberations to unravel the intricacies and nuances of the transformational legal reforms that will take effect from the 1st of July 2024. I would encourage all participants to leverage the session for thought-provoking, innovative discussions and fostering collaborative dialogue and knowledge sharing amongst the assembled distinguished legal minds. We have a distinguished panel who have years of experience in the criminal justice system, and it would be really a delight to hear from them. This session will be chaired by Honorable Mr. Justice Soumitra Hoikia, Judge, Guwahati High Court. I'd request you, sir, to kindly come forward and take your seat on the dais. Thank you. The moderator for this session would be Professor Vageshwari Deswal, Faculty of Law, University of Delhi. Ma'am, could we have you on stage, please? Thank you. And the panelists are Sangeeta Pradhan, Deputy Solicitor General, Sikkim High Court; Ipsita Borthakur, Special Judge, PO CSO Nagaon, Assam; Shri Amol Dev Chauhan, Associate Professor, National Law University and Judicial Academy, Assam. Can we have you all on stage, please? Thank you. I'd now hand over the session to Professor Vageshwari Deswal, Faculty of Law, University of Delhi, the moderator for this session, to commence the proceedings. That would be better. Okay.
Good morning to all the dignitaries, legal luminaries, guests, and welcome to the conference on India's progressive path in the administration of criminal justice, organized by Department of Legal Affairs, Ministry of Law and Justice. This is a momentous occasion as we gather here today to deliberate on the three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. Bharatiya Nyaya Sanhita is set to replace Indian Penal Code that was enacted by our colonial rulers in 1860, and the focus, as is evident from the title itself, was on punishment. In 2023, our democratically elected representatives enacted a new law with focus on justice for their people. The law has been restructured and reorganized systematically. Many archaic provisions have been deleted, and new provisions have been added to make it contemporary, progressive, and futuristic. I am Professor Vageshwari Deswal, the moderator for Technical Session 1 on Bharatiya Nyaya Sanhita 2023. It is my privilege to introduce to you my esteemed panel. The chairperson of this panel is Honorable Mr. Justice Soumitra Sakya, Judge, Guwahati High Court. We have an eminent panel consisting of representatives from the bar, the bench, and from the academia. We have Ms. Sangeeta Pradhan, who is the Deputy Solicitor General of Sikkim High Court. There is Ms. Ipsita Borthakur, Special Judge POCSO at Nagaon, Assam. And we have Dr. Amol Dev Chauhan, Associate Professor, NLU, Assam. I would now request our chairperson, Honorable Mr. Justice Soumitra Sakya, to give the introductory remarks.
A very good morning to all of you. Nice to see all of you familiar faces here this beautiful Sunday morning. We are here to begin the first session And I would just like to go back to what has been deliberated upon yesterday. The first session pertains to the Bharatiya Nyaya Sanhita, BNS, which is the new Indian Penal Code. I'll just give you a brief outlay about this new act. This BNS has been concised, and it contains now only 358 sections as opposed to 511 sections of the IPC. Earlier, under the IPC, there used to be some incomplete categories of offenses, like attempt, abetment, conspiracy. All these have been brought together under one chapter. There are about 21 new offenses which have been added. The term of imprisonment for 41 offenses also has been increased. Then it repeals 19 provisions, changes 175 existing provisions. In all, about 64% of the earlier IPC has been changed. Some of the newly introduced sections are the abetment outside India for offenses in India. This is under Section 48. Section 69 deals with the sexual intercourse by employing deceitful means. Section 73 is about printing or publishing any matter relating to court proceedings without permission in respect of offenses referred to in Section 72. Section 111 is for organized crime. Section 112 is for petty organized crime. Section 113 is Terrorist Act, which is an entirely new section which has been brought in. Section 152 is regarding the earlier sedition section which was repealed, and a new section 152 has been brought in, which gives a punishment for acts endangering the sovereignty, unity and integrity of India. Now, attempt to commit suicide under the earlier 309 has been deleted, but there's a new section 226 which has been brought in, made punishable for attempt to commit suicide to compel or restrain the exercise of power. Another important section which has been brought against is snatching under Section 304. So, actually, to be honest, I had prepared a small slide, but then this morning I came to know that there will be no slideshows. So we've got a printout, and I declare this first technical session to be open. I request all participants to participate and ask whatever questions and doubts they may have with regard to this act. We will try to satisfy you with your answers. And this is an opportunity which has been given under the aegis of the Ministry of Law, Government of India, to deliberate upon these three new acts which has come in. And I think everyone present should take full opportunity of this particular conference. I thank the Secretary and the Ministry of Law and Justice for organizing this conference and giving me an opportunity to preside over this first technical section. Thank you very much. Let's get started.
So thank you, Lordship, for setting the tone for this session. Now we begin with our panel discussion. Okay. So with your permission, we now start the panel discussion. My first question is to Ms. Sangeeta Pradhan. Madam Sangeeta, Bharatiya Nyaya Sanhita has decolonized our substantive criminal law by removing terms referring to the colonial era such as British calendar, Queen, British India, etc. Okay. In the same vein, what we have done, we have replaced the offense of sedition that was earlier given under section 124A of the IPC, and that entailed strict liability as well. So now what have we done? We have replaced it with treason. So now instead of Rajdroho, now we have Deshdroho. So how do you see this change?
Thank you for the question. Good morning, all of you. First, I would like to refer to section 124A of IPC, which says, which deals with the offenses of sedition replaced with section 152. Section 124A of IPC says, whoever with the intention of inducing or compelling the President of India or governor of any state to exercise or refrain from exercising in any manner any of the lawful powers of such president or governor, assaults or wrongfully restrains or attempts wrongfully to restrain or overawes by means of criminal force or the show of criminal force, or attempts to do overthrow. Such president or governor shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. And this section, section 124A, has been replaced by BNS section 152, which says, whoever purposely or knowingly by words, either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise excites or attempts to excite, sedition or armed rebellion or subversive activities, or encourages feeling of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life or with imprisonment which may extend to 7 years and shall also be liable to fine. So as we see, the words used in BNS are sovereignty or unity or integrity of India. And against the 7 years of imprisonment in the prevailing IPC, it replaces with the imprisonment for life or 7 years imprisonment and fine. So this section basically gives the clarity of definition in the new act, BNS. The clearer and more precise definition mentioned in BNS section 154, like the sovereignty, unity and integrity of India, it is easy for anyone to understand what does the section means. It gives clear picture and we can understand what is the intent and purport of this section. Section 124E of IPC uses the word sedition, which is broad and complicated. So why the law will have to be broad and complicated? Why can't we understand in one go? So the new law, BNS, has explained in detail and explained in an easier language for a common man, for a layman to understand what does it mean. So this clarity in BNS can help us to prevent misuse of law. Firstly, It will help us to prevent misuse of law, and it ensures that only genuine threats to national security are addressed. And other things which we can see in the new section 154 of BNS is protection of freedom of speech. The section provides greater protection of freedom of speech and expression by narrowing the scope of punishable actions to those specifically related to the threats against the nation, sovereignty and unity of the nation. This certainly elevates the concerns about misuse of the word sedition laws. It also gives focus on national security by explicitly targeting the actions that pose a threat to the sovereignty and unity of India. Section 152 can help prioritize national security concerns and enables authorities to more effectively address internal threats to the country's stability. And it also has alignment with contemporary challenges. Updating the legal framework to reflect current challenges to national security ensures that the law remains relevant and effective in combating modern threats such as terrorism, cyber crimes, and disinformation campaigns, etc. This section also enhances legal protections. This section incorporates safeguards to prevent abuse of power, and it ensures fairness of treatment of individuals accused of offenses against the national unity and integrity, thus strengthening legal protections of citizens of India. Therefore, replacing section 124 of IPC with section 152 of the BNS could promote a balanced approach to national security, clarifying the scope of offenses which are punishable under the section, protecting fundamental rights at the same time, and enabling more targeted responses to genuine threats to the country's sovereignty and unity. Thank you.
Thank you, Madam Sangeeta, for explaining the change from 124A to section 152 of the new BNS in such a beautiful way. You have elaborated in detail upon the definition. I would just like to add to it a little bit. See, when we got our Indian Penal Code in 1860, at that time, sedition was not a part of the Indian Penal Code. This was introduced by the Britishers in the year 1870. And why was it done? Because they realized that the noises of dissent, they were increasing. And they wanted to quell any signs of dissent from the people against the crown. So our imperial rulers, they decided to bring in a law in which we dare not question any of the policies of the crown. And irrespective of what the intention was behind raising those questions, whether we did that deliberately on purpose or whether that was a genuine query, they would criminalize the act. So now, in 2023, when we had an opportunity to do away with this archaic provision, when we had an opportunity to enact a law for our people, what we have done, see, you have the liberty to question your state. You have the liberty to ask them pertinent questions, provided that is done in a very lawful manner in order to bring about a positive change. Moreover, we are no longer keeping it as a strict liability offense. So that is why we have introduced terms that are equivalent of mens rea herein, knowingly, purposefully. So it is only when these acts are done with a malafide intention, it is only then that the law will take action. So thank you, Dr. Sangeeta. Now we move on to our next panelist. My next question is to Ms. Ipshita. Madam, the new law has created a separate chapter for crimes against women and child and placed it even before crimes against human body or state. So women have hailed this change and also the introduction of section 69 to check incidences of sexual exploitation of women. So what are your views regarding this?
Good morning to all. With Lordship's permission, I would like to proceed to answer Madam's question. Chapter 5, as Madam said, it has brought within itself all the offenses against women and children. So earlier, those offenses were scattered under different heads, and now it has all come under one head, that is Chapter 5. Now it is more systematic, and it also reflects the high priority accorded by the legislature towards the offenses against women and children. Now coming to Madam's question on section 69 and its implications. For everybody's convenience, since BNS is a new act, I would first like to read section 69. 69 is as we all know, is a newly enacted section, and it punishes sexual intercourse by deceitful means. Whoever, by deceitful means or by making promise to marry, to whom? To a woman, without any intention of fulfilling the same, has sexual intercourse with her. Such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So from a reading of section 69, as I understand, there are two parts. One, sexual intercourse with a woman by applying deceitful means. And the second part is by making a promise to marry to a woman without any intention of fulfilling the same. Earlier, the Indian Penal Code did not have any specific section pertaining to this offense of sexual intercourse by employing deceitful means or by making a false promise to marry. However, the interpretation already existed. Cases of this nature were decided with the help of judicial precedents by interpreting the ingredients of section 375 IPC, section 90 IPC, which relates to consent, what is valid consent and what is not valid consent. A consent obtained by misrepresentation of facts or a consent given under the misconception of fact, that does not amount to consent. And also section 114 of the Indian Evidence Act, which relates to presumption. So section 69 is now a specific and express provision in the BNS dealing with commission of sexual intercourse by employing deceitful means. As we see, this section has incorporated most of the landmark judgments of Honorable Supreme Court, holding that the intention not to fulfill the promise or to cheat must exist from the inception. There may be cases where the intention did not exist from the beginning. The man had intention to marry, but later on he was prevented by some unavoidable circumstances to carry out his promise. So those cases were not interpreted as rape. But under this new section also, this intention to cheat and the previous and subsequent conduct of the accused, they are relevant for deciding cases under section 69. So earlier, the difference that has come is that earlier these cases were punished under section 376. Now, this kind of offenses have been taken away within the purview of rape. As it appears from the use of the words in the section, such sexual intercourse not amounting to the offense of rape. Now, we have to read the section along with the explanation, because the explanation part is also very important to understand section 69. So this definition of 69 has been now made very wide, and it includes not just a false promise to marry, but also deceit by employing or inducement, a false promise of employment or promotion, not just marriage, but also promotion or employment, or a situation. It also covers a situation where the accused marries, but by concealing his identity. So all this, now a wide range of situations are covered under section 69 of the BNS. Now coming to the main part of the question, what would be the social implications? Like before that, I would add another thing, like there could be three situations. If we read the section along with the explanation, to make it more precise and understandable, like first situation, when the accused promises to marry but does not marry. The second situation, when the accused employs deceitful means by inducement or a false promise of employment or promotion. Now the second situation has nothing to do with marriage. And the third situation where the accused marries, but what? After concealing material facts and his true identity. And in all the three situations, the accused commits sexual intercourse with the women. So all the situations are covered within the ambit of section 69. Now coming to the social implications of this new provision, that would depend on the rate of conviction and acquittal that will take place in the future, which is again dependent on the quality of investigation, then the collection of evidence, etc. If the quality of investigation is improved, and if the ingredients of offense under section 69 can be successfully proved by the prosecution, because it is very difficult to prove intention otherwise. So, but now we have along with the BNS, we have the BNSS and also the BSA. So those are now made very scientific and technology based. So if the investigation improves and the case can be proved beyond reasonable doubts, along with it, what is important is for us, for the courts, is expeditious disposal of such cases, because it has a huge impact on the mind of the public, the time taken for the disposal of the cases. So if all these things happen, then we can expect some positive social implication. Along with this, there is also requirement of extensive training for the investigating officers and the prosecuting agencies on this new section. And most importantly, the law has been made, but it has to be brought down to the masses. So there has to be percolation of the new law down to the masses, the real stakeholders of this offense. So earlier, although the judicial interpretation existed, but the common masses, they are not like legal experts. We read the judgments, but the masses who reside in the remote areas, they do not actually understand. That is a dire fact. But now the section is specific. So if the people are made aware of this new provision and its consequences, like this is one program, and there are many other programs, awareness camps, which are taking place across the length and breadth of the country. So that will go a long way. The person has to be made aware that if he makes a false promise to marry, or if he marries by concealing his identity, then it is an offense punishable up to 10 years. So once the new law percolates down to the masses and people understand the penal consequences of the offense, so that will secure positive outcome, in my opinion, in lowering the number of cases under this section. Thank you.
I'll just add to what our expert panelist has said. The stress on section 69, this is for those cases. You see, rape is an offense of forcible or forceful sexual intercourse with a woman without her consent. Now, very often we find that there are cases where initially there was a consent, but the consent was obtained by deceit. Now, whether it would form rape, because the other partner was also consenting. So, it is in order to give relief to those situations that 69 is there. The underlying provision, underlying stress is on intention, consent, deceitful manner. So, whoever makes a promise to marry by deceitful means or without any intention. So the intention that is obtained from the lady is by deceit or by making false promises. And therefore the lady had given a consent. So these are now cases which will be covered under 69. Thank you.
Thank you, Ms. Ipshita. And thank you, Justice Sakya. This was like taking the bull directly by its horns. Okay, we have explained the problem so directly, we've not minced our words, because we have to understand that laws, they exist for the society, and it's not the other way around. So whenever we make any law, we have to understand the peculiar social conditions under which these laws, they are going to operate. In our society, where marriage is an important milestone for every woman's life, when a woman, she seeks to search for a job, she faces so many impediments. In such a situation, if somebody tries to exploit the vulnerabilities of women by promising her a marriage or a job or a promotion, and in return asks for sex, and in such a situation where the girl, she's not in a position to deny it. Here, this is not a consent. Here, the consent has been obtained fraudulently by exercising deceit. Moreover, in our country, where there are so many divisions on basis of caste, community, religion, and these are the factors which play a very, very important role when we look for a life partner. So if somebody misrepresents their caste, their community, their religion, and on the basis of that misrepresented belief, the girl agrees to marry that man, now again, that is cheating. I mean, how can you justify such actions? So that is something which, when our lawmakers, they set to amend the law, this is something which could not have been ignored, especially because we had so many judgments in this regard. And that is why we have here section 69 for you. Thank you again. Now we move on to the next question, and my next question is to Dr. Amol Chauhan. See, Dr. Amol, the number of chapters and sections have reduced from IPC to BNS. The law is being hailed as being more systematic and structured. So what is the broader scheme and planning behind this new arrangement?
Thank you, Madam. Honorable Lordship and all distinguished speakers on the dais and all the distinguished members of this gathering, ladies and gentlemen, as I think that we are in the first year, first class of the BNS, so we need to understand the concept of this particular, the scheme and the planning of the chapterization under the BNS. We need to understand in a two-way. The first, that is the journey from the colonial to Swaraj, Swaraj to the justice. And secondly, we need to understand what is the intention of the legislature behind to place these particular chapters in at appropriate place. Earlier, into the Indian Penal Code, if we see, the priority was given to the state, where the state is more concerned with the Britishers. But if we consider the BNS, then we realize the priority is given to the human beings. So as Madam rightly point out, the offense against the women and the offense against the children, which is an favorable group of the society, which is given a very priority, and the offense which is scattered throughout the Indian Penal Code, which is given earlier under the various chapters, it is clubbed together, where it provides the comprehensive, the comprehensiveness about these particular offenses, where this particular human being will be protected. Now, secondly, the second place, which is of course given to the offenses against the human body. So this particular scheme of the chapterizations is indicate the intention of the legislature is not to protect the state first. It is the protection of the individuals or the human beings. So considering the Nyaya, So when we talk about the justice, so for the Nyaya, we give the priority to the gender or to the human beings. Now, secondly, the similar provisions under the old act, that is the related with the abatement and the conspiracy and the attempt, these particular provisions are clubbed together where these particular people will get the overall idea and the understanding about that particular, what we called as an in-short kind of the crimes. The third thing was what I, as an academician, personally feel, the language which is used by the legislature is very easy. The scheme of the chapterization is made as per the priority which is given to the persons. Secondly, one, that is the law, what I personally feel, this particular BNS is made for the common public or the common persons, where the common people are easily accessible and understand the provision which is contained under the BNS. In the same manner, the offense against the human body is given the priority in the sense the offense, the offense of terrorist activities is not come under the definition of the BNS. Though it is covered under the UAPA and the other laws, by the time we make so many legislation on it, but considering the terrorist act, which at the same time, that is an earlier, what is our understanding is the terrorist act is only caused to or it is threat to the society, or it is threat to the state only. But insertion of that particular terrorist act in the chapter of offense against human body, it shows the intention of the legislature that the terrorist act did not, that is, cause any harm not only to the state, but equally it is very important because it is caused the threat to the human being also, or the human body also. So this particular, the structure which in the BNS which was changed by the time, so it is, the time will, of course the time will says, it will be very helpful for the common people and every citizen who is a part of this, the criminal law.
Thank you, Dr. Amol. Yes, indeed. Now, BNS has been structured in a more systematic way, like see earlier, because the law was enacted by our colonial masters, and that is why immediately after doing away with the definitions and the exceptions and the chapter on inchoate crimes, they immediately came to offenses against the state. But now there is a better structuring. After explaining what are the definitions under the law, what are the exceptions that are available to an accused from criminal liability, what are the inchoate crimes of abetment, conspiracy, and attempt, and then we straight away move on to a very special section of our society, that is women, children. Thereafter we move to offenses affecting the human body, and only then does the state come. That doesn't mean that the state has been given any less important than its people. But yes, the people who comprise the state, they have to be prioritized. Their safety is something which needs to be prioritized before anything and everything. So thank you, Dr. Amol. Now moving on to Madam Sangeeta Pradhan. The definition of movable property has been expanded, and now it includes even incorporeal property. Okay? Similarly, when we talk about documents, so that includes digital as well as electronic records. So how useful would these changes be in tackling contemporary era crimes?
Thank you for the question again. In this section, basically what we see is the changes in the definition includes cyber crimes and intellectual property. As we all have witnessed, the cyber crime has been growing in a society. So many police officials are here, they might be registering the cases of cyber crimes in the police stations. And it is very difficult to, go through into the investigation. So many of us sitting here are victims of cyber crimes. So with yourself, sometimes with your family members or in friend circles. Because these days, the cyber crimes are rapidly growing up, and we are not able to, especially the investigation team are not able to come to the conclusion and investigate the case properly. When we go to the police station and try to lodge FIR for the offenses like cyber crimes, online fraud, etc., what happens is initially, first of all, it will be hesitant to, for the police officials to register FIR, right? And even if the FIR is registered, after that also there will be a problem in investigation, because there was no such penal provision in IPC. So now with the change of this section, with the coming of this new section in BNS, this will help especially to the investigation team to lodge an FIR. And I would like to add in this that to combat this kind of situation like cyber crimes, we need international cooperation as well. I feel like that, because most of the cyber crimes are often happens in the border areas. So therefore, in today's era, BNS has changed this definition to combat with the contemporary situations. And this is the need. I feel that this was a need of an hour. Like, this law had to come. So thankfully this law is added, and it helps in the society to the great extent to punish the criminals, to punish the offenders. So I have seen many officials from the state of Sikkim also. So they have come from the jail, the prison, central prison. And please make note of this, that this kind of law has come, and the Home Department officials and our public prosecutors have also come. So this will definitely help our investigating team to combat with the contemporary world. Similarly, including digital and electronic records in the definition of documents, this helps to address crimes involving digital forgery and theft also. So basically it will, before coming to the courts of law, before coming to the lawyers, it will be the job and it will be the responsibility of the investigation team to deal with this kind of cases, and the sections helps in this in handling such kind of tackling such kind of situations. I think I'm clear in this. If there is any question, I would like to have a discussion amongst the audience also, because we are sitting here and talking, and we do not know if you have understood what we are talking about. Please, you feel free to put any questions, and we'll try to reply to those questions.
Right.
Let's have interactive session.
We'll have an interactive session, but first, let's just try to understand the main provisions, and later on we have time reserved for questions from the audience, because that is very important. Unless and until we know what they are thinking and what they want to know, till that time no panel discussion can be complete, but we'll come to that. As of now, thank you, Madam Sangeeta, because you very pertinently remarked that this is the need of the hour, and rightly so. We all know how tech-savvy our criminals are getting nowadays. So we need to beat them at their game. So we need to get the act together, need to amend the law. The law has to keep pace with the changing times, changing needs of the time. And technology, definitely it cannot be ignored anymore in this cyber age. So when we talked about movable property in earlier times, it was only tangible property. See, even to the extent, in order to address theft of electricity, we had to enact a special law. But now when we talk about theft of property, it would be movable property, which could be tangible, intangible, corporeal, incorporeal. So a simple change in the definition clause has brought about all the difference in addressing all sorts of crimes. Now, thank you. Moving on to the next question, Ms. Ipshita. Now, this question is for you. How does Chapter 5 of the Bharatiya Nyaya Sanhita, the one related to woman and child, intersect with? That is, how does it contradict or complement the existing special laws? See, we have POCSO, we have JJ Act, we have ITPA dealing with trafficking, we have the Medical Termination of Pregnancy Act, and now there have been many changes. All the provisions related to women and child, they have been clubbed together in one place. So how do you think this chapter is going to complement or contradict those existing special laws?
Thank you, madam, for this interesting question. As I have already mentioned in my last question answer, Chapter 5 is a completely dedicated, completely dedicated to offenses against women and children. So the BNS provides a systematic and contemporary code that has incorporated most of the rampant crimes, technology-based crimes, and also futuristic crimes against women and children. It has brought in a number of positive changes based on the demand of time and society and in consonance with the dynamic nature of law. So whenever a law is made, it is based on the need of the society, the demand of the society, and also the acceptability by the society. Both these things have to go hand in hand. In fact, the BNS has gone beyond the criminal law amendments of 2013 and 2018 post-Nirbhaya and reflects a very sincere and dedicated effort to curb offenses against women and children. Now coming to the question, whether the BNS Chapter 5 complements or contradicts the existing laws such as POCSO Act, JJ Act, and other special laws. First is the factor of uniformity. Now the new definition of child as provided under the BNS is the same as Section 2D of the POCSO Act and also under Section 2 of the Juvenile Justice Care and Protection of Children Act of 2015. Now, child means any person below the age of 18 years. So earlier there was some disparity in some of the provisions between POCSO and the IPC. In some of the offenses under the Indian Penal Code, such as like kidnapping, there were different ages for boy and girl, and also in cases of rape, then 12 years, 16 years, and 18 years. So now it has been made 18 years in the BNS as well as in the other acts, it was already there. So the definition of child under the BNS has brought uniformity. Now the sexual intercourse or rape against a child below 18 years is penal both under the POCSO as well as the BNS, irrespective of her marital status. So that is one positive development. There is actually no conflict between the POCSO and the BNS. Section 4.2 of the POCSO Act and Section 65.1 of the BNS, they provide for the same punishment, that is commission of sexual intercourse against a child below the age of 16 years. Now the new provision, Section 70, pertaining to gang rape. The minimum punishment is even higher than under the POCSO Act, because under Section 6 of POCSO Act, which deals with aggravated penetrative sexual assault, that also includes gang penetrative assault. So the minimum punishment is 20 years, and it may extend to life imprisonment, which for the remainder of the person's life, and death. And under Section 70, subsection 2, however, the minimum punishment is life imprisonment. It is mandatory minimum life imprisonment or death. So it is even more strict than under the POCSO Act. Both the POCSO Act and the BNS, they contain provisions punishing disclosure of identity of victims of sexual offense. So BNS is very sensitive to non-disclosure of the identity of the victims, which is a very interesting development. And there is no conflict whatsoever between the POCSO Act and BNS. Actually, there can be no conflict because Section 42 of the POCSO Act and Section 42 capital A, the solution is already there. Section 42 says that when for a given offense. Say an act of sexual intercourse has been committed against a child. Then, if the charges are framed by the court, both under section 376 as well as section, say, 4 or 6 of the POCSO, the punishment will be like imposed only for that offense, only for that higher section, the section which provides for the higher punishment. So there is no conflict. And section 42A makes it very clear of the POCSO, it makes it very clear that the provisions of the POCSO Act are in addition to and not in derogation of other laws. And as we know, the rule of interpretation is that if there is a conflict at all between the General Act and the Special Act shall prevail. So it is already, the solution is already at hand. And next I come to, but yeah, one suggestion that I would like to make, like section 42 of the POCSO Act, it still contains the provisions 376 capital AB, DA and DB. Now that these sections no longer exist in the IPC, so corresponding changes are also to be entered in the section 42 of the POCSO Act. Now coming to another act dealing with children, that is the Juvenile Justice Care and Protection of Children Act of 2015. So chapter 9 of the Juvenile Justice Act, from section 93 to section 99, that chapter contains punishments for offenses committed against children. But these offenses are distinct from the offenses under chapter 5 of the BNS. There may be some common components, but whether in the facts and circumstances of a given case, whether the case will fall under the JJ Act or the BNS is for the courts and the investigators to decide. There is no such conflict, and moreover, the POCSO Act and the JJ Act, they deal specifically with children, but the BNS is wider. It deals for offenses not only against the child, but also against adult women. So, in fact, the punishments under the BNS are in fact higher in some cases than under the JJ Act. And I would like to highlight one interesting provision, a new section that has been inserted in the BNS, that is section 95. It's a very interesting provision and how it has some correlation with the JJ Act. So section 95 of BNS provides for strict punishment for the offender for hiring, employing, or engaging a child for committing offense. So in my opinion, the purpose of this section is twofold. So whoever hires, employs, or engages a child for commission of any offense will now be punishable under section 95 of the BNS. So the inclusion of 95 may help in reducing the number of cases where children are employed by veteran criminals. As we all know, children are employed by the criminals and antisocial persons for committing heinous crimes because they very well know that nothing much will happen. The children will come under the definition of child in conflict with the law under JJ Act, and that the maximum sentence that may be imposed by the JJ board under section 18 is 3 years at the special home. Of course, now we have the children's court also, but the children who commit the offenses are punished, but the main offender, the principal offender, remains unscattered. So the BNS deals with this, that now the person who employs, like hires, employs, or engages a child for commission of offense, now he will be punished strictly under the BNS. So that will have a corresponding positive outcome, in my opinion, in reducing the number of cases under the Juvenile Justice Care and Protection of Children Act. And moreover, the JJ Act or the Immoral Traffic Prevention Act, they mainly deal with some traditional offenses, maybe like prostitution, etc., or other forms of sexual assault. But the BNS is more like contemporary. It addresses the use of children, the rampant use of children, and the massive upsurge of the use of children for pornographic purposes in the social media and other futuristic crimes. So it is more progressive than the existing special acts and there is no conflict among the acts because they're all working towards the same goal. Whenever I read an act, the first thing I look into is the legislative intent behind the enactment of any legislation. What is the legislative intent behind the BNS or the other special laws dealing with women and children? Protection of the children from offenses? It could be various forms of offenses, and Chapter 5 now encompasses a wide range of offenses, like committed against children. So they are all moving towards the same goal. So how can they conflict? There could be some overlapping, but the basic purpose is the same. They are all moving towards the same goal, and in the BNS, like with this acts were already there. So why there was a necessity? A question could come to the mind. Yeah, because new offenses are now coming up. As the technology has advanced, along with the one negative implication effect is also that now new offenses have come up. So that is why there was a need for the new enactment of new sections, specifically committed against children. So in all, my answer is that the BNS, Chapter 5 of the BNS, and the other special laws dealing with children do not conflict but complement one another. Thank you, ma'am.
Thank you, Ipshita, for dissecting the provisions so beautifully. All the provisions, they have been laid threadbare in a very simplistic manner for all of us to understand. Okay, just to add a little bit, Section 95, see what it says, it prohibits the employment or engagement of children. Now see, we all know that many times people, they manipulate birth records. And with JJ Act in place, which protects the identity of a child against disclosure after the child has completed their term, and the maximum punishment that is prescribed is anyway 3 years. So with so many people living below the poverty line, children become easy targets for criminals. Those children, they are targeted, they are brought into a life of crime by sometimes monetary considerations, sometimes certain other considerations due to which they fall easy prey. Now 79 puts an absolute bar on this. So this is a very timely provision, and thank you, Ipshita, for clearing all our doubts. I had certain doubts in my mind also, but the way you interconnected it with POCSO and JJ Act, so I'm sure all of us will be going home better equipped with this knowledge today. Thank you. Now, coming to Dr. Amol. So, Dr. Amol, in your previous answer, you talked about Terrorist Act. So, this is a question again about that. How do you see the introduction of Terrorist Act as a crime under Section 113 of the BNS, despite the existence of a UAPA?
Yes, ma'am. So there is a discussion and debate is going on that we have the special law on the terrorism, that is UAPA. So why there is a necessity to insert the special provision of about the terrorism under the new law, that is an BNS. So considering that, if we compare the BNS and the UAPA, then we realize the UAPA is a special law, whereas the BNS is a general law. If you go with the investigation part, so under the UAPA, where the state having the very less control, or the investigation is conducted by the specialized agencies, so far the BNS is concerned, it is a general law where the police officers and the state machinery having the more power to go with the investigation. As you know, as we all know, the terrorist activity or the terrorism is an overhanging sword on the threat of every state. But considering the similar provision, of course, I am agree that the definitions, which is definition of terrorism, which is given under the UAPA, and the definition under the BNS, is a mirror definitions. There is no drastic change into the definitions. But considering the applicability and the procedural aspect, let's just try to understand the scope of the BNSS and the upcoming new Indian Evidence Act. So this particular law provides the new mechanism of the investigation first. Secondly, it provides the scope of the collection of evidences. it provides the power of the police officers so that it will be helpful to control this particular kind of activity. Now, the second point is that when we talk about the UAPA and the general law, of course, as Madam told in the last question, whenever there is a conflict will arise between the general law and the special law, of course, the special law will prevail. But considering the BNS, if we considering the BNS, this particular provision under the BNS is more friendly, and the people will know earlier whenever the terrorist activity will be committed. So the people having the very little bit idea about the special laws, whereas if the terrorist activity will commit in future, so that particular people will get the broad idea that particular offenses come under the definition of the new law. Now moving forward, if we read the UAPA and the BNS, so there is a provision that is under the BNS, we have the provision of general exceptions. Whereas under the UAPA, this particular provisions or this chapter is not included. If the innocent person is booked under the UAPA, so there is a very less chance to prove his innocence beyond reasonable doubt. So this particular, the BNS provides the protection to the innocent persons who commit the particular kind of the offenses. Now coming toward the power, which is, of course, there the questions in your mind, why the superintendent of police will take the call when the offense is either to offense registered under the BNS or the UAPA. So this particular this particular discretionary power, if we think with connection with the intention of the legislature, of course, the superintendent of police having the discretionary power to either to decide whether the offense is registered under UAPA or the terrorist or the BNS. So considering that, if that particular discretion, because the superintendent of police and the other police personnel is really work on the ground, they know the scenario, they know the situation, they know the act, they know the intention, they know the background of that particular thing. If that particular discretion is exercised in a very positive way, so of course this particular general law will be, the BNS will provide a kind of a step forward to come up with this particular the issues. So far the investigation part is concerned, if you go with the BNS, so the investigations will be conducted by the police, the state police of course, so they better know the situations and the circumstances where this particular problem will be well addressed. I personally think compared to the UAPA and into the BNS. Now, so far the Terrorist Act is concerned, that is new, it is the scope and the horizons of this particular offense or the definition is increased in terms of the, as I told, the investigation part. Now, by the very same time, it may be also considered that UAPA was enacted looking the highly specialized and the complex nature of the terrorist activities, whereas the BNS is a general law where the people are well aware and well understand these particular provisions. And it is established precedent that the situation involved in both the general law and the special law which address, and of course, the concerned agencies, if suppose this particular conflict will be arise, so I personally think the agencies which work under either into the UAPA or under the BNS will definitely give the new path or the new way to address this particular kind of the issue. Yes.
There is one aspect which perhaps requires a little bit of thought. In UAPA, there is a presumption. There is a presumption that you are guilty of the offense. Whereas in this BNS Act, there is no presumption. So perhaps in a given state, the power is left to the SP to decide whether the offenses under Section 111 of BNS is applicable, or are the provisions of UAPA required to be invoked. Now, as you all know, general criminal law, you are innocent until proven guilty. Whereas UAPA is a special act where there is a presumption. So this is an area which requires proper discretion of the authorities concerned. Thank you.
Rightly added, Justice Sakya. Yes, this is more, I feel, in keeping with the intent of our legislators that is reflected in the title of the law itself, Bharatiya Nyaya Sanhita. So no injustice should be done. So in case there is any such presumption which has the capacity of going against a person, during investigation, the investigating officers, they get an idea of what the case is and whether the accused is innocent or whether they have sufficient material against that person. And that is why there is a discretion now that has been given to the superintendent. And of course, the discretion has to be exercised in an extremely cautious manner. And rightly remarked, Dr. Amol, when you said UAPA being a special legislation, not everyone is aware about what the special legislation is. But once we put it in the main law, which is the Bharatiya Nyaya Sanhita, once it is in the main law, everybody would now know that yes, Terrorist Act is a separate crime. So now the definition of what is a terrorist act, what punishment it entails, now it is something which each one of us will know. Thank you. Now moving to the next question to Madam Sangeeta. Okay. The implementation of section 106, see that is the only provision in the BNS, that implementation has been put on hold as of now. There are several issues relating to criminal liability of doctors, non-reporting of information in hit-and-run cases, and also the increase of punishment from 2 to 5 years of imprisonment. So what are your views regarding these proposed changes?
Is to understand this, we may need to refer to the sections first. Section 106, subsection 2. This provision is put on hold, which stipulates that whoever causes death by rash and negligent driving and escapes without reporting to the police officer or magistrates soon after the incident. The difference is that we have to see here is after the incident, who escapes that spot. Then only the provision, the harsher punishment is under section 106, subsection 2. So there has been a strike by we all know that there has been a strike by All India Transporter, alleging that the provision under the section is, the punishment is too harsh, that is why it is on hold. But what we need to see is if the accident has occurred, and that accident is reported to the police officer or the magistrate, the harsher the sections, section 1062 will not attract. It will attract 1061. So 1061 is not harsher. It says, therefore the section 1062, we have to read that if only after the incident the person who causes death flees from the incident. So therefore we see the clear intention of the parliament. First intention would be the person who causes death will have to report to the police officer or the magistrate. And another intention of the parliament, what we can see here is the driver staying in that area may be subject to the mob lynching. May subject to mob violence. It is the fear of mob violence that drivers are fleeing from the spot. However, we also have to see that mob violence is separately dealt by the BNS, separate provision, that is BNS under section 103, subsection 2. So if a driver causes death of a person intentionally, then it attracts murder, section 101 of BNS. So for this section, we have to refer to section 103, subsection 2, and also section 101, murder. Right? So as we see that this section harsher punishment under section 1062 is only with the intent to flee from the spot, not reporting to the police officers or the magistrate. And therefore, I did not see, while going through the provision, while analyzing the provision, I did not see any harsher punishment, because if there is no intention to flee from this, even if the accident causes and the person causing the accident will report it to the police officer or the magistrate, then the harsher section, this harsher provision will not apply. So if you understand this way, there is no any reason that this section cannot be implemented further. Because we have to see the intention. If there is the intention of killing that person by rash and negligent driving, then only the harsher punishment is implemented, attracted. And with regard to the liability of doctors, this section does not provide harsher punishment for the doctor. It's 2 years and fine. So protecting doctors from liability for treating victims, this could encourage them to prioritize the victims of the accident. So therefore, in my view and in my opinion, the section is very clear. That's first proviso of the section. Proviso 1 does not talk about the harsher section, a harsher provision, harsher punishment, as even if the incident happened, even if the accident happened, and then not with the guilty intention, it reports to the police officer and magistrate, then the punishment is very less. But if with the criminal intent, or maybe with the fear of more violence, if the person causing the incident flees from the accident spot and does not report to the police, then only harsher punishment will be applicable. As I already mentioned, that this section we have to read with section 103 of section 2 and section 101 modern. Therefore, I don't see there is any substantial reason for holding the section 106 of section 2. Thank you.
Thank you, Madam Sangeeta. And rightly remarked, we needed tougher sanctions, because as per the NCRB data, the number of lives that are lost annually to hit and run accidents is even larger than the number of lives lost annually in culpable homicides or murders. And that is why we needed a harsher punishment. But then again, since there is no mental element of intention or knowledge involved here, and that is why we need to rethink this provision, and that is exactly what yesterday the Minister Shri Arjun Ram Meghwalji remarked, that we are open to samvad. And that is why putting on hold section 106 for the time being, that illustrates our commitment to our people, that see, till the time people, they are not convinced that this is a law by the people and for the people, and the interests of the people would take precedence. So till that time, we are not in any haste implementing any of the provisions. Moreover, see, most of the people, they don't know that provisions regarding EFIR, zero FIR, they will be now implemented once the BNSS comes into operation from 1st of July. But then again, whether our truck drivers, they are so tech savvy, whether they can use their smartphones to register EFIRs, see, that is again a very big question. So till the time we can ensure the safety of all the parties concerned. See, this provision, why it was introduced? Because it is important to save lives during the golden hour. That is immediately after the accident. We could minimize the casualties in case we had a provision in place which made it mandatory. That, see, you are a good person, prove it. Just inform the authorities. But then again, they are equally scared. What if there is a mob that collects? What if they are lynched? So all these considerations, they have to be considered before we finally implement this. Now coming to the next question, Ms. Ipshita. This is a very contentious question that I'm posing to you, but given your experience in dealing these POCSO cases and women-related cases, I'm sure you'll be able to handle this. See, this is unnatural offenses that were earlier punishable under section 377 of the IPC. Now they have been omitted totally from the Bharatiya Nyaya Sanhita. Now, does this mean that men above the age of 18 years and animals, they have no legal protection against sexual violence?
A contentious question indeed. I'll try to answer. Section 377, as we all know, have been completely deleted from the BNS. So, the 5-judge bench of Honorable Supreme Court in Navtej Singh Johar versus Union of India in the year 2018 held that Section 377 IPC, insofar as it criminalizes consensual sexual conduct between adults of the same sex, is unconstitutional. So, consensual sexual intercourse between consenting adults, it was like permissible. It was, and this is a landmark judgment in ensuring the constitutional protection of sexual orientation to transgender persons. So this was a very important judgment, particularly for the third gender persons. And the question that has been put to me is, with the complete deletion of Section 377 IPC, whether men above 18 years and animals will have no legal protection against sexual violence. The POCSO Act, as we all know, is gender neutral, and it penalizes penetrative and non-penetrative sexual assault, sexual harassment committed against the child. So the protection exists for the child. But what about the men above 18 years and animals and transgenders? So these are the questions, perhaps, that are coming to everybody's mind. So although Section 377 has been deleted from IPC, there are other special acts still existing on the subject. Like for transgender persons, there is this Transgender Persons Protection of Rights Act 2019, which includes like sexual assault along with other forms of assault against transgender persons. And the BNS also now recognizes transgender persons under the BNS, along with men and women. So this is an important development. Now coming to children, or sorry, to animals, as you said, like the Prevention of Cruelty to Animals Act. It contains provisions to prevent cruelty to animals. Although there is no specific section dealing with bestiality, however, if we read Section 11, just to my understanding, and it is subject to judicial interpretation, Section 11 punishes different forms of cruelty to animals, along with subjecting, the second part of Section 11, subjecting animal to unnecessary pain or suffering. So perhaps my answer would be that there still exists provisions to protect animals against such kind of assaults. Moreover, the right to private defense against an assault with the intention of gratifying unnatural lust still exists in the BNS. So if there is such an attempt, any person will have the right to private defense. Besides that, if an adult male sustains bodily pain, infirmity, or grievous hurt due to the unnatural sexual acts committed by the accused, so there are sections under Section 115 and 16 hurt, grievous hurts, etc., which are the general provisions, and under which the adult male can still seek legal remedy against sexual assaults. So that would be my answer to your question.
Thank you, Ipsita. There couldn't have been a better person to answer all these queries. Now coming to you, Dr. Amol. Introduction of community service. That is being hailed largely as a reformist measure and a progressive move. On the other hand, retention of death penalty, despite there being a moratorium against death penalty in most of the countries, now this is being questioned. So how do you balance the concept of nyaya with these two extremes?
Yes, ma'am. So when we talk about the nyaya, so we need to make the balance between this particular two punishment which is provided under the BNS. See, the community services punishment was a long-awaited efforts or long-awaited, was supposed to be inserted into the new law. But by this legislation, the legislature put this particular punishment into the BNS, which provides a path, a way toward the reformation, that is the journey from retribution to the reformation. So reformation in the sense, can we think that instead of sending the person into the jail, can we take the service of that particular person for the betterment of the society? So that may be the also what we called as a reformative step, which is taken by the legislature, and this will provide a new platform to revise or to reform the existing criminal law, that what we start the journey from the punishment to the nyaya. Secondly, the community services is mainly focused on the rehabilitation of the person. So sending the persons into the jail, that we already know that there are so many activities is going on into the jail for rehabilitation purposes. But considering the community service, it is a reformative step. Instead of sending the person into the jail, the reformation maybe took place when the person is participated into the society. Say for example, if the person is found some offenses related with the cow slaughtering, so can we think that the sending the persons, that is the petty kind of the offenses related with the cow or the cruelty against the animals, so can we think that the sending the person into the Gaushala will help to understand the consequences, the nature, the gravity of that particular offense, and the reformation will be took place by inserting that particular person into the new kind of the punishment. Secondly, when the person is involved into the petty offenses, say for example, now this particular new law provides in 6 offenses the punishment is provided. Suppose the person who is an offender into the case where the value of the property, theft property, is less than 5,000, say for example. So sending the person for months or 2 months or 3 months, of course it is the discretionary power of the judicial officers. Sending the person into the jail, can we think that send the persons to the slum areas or the places where these particular persons will take the lesson? How the money is important for the persons who is carrying it. So I just picking the pocket and I taking the money from that particular person. So what kind of pain he realized when he served his services to the community. So considering the reformative, that is when we are talking about the nyaya. So nyaya is not to send the person into the jail and to keep into the jail. As we all know, there are so many the reformations, the committees onto the jail reformation, and the plethora of cases where the Honorable Supreme Court of India raised the concern about the overcrowding problem, the problems of violations of human rights into the jail. So the persons who is involved into the small categories of offenses where the jail is not the proper punishment, so the community service, of course, the community service will play a very crucial role in the reformations. Looking toward the community service punishment at the globe level, that is, it is already started in UK, US, Canada, Norway, Australia, etc. So why the India is awaiting for that is up to 2024? So the reformation is not only the thing where we are sending the persons into the jail, but reformation start to make the realization of that particular offense where the persons himself get rid of it and will come up with the new contribution, a good contribution to the society. Now looking toward some judicial decision, I just give the reference of Babu Singh versus State of Uttar Pradesh, Sunita Gandhar versus State of Madhya Pradesh, Sanjay Chaudhary versus State, where the Supreme Court of India many times make the recommendations or observe that the time is come to make the reformation into the new criminal justice system by way of introduction of various the new kind of or the new punishments. Now community services is a reformative in the sense where the persons will realize the involvement and the persons will realize what kind of wrong he is committed. Now, I know that there is no specific definition is provided under the BNS or the explanations or the clarification is made under the BNSS. So the doubt may be in our mind in what way, to whom, how, and up to what extent this particular community service we will inflict and we will give to these particular people. Now, as an academician, what I personally feel, there may be an intention of the legislature, let's give the chance or let's give the room for the judicial officers to interpret as per the nature of the crime, as per the status of that particular offenders. And of course, I'm sure by the time or with the passage of time, when this particular kind of offenses will come forward, so this particular judiciary will make a set or set the principles which will be guide to the other countries, or which will guide to the world, where we can come up with some kind of the new kind of the community services. Now, madam, coming toward the second question of your part, so far the death sentence is concerned. Of course, so far the death sentence is concerned, the debate is going on. Already the debate was there, where the Supreme Court of India raised the concern about it at the globe level, where so many international conventions, human rights issues, there are so many things are there. But still, in the world, if you see the judicial system or if you see the criminal justice system, where the death sentence is not fully abolished from the world. So why we are, thinking that the death sentence is against to the human beings? And I just give the three parameters to make the deterrence on that particular offenders. Now the first is that all guilty people deserve to be punished. Secondly, only guilty people deserve to be punished. And thirdly, guilty people deserve to be punished in a portion of the severity of the crime. So considering that, so death sentence is not the punishment which is provided in every offenses. Considering the brutality, what we see, what we witness, what we observe in the Nirbhaya's case, and there are plethora of cases where the brutality of that particular person shown by this particular act, if we did not punish them by way of the death sentence, so what kind of the message we are setting for to address the criminal justice system? So far my observation, so far my knowledge, and so far my understanding is concerned, the death sentence is a path, or we can say that the death sentence is a part and parcel of the Nyaya. What happened with that particular innocent persons who suffer the lot due to the brutality, due to the heinocity, and due to the intentional act of that particular persons. So sending the persons into the jail in the life imprisonment will not serve the purpose, will not create the data in the mind of the person. So I make the balance between, that is, a death sentence is appropriate, and it is only given into the rare of rare case, as we all know. Where the rare of rare, so far the rare of rare case is concerned, the session judge, once it is decided, so it should be confirmed by the division bench of Honorable High Court. So there is a ample power to make the scrutiny, to go with the in detail, to decide to confirm the parameters of the rare of rare case. So it is not the case it is confirmed by the because the session judge has no power to execute the sentence unless and until we go with the appeals, reviews, and the mercy petition and so on. So this kind of there is a check and balance is there. So the death sentence is appropriate in a particular cases. So far the BNS is concerned in 13 offenses where the death sentence is provided. So this, if you see the nature of this particular offenses, it shows the brutality, it shows the heinocity of that particular crime. So considering this particular aspect, the community service, of course, it having the good place at where it requires. At the very same time, the death sentence is also appropriate and it is justified in terms of the brutality, because it is not the case where we simply give the, and if we see, in how many cases from last, if you go with the statistic of last 50 years, where we have the population of more than 150 crores, where the offenses are increasing day by day, brutal offenses are increasing day by day, in last 50 years, in how many cases we execute the death sentence? So that is also the questions which we need to understand. So in that way, I think both the punishments are appropriate at that particular place.
Yes, Dr. Amol, indeed you've made your point very strongly that yes, see, this is a reformist measure, and see what our Father of Nation says, hate the sin, not the sinner. So every saint has a past, every sinner has a future, and so everybody deserves a second chance. But then there are certain people who are such hardened criminals, and that is where death penalty has to be awarded. But then again, we have qualified it by the rarest of rare doctrine. So thank you. We've got more questions, but I think we are running short of time, so I think we'll take some quick questions from the audience. So anyone from the audience, if you want to ask a question, the floor is now open. Could you just pass on the mic, please? There are more than a couple of hands up in the air, so I would request our panelists to quick short answers, please. So please first introduce yourselves and then please the question.
Thank you, madam. I am Neeraj Kumar, Public Prosecutor, CBI, Guwahati Anti-Corruption Branch. Namaskar, Your Lordship. Namaskar, dignitaries on the dais and in the conference hall. Actually, changing in law is the need of the society, we well know. My question is lesser question, but greater suggestion. Actually, when I heard Special Judge Ma'am, there is a harsher punishment in IPC. Now it is a Bharatiya Nyaya Sanhita. There is a harsher punishment in compare of POCSO Act. Of course, we have at hand, which for the purpose of avoiding conflict between the changes in general law and POCSO Act, I am very thankful to our wise person who had made the legislature in that sense to avoid any conflict. But if there is harsher punishment, which is the intent of legislature in Bharatiya Nyaya Sanhita, and if POCSO provide lesser punishment, now question is, which is, I am again repeating, which is a lesser in form of question and greater in form of suggestion only, unless there is corresponding change in POCSO Act, whether it not put in difficulty to our learned judges while they are offering sentence or whatever. And another thing, second ma'am, it is for all the dais dignitaries, it is for all and especially for Lordship. My question is, in 69, the first line where the legislature has put an individual, I am agree. But in second line, deceit only women in such a 21 centuries, which this is my opinion, I can say my opinion. I am disagree. There should be an individual, there may be men, women, because in 21st century, again, we are repeating the same thing. We are putting in dark only men. I disagree. So this is my suggestion. With all due respect. Thank you very much.
First, I will come to the first part, your first question, relating to the conflict between the POCSO Act and BNS, so far as punishment is concerned. I had already mentioned in the answer to my question, not in all offenses. What I meant to say is that under the minimum punishment under Section 6, the minimum punishment only, that is lesser than Section 70, subsection 2 of the BNS, but the maximum punishment is death. So it is for the judge to decide whether to impose the minimum punishment or the maximum punishment. So basically, like POCSO has minimum is 20 years, but under Section 70, subsection 2, the minimum is life imprisonment. And Section 6 of the POCSO Act provides for like minimum 20 years, then life imprisonment and death sentence as well. And Section 42 of the POCSO is very clear on this, 42 and 42 capital A of the POCSO Act. So when in the same offense, like what happens? When do we frame charge under Section 376? Especially only in the borderline cases, the age group between 16 and 18 years, where it may be difficult to prove the age of the victim. So when the prosecution cannot prove that the victim is a child, then we will go to the BNS. So if both the offenses are proved, then as per Section 42 of the POCSO Act, the punishment will be imposed under the section which provides for higher punishment. So the remedy already exists, and 42 capital A POCSO again has a solution that POCSO Act does not conflict with the other laws. It is not in conflict with the other laws, but it is in addition to the other laws. But in case of a possible conflict, the POCSO Act shall prevail. So I think I have answered your query. And the second part, Section 69. Now, 69 is a new provision altogether, because it has been made wider than only rape. Now, it has taken the offense like out of the ambit of rape. Earlier cases of this nature were interpreted by the higher courts as commission of offense under Section 376. So, although the consent was there, but the consent was not a valid consent. It was a consent given under misconception of fact. Now, this is a new provision. So, legislature, so far as possible, has encompassed a variety of situations, like not only false promise to marry, but also false promise of promotion, employment, right? And then also marrying by suppressing identity. And law is a dynamic concept. The world does not end here. Now we have a new law, we'll try to make it workable. We will try to ensure that it goes down to the masses. So as and when there's a need of the society, there's acceptability by the society, whenever the legislature makes a new law, it has to take into a variety of factors, whether there is the necessity of such a law. Also regarding the rate of prevalence of such offenses, along with academic discussions, judicial precedents, a lot of things go into it. So let us hope for some more developments in the future, because this is not the end of it, and law itself is dynamic, society is dynamic, and there are a number of emerging crimes. So we can possibly expect, at least the BNS make some positive changes. Now it is recognized even transgender persons within the definition of gender. Would we think about it earlier? No, but now it's a progressive document, but we can always expect more positive changes to come up in the future. Thank you.
Okay, next question, please. And please, we are taking questions, not suggestions. So next question, please.
Good afternoon, sirs and madam in the panel. My name is Nukcheng Moman from Meghalaya Police. As we are in a transition phase from old law to the new law, I have some questions, ma'am. My question is, suppose we have a case which was registered for an offense under IPC, and the investigation is being continued under the provision of the old law. If we continue the investigation beyond 1st of July, whether shall we follow the old laws, because the crime was committed prior to the implementation of this new law, and whether during charges shall
Okay, so Dr. Amol, would you like to answer that?
I think, madam, the second session is on CRPC. Okay. That is BSNL.
Let us leave it to the experts then.
The panel will clear the more about this particular thing. So it will be repetition for us, na?
Yeah. Okay. So thank you. Next question, please.
Namaskar. I am Dr. Ajitesh Pal from Tripura State Forensic Science Laboratory. My question is, what is the role of forensic evidence in the new 3 laws?
Again, that would be taken up in the upcoming session on Bharatiya Sakshya Adhiniyam. Okay, next question, please.
Thank you, madam.
Okay, and this will be the last question, please.
Good morning, ma'am. My question is to Justice Bharat Kaur. She has mentioned that discretionary powers of police officer. Isn't it dangerous to give discretionary powers to police officers? What are your views, madam?
Who is it addressed to, this question?
Madam once mentioned in her session. Discretionary powers of...
Madam Sangeeta?
No, no, no.
Miss Ipshita. Ipshita.
I mentioned about the discretionary power of the police officer so far the terrorist and UAPA is concerned. So my opinion is that the discretion is always come with the arbitrariness. See, so, but there is another side. When the person's having the discretion, it is what we call as the discretionary power may be used into the real sense. So far the police officer is concerned, of course there may be a debate and discussion will be in near future we will come across. But so far this particular UAP and terrorist activity is concerned, there are two sides. First, discretion may be sometime goes against to the law. But at the very same time, if the discretion is used in a very proper and as a lawful manner, so it will give the justice to the society. So it is the person who will take the call at the particular point of time, whether it is within the four corner of the discretion or not. So let us see what will be the activities will happen after the first, because of course the discretion having some room of the arbitrariness, but there is some check and balance also. So this particular, if the discretionary power is used arbitrarily, so we have the mechanism to check it. And by way of the check and making the balance, this particular discretion may be curtailed or discretion may be used in a very real sense.
Thank you, sir.
Okay. Oh, okay. So after such...
good morning, madam. Just a question, madam. Mera suggestion hai, madam, to all, for all our own dais. मैं डिप्टी कमांडेंट सुभाष मैडम फ्रॉम ITBP. मेरा एक छोटा सा सजेशन है मैडम.
सर हम क्वेश्चंस ले रहे हैं, सजेशंस के लिए ये फोरम नहीं है.
मैडम ये क्वेश्चन ही समझ लीजिएगा इसको.
ठीक है.
नहीं मैडम. दिस इज अ क्वेश्चन मैडम.
प्लीज कीप इट शॉर्ट.
मैडम देखिए इट इज अ बिग फॉर्म मैडम, जो एक बहुत बड़ा रिफॉर्म करने जा रही है लॉ में, तो मैं समझता हूं कि उन चीज़ों को भी थोड़ा सा इंक्लूड किया जाना चाहिए. जी मैडम, एक तो हमारे देश में जो एजुकेशन का जो सिस्टम है दैट शुड बी फ्री अप टू द डॉक्टरेट लेवल. जी मैडम, दिस इज माय क्वेश्चन. दूसरा मैडम,
सर दैट्स अ वेरी गुड सजेशन, बट आई रिपीट दिस इज नॉट द फोरम फॉर दीज सजेशंस. Please, sir, please, we can maybe talk over lunch, and maybe we can talk to the Honorable Lordship and all other panelists also. Okay.
Thank you.
So after such a brainstorming and intellectually stimulating question and answer session with our panelists, I now request our esteemed chairperson, Honorable Mr. Justice Soumitra Sakya, to deliver the concluding remarks.
I'm sorry, I think one clarification is still, I thought it's necessary to put forward in the audience. With regard to section 69, the question was posed from the audience side. With regard to section 69 BNS, we all have witnessed about the society, like women in the society are victim of love jihad. We all are aware of that. There are many Hindi movies also have come up, which makes us understand get the clear picture on love jihad, right? So to combat with the situations like love jihad, section 69 has been introduced. This is also an need of an hour in the society, because so many all over the country, there has been many women in the society who do not understand what is going on with in their lives. So to combat with this situation, this section 69 has been introduced in the new law, BNS. Thank you.
Thank you, Madam Moderator, and all the panelists for a wonderful session here. Insofar as the questions which were asked and deliberated upon. The issue of 124A sedition being replaced by 152, this has been a wider, sedition was misused quite often, and therefore a new section has come in, which has got a wider ramification. Then, so far as 69 is concerned, 69 is definitely directed for the protection of women whose consent has been misused or has been falsely taken by persons for misusing, having intercourse with the women. So I think, as rightly pointed out by the panelists earlier, it was brought under rape 376, but then there was most of the cases, or some of the cases, we find that there was some consent. Now this section has been enacted to take care of those particular instances where consent was not given voluntarily or on the basis of known facts. Then this new Act BNS, as have been discussed since yesterday, has been concised, made more concise, more structured. Chapters are more reorganized in a systematic way. And this is expected to bring, as we all say, Nyaya, justice. It is not an enactment essentially for imposition of penalties. It has to be understood and seen to be an enactment, a legislation to bring in justice on citizens. Then the question with regard to movable property being included, which includes digital and electronic record. Yes, in today's context, this has become a very significant provision in the Act, because everywhere it's no longer just physical paper, which is termed as a document. We have digital documents, we have records, we have videos. So in the context, in today's digital world context, I think this has this is going to bring in a sea change in tackling those offenses pertaining to documents. Then in respect of any conflict or contradiction between JJ Act and POCSO and BNS, JJ Act essentially is to look after the interests of a child in conflict. Now BNS has a chapter, has a section where persons who force children are if convicted, are given punishment. So therefore, JJ Act and BNS essentially operates on two different platforms. Then POCSO is definitely a special act, more stringent, and rightly pointed out by our panel that the punishment in BNS, maximum punishment has been enhanced, whereas the minimum punishment is still there. It is for the trial judge to decide whether to impose the punishment on the POCSO or on the BNS. In so far as terrorism is concerned, yes, this is a new chapter, new section which has come in. This being a general law, as I've said, essentially you are innocent until proven guilty. So therefore, assuming there is a allegation against you, you have ample opportunity of proving your innocence depending on the evidence that is available. Whereas on the UAPA, which is a more stringent legislation, there is a presumption. Definitely the standard of proof against this presumption would be very high. Now, the power has been given to the SP to decide on which of these two legislations the crime is to be registered, the offense is to be registered. Insofar as Section 106 is concerned, I think this is again a very important section, which is the need of the hour. As pointed out by a moderator, the statistics are staggering and scary in respect of hit and run cases, traffic accidents. So therefore, This is a section which will perhaps cater to the needs of those cases pertaining to hit and run or traffic cases. So far as 377 and the apprehension that men and animals, do they have no protection? Perhaps the suggestion which had come from the gentleman there needs to be carried on by the ministry officials, if possible, to see whether these, in years to come, I'm sure the legislature will decide to make it gender neutral, perhaps. Now, as it stands today, the protection is only against women. So this is the wisdom of the legislature, and they decide to bring in this provision in this particular form. So far as community service is concerned, this is again a very innovative new provision which has come in, and which will go a long way to cater to the needs of small petty offenses and also in respect of persons who are first-time offenders. The purpose is not to incarcerate these persons along with, because as you know, the jails are not segregated. In a particular jail, you may have a first-time offender, you may also have offenders who are convicted of very serious and heinous crimes. So the first-time offenders or offenders convicted or found guilty to be of minor offenses, can they be reformed by way of community service? And yes, this is a practice which is followed in many countries across the world, and this is definitely a step towards reforms taken by the legislature. And so far as gender neutrality, did we go into this gender? We did not. Okay, right. So I hope this session, technical session, has been able to cater to the purpose for which it was held, that is the BNS, the Bharatiya Nyaya Sanhita, and I hope the members in the audience will carry home the discussions which have been held by the erudite panel here. And I thank you, the Law Ministry officials, the Government of Assam, Government of India, for giving us all an opportunity to participate in these discussions. Thank you very much. Have a good day.
Thank you, Lordship. As the moderator of this session, it is my duty to propose a vote of thanks to our respected chairperson, my esteemed panelists, and all the guests who took time out of a Sunday to engage in this discussion on Bharatiya Nyaya Sanhita. Your presence and participation has made it worthwhile. Thank you. Jai Hind, Jai Bharat.
Our sincere thanks to all for sharing their valuable insights, and we indeed had some outstanding questions, remarkable in their thoughtfulness. We would now like to present mementos to our esteemed guests on the dais. I would request Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, to kindly come forward and do the honors. First, we would present the memento to Honorable Mr. Justice Soumitra Hoikya, Judge, Guwahati High Court. Thank you. We would now present the memento to Professor Vageshwari Deswal, Faculty of Law, University of Delhi. Thank you. We would now present the memento to Sangeeta Pradhan, Deputy Solicitor General, Sikkim High Court. Thank you. We would now present it to Ipsita Borthakur, Special Judge, POCSO, Nagaon, Assam. Thank you. We would now present the memento to Shri Amol Dev Chauhan, Associate Professor, NLUJA, Assam. Thank you. I would now request our esteemed guests on the dais to kindly step forward for a group photograph, which will help preserve the memory of this event. Thank you all once again. We will now take a short tea break and reconvene at 12 noon sharp for the second technical session. I would most humbly request everyone to kindly stick to the schedule. Thank you once again. I would request everybody to kindly be seated. In just a short while, we'll be starting with the second session of the day. Thank you. Ladies and gentlemen, welcome back. We would now proceed to the second session of the day, and the topic for this session is Bharatiya Sakshya Adhiniyam 2023 BSA, the new act that replaces the Indian Evidence Act 1872. We will do a deep dive into the features of the BSA and leveraging technology in the context of the new legislation. This technical session is meant to be a platform for deliberations to unravel the intricacies and nuances of the transformational legal reforms that will take effect from the 1st of July 2024. I would encourage all participants to leverage the session for thought-provoking innovative discussions and fostering collaborative dialogue and knowledge sharing amongst the assembled distinguished legal minds. Ladies and gentlemen, each of the panelists we have with us today are authorities in their own right, having distinguished themselves in various facets of the criminal justice system, and it would be extremely interesting to have their perspectives. The session will be chaired by Honorable Mr. Justice Debashish Barua, Judge, Guwahati High Court. The moderator for this session would be Mr. Roktim Duara, District and Sessions Judge, Kamrup Metropolitan, Guwahati, Assam. I'd request you both to kindly come forward and take your seats, please. Thank you. The panelists for this session are Shri Ranjit Kumar Deb Chaudhary, Deputy Solicitor General, Guwahati High Court, Dr. Nitesh Mozika, Deputy Solicitor General, Meghalaya High Court, Shri Roshan Lal, District and Sessions Judge, Karbi Anglong, Assam, Monica Sharma, Special Director, Enforcement, Directorate of Enforcement. I would request our panelists to kindly come forward and take their seats on the dais. Thank you. We would now like to present mementos to our esteemed guests on the dais. I'd request Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, to kindly do the honors. First, we would present the memento to Honorable Mr. Justice Debashish Barua, Judge, Guwahati High Court. Thank you. We would now present a memento to Mr. Roktim Duara, District and Sessions Judge, Kamrup Metropolitan, Guwahati, Assam. Thank you. We would now present the memento to Shri Ranjit Kumar Dev Chaudhary, Deputy Solicitor General, Guwahati High Court. Thank you. We would now present it to Dr. Nitesh Mozika, Deputy Solicitor General, Meghalaya High Court. Thank you. We would now present the memento to Shri Roshan Lal, District and Sessions Judge, Karbi Anglong, Assam. Thank you. We would now present it to Monica Sharma, Special Director, Enforcement, Directorate of Enforcement. Thank you, sir. I'd request you to kindly take your seat. I'd now hand over the session to Honorable Mr. Justice Debashish Borua, Judge, Guwahati High Court, our moderator for this session, to commence the proceedings.
A very good afternoon. Honorable Mr. Justice Debashish Borua, Judge, Guwahati High Court, and dignitaries on the dais, off the dais, judicial officers, government officials, students, ladies and gentlemen. It is indeed a privilege for me to be the moderator of this session, second session on Bharatiya Sakshya Adhiniyam, BSA in short. And in the first session, we have seen the deliberations. And I hope and expect from the eminent panelists who are present here, it will be a very fruitful session. We have amongst us Honorable Mr. Justice Debashish Borua, who had an extensive practice in civil, taxation matters, arbitration, company matters, criminal law, and his lordship was an additional Advocate General of Assam at the time of elevation, and also was a standing counsel of Election Commission of India. I welcome my lord. We have amongst us Mr. Ranjit Kumar Dev Chaudhary. He had an extensive practice in all fields, and he was a senior government advocate also before becoming the Deputy Solicitor General of India with effect from 7/10/20. We have amongst us Dr. Nitesh Mojika, Deputy Solicitor General of Meghalaya High Court, a senior advocate designated by the Honorable Meghalaya High Court on 25/2019, exactly 5 years from today. We have Mr. Roshan Lal, District and Sessions Judge Karbi Anglong. He was also a faculty in the Judicial Academy, Assam. So he has some extensive experience in dealing with various laws. And then we have Mrs. Monica Sharma, IRS of 2003 batch. She was earlier posted as Additional Director, ED, Ministry of Finance, Government of India, and now a Special Director, Enforcement. I welcome all the dignitaries, and from the composition, we all can see that we have the members from the bar, bench, as well as from the prosecution. So I would not say much, and with the permission of the chair, I would like to start the session. The session, I will discuss going by the flow, not by direct pointing questions to individuals, so that my aim is that for getting more and more inputs from each of the panelists. And then we'll make the session open for the audience to put questions. Thank you.
Ladies and gentlemen, and my esteemed panelists out here, the members of the bar and the bench, the officials of the police department, and all who have been all along looking into, have been dealing with the three laws, the IPC, the Indian Penal Code, which we say to be the one of the most important legislations from the British time. The CRPC, initially it started in the 1898, and now it has become in 1973. And then we have the Indian Evidence Act, 1872. Now, all these laws have been a part and parcel of all these people, starting from the bar and bench, as well as the police department and everybody. Now, with this change in the laws out here, there has been a certain people, for the people, what is there? That these new laws have come in, what is to be done in respect to these new laws. No doubt, these changes have been various as regards the Indian Penal Code as well as the Code of Criminal Procedure. However, as regards the Bharatiya Sakshya Adhiniyam, the BSA, the changes are minimal. There's a reason why. The reason is that the fundamentals of evidence cannot change. The fundamental of evidence will always remain as it is. Just for example, the basis as regards a person cannot be put to incriminate himself, which flows from Article 22, shall always remain. The right of privilege, the right of privacy, which is a facet of Article 21 of the Constitution, will remain as it is. As such, you have these privileged communications, the privileged communication still holds forth in the new BSA. One has to understand that the Bharatiya Nyaya Sanhita starts or gives a flavor from on the basis of its own title. It says about Nyaya. Yesterday, Honorable Mr. Justice Rishikesh Roy said, Nyaya means reformist justice. That day I was hearing a conference in respect to a similar conference pertaining to the BSA and all, where it was mentioned by the Attorney General that it is social justice. So the perspective by which this new law of Bharatiya Nyaya Sanhita has been brought is more like a reformist law or reformist or our social justice is being given. Now, if we come, this law is very relevant because of the fact that this is a substantive law. Now, the second aspect comes again is the Bharatiya Nagarik Suraksha Sanhita. Suraksha means protection. If you see the earlier act, it's the Code of Criminal Procedure, by which it is a procedure mandated for the criminal courts. This is what all the people used to think, the judges, even as regards the lawyers, for them it was a code for the criminal courts. But now, this is a code which is now being made to that effect that it is a protection laws to the people. Nagarik means people and the Suraksha means protection. A protection against, in favor of a fair procedure. Now what is this? As I said, the Bharatiya Nyaya Sanhita as well as is a substantive law. Bharatiya Nagarik Suraksha Sanhita is a procedural law. Now what is Bharatiya Sakshya Adhiniyam? It is a law by which you operationalize both the BNS as the BNSS. And as such, in common parlance, it is known as an executive law by which you can operationalize the BNS as well as the BNSS. Now, you see, for my opening remarks on the present technical session, I would say that the basic essence of both the substantive and the procedural law has to be understood. I would say that the Bharatiya Nyaya Sanhita brings in some significant changes into the substantive criminal law while retaining a substantive part of the Indian Penal Code. The Bharatiya Nagarik Suraksha Sanhita introduces, on the other hand, sweeping changes in the procedural law designed to stimulate the Indian judicial system to the present times. The manner of filing proceedings, right from lodging of the FIR to the appeals. The imposition of strict timelines for various stages such as investigations, inquiries, trials, judgments, and appeals, as also by the introduction of liberal use of electronic medium to enhance efficacy, are provisions to strengthen the integrity of investigation, make the criminal justice system victim-friendly, and fair procedure to persons accused of an offense. Therefore, to keep track of the changes made to the procedural laws, some minimal but very significant changes have been brought to the Evidence Act by the Bharatiya Sakshya Adhiniyam, which would be seen in the present discussion. Thank you.
Thank you, my lord. Before going to the questions on the BSA, I would like to request Mrs. Sharma to kindly enlighten us with the changes which has been effected in BSA.
Thank you, sir. Sir has given a background that why there have been changes in these three criminal laws. I would give that what and how these changes have been brought in BSA, and I'll be discussing it in 2-3 ways. पहली बात तो ये है कि 1947 we got independence and thereafter we all talked about new. हम सब ने वो गाना सुना था, छोड़ो कल की बातें, कल की बात पुरानी, नए दौर में लिख देंगे हम मिलकर नई कहानी. So the constitution was the first step जिससे एक नए युग की शुरुआत हुई. फिर उसके बाद अगर आज हम अपने इस रियलिटी को देखें, the reality, the social reality, the economic reality, as well as the criminals who have kept their pace with the technology, so there was a requirement that our laws should also reflect this new reality. Technology has seeped into each and every part of our lives, how we communicate with each other and how we record our information and what is precious to us. So there was a need that this technology should be imbibed and it should form part of our criminal justice system also. So the significant changes have been made in BNS. It has also been made in the BNSS that now even the witnesses can be examined through audiovisual means. Now, as we know, the technology after especially the COVID period, the distances are immaterial. We all connect with each other through virtual world, so why not the witnesses be also examined through the electronic means by the courts? This is the first aspect, and it also provides for future, because every law should be futuristic. It should be able to address the issues which we are going to face in future. So if we see the definition of expert, so now a new, this has been added, any other field. So as we know, the technology is emerging every day. So now we have AI, now we have the criminals who are committing the cyber crimes using newer and newer means. So tomorrow, we may require the experts which we may not be able to define today. So I would say this is a very, very welcome step. The legislature has addressed the future as well. So I would sum up by saying, my first part of the introduction, that what has changed, that it has shed what was not required, it shed the past, it has embraced the present, which is our technology, and it has also provided for the future. Now coming to the more technical part of it, that what has changed. As we see, there were earlier 167, now there are 170 sections, and it has been rationalized, and it is also no longer an exception to any other act. I'll explain. Whenever we had to see the definitions, we always refer to the section 2 of any act. So now in Indian Evidence Act also we have section 2 on definitions. So it is now all the laws are same, and if we have to see the definitions, we go to section 2 in the BSA. And the other significant change is that electronic evidence, which is now the most important evidence for all the LEAs, since I represent an enforcement agency and I can relate to the problems which are being faced, because I see many police officers also and the representatives from other LEAs also. So this, it has been now provided that the electronic record will be document. Right? So it has now made easier that the electronic record should become admissible rather than getting into the hyper technicalities whether it should be treated as document or not. So this ambiguity which was there in various judgments, it has been addressed and now it is a document. Further, there was no standardized format for the certification, that what should be the standard language. Now there is a schedule in BSA which contains the certificate which is to be issued to get the electronic record admissible if it is reproduction of the original. And second, very significant change has been made, that now this certificate is to be signed not only by the person who owns or manages or operates the electronic device, but also by a forensic expert. Because these changes were necessitated not only that the electronic evidence becomes admissible, but also the changes which have been made in our two laws, the BNS and the BNSS. And then there is rationalization also. There were earlier some sections which were on the same topic, but they were scattered, like on confession. Now section 22, it combines the other sections. Similarly, the section 23 and 24, they also combine other sections. Earlier, the electronic expert, it was treated separately, 45A. Now section 39 treats the both at par, and it is only in one section. And similarly, the public and private document, they are also dealt with in the same section. So this is how it has now been made more rationalized. So if the question next would be, if the sections of the Indian Evidence Act have been combined in few sections, then how the number has increased. So in the year 2000, when the Information Technology Act was enacted, there were many sections which were introduced as A. So all those A which stood apart and which showed that they are the later addition, now they have all been numbered along with others. That is how we have 170 sections now. So this is what I had to say, that this is how it has been changed. Thank you.
Thank you. Thank you, ma'am. As ma'am has rightly pointed out, that this electronic evidence, the definitions have been included as documents. And then it becomes a primary evidence that is included now. This is the change, and the explanations are also there. Sections 63, again, with the schedule in the BSA, 2 certificates are required, as has been rightly pointed out. Now the question is that what would be the nature of evidence the prosecution will collect, and how the court will appreciate these things, how those electronic evidence is to be kept in custody, whether the chain of custody will be there. And I am told that certain electronic evidence, if kept in plastic bags, that may lose some materials. So basically, the government has to come up with this training process also of the police officials and the other persons. Now I would like to go to the next question regarding what would be your response in the changes in the section 57 to 63 of BSA. Mr. Lal perhaps would like to start.
With permission from the chair, I would begin by saying that Arjun Pandit Rao Kotkar, 2027 SCC page 1, is a 3-judge decision of the Honorable Supreme Court, penned by Justice Nariman. Now, in this judgment, if we go through the decisions, paragraph 20 onwards, we will see the Supreme Court has already laid down in very clear words that electronic records are of 2 types, primary and secondary. Therefore, the illustration in section 57, which says that electronic records are now primary evidence, is nothing new. It is just giving a statutory clothing to the principle already evolved by the Supreme Court of India. This brings us to the core question, what the learned moderator has asked, as to how to bring such electronic record or digital record into evidence. I will request the House to have some patience with me, because the answer will be a little bit long. Or maybe I can put it very shortly and invite questions from the House. We will all appreciate this is a very new area. So let me begin with this rider subject to correction. Now, in the chapter on document in the Evidence Act, we will see that there are 2 parts to every document. These 2 parts are what we call in Assam execution and content. In the Evidence Act, it is called existing and content. Now, execution relates to admissibility of a document. Content relates to the mode of proof. Am I correct? So, section 57 makes electronic records admissible. So, what do I do? I take out my phone and go to a court of law and say that, see, this is my phone. I have received a threat message from Mr. B. So, if it is not disputed, first of all, if it is disputed, it no longer remains primary evidence. If it is disputed, then it becomes in the realm of secondary evidence. Suppose it is not disputed, then what does it prove? If we read the old 88A of the Indian Evidence Act, and now 90, as Madam correctly said, A's have all gone away. So, what does it say? That I have received a message. To that extent, court can prove it, bring it on record as admissible, but not as to who is the originator of the message. The legislature has been very careful because electronic evidence are very volatile. Therefore, though it is made primary evidence, this aspect need to be noted. Section 88A of the old Indian Evidence Act and now 90 of the BNA. Additionally, I will say, if we take note for 1 second to section 62 of the BNA, Bharatiya Sakshya Adhiniyam, it says in very, very clear words that the content of electronic or digital record has to be proved in the manner prescribed in 63. That means what? Certification is mandatory. Because if it is in the manner, content is as per 63, certification under 63 is mandatory. So that is my answer, sir. One rider I leave to the house is as regard the certificate. Now certificate says part A and part B. If we open your smartphone, my friends, especially the judicial officers, will see part A contains in the last part has value. Now suppose I have to give a certificate as a judge in a case where I am a witness. I will not be able to take out that algorithm. So how we will be able to give that algorithm when we give that certificate is something we will have to ponder during this discussion. Thank you, sir. Thank you.
If I may just add what see, section 57 now brings in a concept of bringing electronic and digital records. You have to see the meaning which has now been ascribed to the Evidence Act, the term evidence. Earlier, after the Information Technology Act came in, the amendment which was made to the Indian Evidence Act was that electronic records shall also be a part of the documentary evidence. Now they have added electronic and digital records. Now another very interesting development which has taken place with this, earlier these documents had to be proved by way of section 65B, now which will be 63. Now here what happens, these documents are to becomes primary evidence. It was not specifically mentioned that it was a primary evidence earlier, but now it has been made with the explanation 4 to 7. Now yesterday I was just finding out what would these explanation 4 to 7 mean, because one has to understand this aspect of the matter. Explanation 4 says, when an electronic or a digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each self-file is a primary evidence. I'll take an example. Today there is some video recording being done by some channel. They record it in some van, they uplink it and it is downlinked in various places, including a place, just for example in Guwahati, they have a head office, they downlink it and put it in various files in the same computer. And there are many files out there, that becomes, all the files becomes primary evidence. Now on the other hand, if you see,
explanation 7, where an electronic or digital record is stored in multiple storage spaces in computer resources, each such automated storage, including temporary files, is a primary evidence. So here, it is different storage. Just for example, the same example, we put it out there in, it is uplinked and it is now downlinked in places like in Guwahati, Delhi, and all these places. Every portion where it is being downlinked will be a primary evidence. Till there it is okay. Now, explanation 5 says, where a digital or an electronic or digital record is produced from a proper custody. Now you see, the proper custody aspect has not been explained here. On the other hand, if you see the explanation to section 81, it says that for the purpose of this section, what would mean the proper custody? In my understanding, there is a requirement to add what would be the proper custody in respect to section 57, because that's when the legislature categorically uses the words in section 81, for the purpose of this section and section so and so, electronic records are said to be in proper custody if they are in place in which looked after by the person with whom such document is required to be kept. This is one aspect. The second aspect which I will also like to bring in, now if you see section 63, on the other hand, they use in the explanation 2 aspects, electronic records and digital records. And mind it, in the first portion I say that the electronic records were already there in the Indian Evidence Act 1872 in view of the amendment made pursuant to the Information Technology Act. So that remains. Section 65B was brought in, wherein it says admissibility of electronic records. Now also we have admissibility of electronic records in 63, but it does not say anything as regards digital records. I think the legislature needs to make certain amendments in that respect. Although, if you see, as Madam has stated out here, there has been a rationalization of the certification, which earlier there was a problem that some person would certify it in a particular manner, some would say certify in a particular manner. Now it has been brought out by a schedule out there stating that this is the certificate in which it's to be mentioned, what is the IME number or whatever number. There they use, in the certificate, however, there are 2 aspects. Electronic records and digital records, by putting it in a hyphen out there, it is being put out there. So I think some amendment would be required in order to put an explanation to section 57 as regards what would be the proper custody. And secondly, as regards 63, that it also includes digital records. Thank you.
Thank you, my Lord. My Lord, I would also like to draw the attention to explanation 5 of BSS to section 57. This says that custody, from proper custody, considered primary evidence unless disputed. So that part is also there. So I request Mrs. Sharma.
Sir, with your permission, since my colleagues from various law enforcement agencies are here, can I say a little more about these explanations with your permission? Yes. So if we read the explanation 4, it says where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. So here we need to take an example that I am making a note on my iPhone and it is simultaneously getting stored on the iCloud. And it is also there on my iPad or any device which on iOS is connected with my particular ID which I have created for Apple. So explanation 4 addresses these kinds of situations. And if we come to explanation 7, so explanation 7 addresses that where the files are being saved even without the knowledge of the user It is without human intervention in the same computer resource. Sometimes what happens, a person makes a document in a particular folder, then he deletes it. And he believes that he has deleted it, but during the forensic analysis, the LEA is able to extract it from some other file. So whenever such kind of questions were raised as to the source, that whether it is the primary or not, so these explanations are addressing those situations. Because in case of electronic evidence, there are two major challenges. Number one is what is the source and what is the origin. And number two is their very susceptibility and vulnerability to the unintended and intended alterations. So there were two, here we need to appreciate that there is a difference. When we have to produce the electronic evidence, we need to satisfy the court that it is the unaltered, untempered, the genuine ER which is being produced. So for that purpose, these conditions were given in the earlier section 65B and now section 63, that whenever we are producing the electronic record, either in the form of taking the printout, or we are taking it in a pen drive, or we are taking it in a hard disk, then how it needs to be authenticated, how it needs to be ensured. So for that, there are few conditions that the information which is being produced before the court from the source, it should have been regularly fed into that. It cannot be that one fine day, there is one CCTV coverage and you produce it. Then it is not a device which was being regularly used. So the first is that device should be regularly used. The kind of information which you are producing, it was regularly being fed into that. And thirdly, if at any point of time that device had broken down, then it did not have the impact that it affected the data in any way or the information which you are trying to bring to the notice of the court. And then it should be exactly the reproduction from the original to the device in which you are producing. So these were the four conditions. And then there were presumptions in subsection 3 that whenever it is connected with network, now there is an amendment, now there is an addition, the intermediary has also been added. So that is a presumption that they will also form part of that machine in which it was being regularly fed. And then the other criteria which was that there should be a certificate. What should that certificate certify? It should certify that I was owning or I was using or I was managing. Because in case of servers, it was always the system administrator who used to give this certificate because he was the person who was responsible. So that person who is either owning or managing or was in the responsible position has to certify that this record which has been produced from the original device, it has been produced from this device to this device. And now coming to the hash value. The hash value may have been introduced now in this standardized format, but it was always there. Whenever any extraction was done, the hash value was always taken, and these are the three standard formats which are used for taking the hash value. And why this hash value was used? Because the IT, the Information Technology Act 2000 in section 3 said that how can you authenticate the electronic record? They can be authenticated only by hash value. So hash value was always used to authenticate the electronic records. So now these explanations which have been brought in section 57 and why it has been made a primary evidence is to ensure that the criminals are not able to fool, criminals are not able to take this stand that since you are not able to find my, the original my laptop or my iPhone, then whatever you are getting from any other place, it is not the original document. So it has been now inserted to address those kinds of situations. And it has also been the explanation 7, it addresses the issue where with the naked eye, you cannot see any file on the computer. But during the forensic analysis, during the forensic, when you are using the forensic tools, then you are able to get those files either from your other like temp or the slack spaces, you can retrieve that. So it is to address the issue of that retrieval of the data whenever it is done.
Thank you, ma'am. Thank you, ma'am. So coming to that certification part, part A and part B. Part A has value is there. Now it has been introduced, as Mr. Lal has said, that it is to be put by someone, it is to be extracted by someone. So in that line, section 39 of BSA, that adds a new thing. It adds or any other field while defining the expert. Earlier, expert was there, now it or any other field has been introduced. So what is the impact? Can we see it in a broader sense, like has value, that whether that this definition, any other field, expert in any other field would include?
Definitely, sir. Because this, I begin again, section 45 of the Evidence Act, we are traditional people dealing with documents. So it says that where the court is of the opinion that in respect to science or art or with handwriting or fingerprints, court needs an opinion, the opinion of such an expert is relevant. That was the Evidence Act. Now let us assume a civil case instituted in Guwahati, where a particular shoe is produced before the court, and the question is that whether the manufacturer of shoe, this shoe, is metro shoes or khadims. Now, whom will we bring as an expert? It is not science nor art. It cannot be fingerprint nor handwriting. So there were areas where section 45 could not have helped the court bring an expert to determine a fact in issue or a relevant fact before the court of law. So Parliament has enacted a very beautifully saying that or any other field, leaving the scope open for the trial courts to call an expert whom it fits, deems fit and proper in the facts and circumstances of the case. That will also apply to electronic evidence. That will definitely apply to electronic evidence when we will need the support of an electronic expert. Now says any other field, so we can call an examiner of electronic records, and we can examine him. But I will leave it to Madam Sama to talk more on that.
This difference has been made because earlier it said that the electronic evidence, if it is required, the expert opinions to be obtained, then the expert opinion would be given by an electronic examiner who is certified under 79A of the Information Technology Act. So there are as of now 12 or 13 electronic examiners who are certified under 79A. But now, if we see in the schedule, the certification under 63 is to be done in each and every case. So now, law, I would say the legislature in its wisdom has differentiated between the expert in terms of certified under 79A and all other forensic experts who can certify the 63 certificate. Because all the time we cannot think only from the point of view that the LEAs have to prove a case and they can get the expert opinion. But in case of the civil suits, even the private individuals, if they have to produce something, they'll also have to produce the certificate in this certificate only. So the forensic expert, who shall be, it has now, as of now, been left open, because it again can be the discretion of the judiciary to decide whether a person who is holding a particular kind of diploma or degree should be considered as an expert, or somebody who is working in this field for last 15 years. So he can also be an expert. So this differentiation between any other field in 39 and the electronic examiner certified under 79A has been made in the Act to address the different situations and to make it more user-friendly for everyone. Thank you.
Yes, madam.
See, what I feel is the legislature did not want to restrict the experts or the expert domain only to foreign law, science, art, or as regards handwriting or finger expression experts. The legislature thought that why not put it in respect of any other field, or there might be various cases. Why should we limit only to these persons? I would not say that about the electronic experts and all these things. Why not many other cases also may be there? A person may be, just for example, he may have some expertise in a particular thing, and that is the relevant issue or an issue of fact which is involved. So these expertise may be very well taken up. So I think the legislature, in its wisdom, thought that it is necessary to include each and everything where, in respect of a relevant issue or relevant fact or an issue in fact in issue, it is required to take the expert opinion. The court would be within its jurisdiction to do so. Thank you.
Thank you, my lord. Perhaps Mr. Ranjit Dev Chaudhary and Dr. may also like to enlighten us.
Thank you so much. Well, so far as the Evidence Act is concerned, the Bharatiya Sakshya Adhiniyam, that's the law which is substituting the Indian Evidence Act. The primary change that we have noted is in the provision relating to electronic evidence. The outdated obsolete provisions have been deleted. Now, I do not know how many of you would be aware that how the provision relating to section 65B has come into our statute book. It is something like this. These particular provisions were enacted in the British laws in 1968, in the civil laws and in the criminal laws of Britain in 1968. That point of time, we did not have computers. Electronic evidence, so to say, was almost nil at that point of time. Ultimately, by the time 1993 came, the Britishers saw that this has become obsolete. In 1993, the perimeter provision of section 65B, which was available in their civil laws, was deleted. By 1999, the same was deleted in their criminal laws as well. But in 2000, we enacted the same thing in our laws. It's quite sad. We did not make any change. What they had discarded, we had introduced into our law. So far as electronic evidence is concerned, the law has been well settled from the case of Sandhu to this, last year, he mentioned Arjun Pandit certification. Now, while dealing with the case, I was appearing for the NIA. A peculiar situation has arisen. I think my friends in the NIA are there. What we say is electronic evidence. Suppose something is there in the hard disk. We seize it from the computer. We send it to the forensic lab. They say, oh, it's there. But how do you tackle problems like emails? Here was a case where an organized group was coordinating their activities via email. One person, by some name that he had taken, was addressing communications to all his colleagues by way of email. Everybody had a different name. And when this one person was arrested, he gave the email ID. In front of him, he gave the password and the emails were downloaded. Now comes the question of certification. I would just ask myself, if email ID is given to the learned judge. He is given the password. He can very well see the email. It is before him. Do we still need a certificate for that? The hard disk is all right, I can understand, but whatever is there in the net, how do you tackle that problem? I think there are still a few more steps that we have to take in this regard. And furthermore, there is one thing that perhaps maybe we have missed out. And the European countries are far ahead of us. The service providers, you know, Google, the Facebook and all those things are there. They have put these organizations in the loop, in their law. They have to cooperate with the investigation. There is nothing like that that I see in our law. In fact, there has been a case, a PIL, which I was dealing. There was an occurrence in Arunachal Pradesh where an accused person was taken out from the police custody and he was brutally killed. That came out in the Facebook. On the basis of that, a PIL suo motu was taken up by the Guwahati High Court. And we have been writing letters to the United States of America, Facebook, nothing is coming out. Whatever has come in Facebook, whether it's the original. Now, a few amendments have been made. Now we can verify whether the particular thing that is in the electronic system by the hash value. But who is going to do that? We have got only 1 or 2 labs in India. In most of my cases, it is going to Delhi or to Bangalore. There is one in Hyderabad, 3. While the other new acts lays down a timeline for trials, if we do not have a ready system in our courts, or in every state, may I say, it will take a hell lot of time to get it authenticated. Perhaps the government, the legislature in its wisdom, will look into this matter so that at least the authenticity of something which is in the net can be verified. We can get the authentic reports from the service providers at the earliest. That would go to a great extent in going forward with the new laws. Perhaps I feel that little portion is missed out. Thank you so much.
Good afternoon. The Bharatiya Sakshya Adhiniyam is a legislation which modernizes the law of evidence. In this age of technology now, which we are in, most of our activities are regulated by technology. Now the question comes, because of technology, all our activities are somehow recorded, for example, in our smart watches, in our phones, in our Google. Every month a mail comes to me that you have visited these places within 1 year or in a month. So my activities are tracked by even Google Maps. So now the question is, all these are, in some cases, they become relevant for deciding certain facts. Earlier, what we used to do, call data record, that's the only source of information about the location of a person. Now we have Google Maps. So now the question is, how do we bring or collect this evidence? Because electronic evidence has been introduced, but electronic evidence can be in 3 forms, at least. First is mails, which can be printed. You can take a printout, get a certificate, whatever you want to do. Then second evidence is video evidences. Video electronic evidences, and third may be audio electronic evidences. Now, printing or what evidence act says that certain emails we can print out and get a certificate. But what about the videos? What about the audio recordings? I know about the cases that a CD of a case that was produced in court, and that was the only copy made, and the CD got somehow, it was broken in the court itself. I also know about a case when a video recording was given to court, but at the time of playing the video recording, when the exact time came when the crime was committed, that got blurred because that evidence was examined after 8 years or after 10 years. So one suggestion, what I feel, because electronic evidence is susceptible to erosion, and it can be erased over a period of time, because whatever storage devices we have as of now, be it pen drive or be it as a compact disk or whatever, to my understanding, those are not permanent in nature. Over a period of time, the evidences disappear from that also, because of some scratches or because of that. So why not we had something like 164 in CRPC, the old CRPC, that, for example, any witness who is familiar with the facts or relevant issue, he is going away, or there is a provision in CRPC, you can record his statement before even the trial commences. So why not there are some provisions in CRPC? That's my understanding of the thing, that when electronic evidence comes of this nature, because trial takes its own time in our courts. And by the time when those evidences, electronic evidences will be examined by court, there is a good chance that this will disappear from the storage device. So something like 164, that electronic evidences can be recorded, something like 164. I'm just floating that idea of something like that can be introduced in the system. And otherwise, it's a great piece of legislation, because the modernized, all our activities now, for example, CCTV coverage. Any road accident happens somewhere, if CCTV coverage is there. Now earlier, we see day in and day out the motor accident cases, whose negligence is to prove whether the offending vehicle was negligent or the offender was negligent, and whether compensation, who will pay the compensation, all those things. Now CCTV footages are there. If CCTV footage is available, so these can be taken use of. So in my understanding, this is inclusion of electronic evidence is a great development of law. It is towards the modernization of law. Thank you.
Thank you. That is why my question started with that thing only, preservation of the evidence. That is, Dr. Mozika has pointed out rightly, and the suggestion. Thank you for the valuable suggestion it is. As we are seeing that in this cyber crimes, not a single person is involved. It is a joint work of many people. So the question of accomplice witnesses also come. Now there is a section 24 of the BSA and section 138 of the BSA. This deals with the confession made by accomplice as well as making the accomplice a competent witness. So in such a scenario, what would be your view? Mr. Roshan Lal, please.
There was one case, a recent one, before the Supreme Court. The case is Raja versus State of Tamil Nadu. It is reported in 2020, 5 ACC 118. Now the facts. It was a trial under the TADA Act. A and B were facing the trial. During the course of the trial, B absconded. The case, over a period of time when his attendance could not be secured, was filed, as we call in Assam. In the CIS, it is called adjourned signed die. temporarily closed. The proceeding continued against A and he was convicted based on the confession and other evidence on record. Some years down the line, B was arrested, put to trial, and before the Supreme Court, prosecution tried to show that, my lord, this is the confession of the co-accused. It has not been acted upon. If it is acted upon, it is a last link. It will lead to conviction of the person concerned. The Supreme Court said, nothing doing, because it is not a joint trial. Confession of a co-accused under Section 30 of the Indian Evidence Act, now 24 of the Bharatiya Sakshya Adhiniyam, requires joint trial. This decision perhaps, or many other decisions perhaps, of this type has led the legislature to create a legal fiction in Section 24, and it lays down that when such a person absconds and it fulfills the requirement of the BNSS, then it will be considered as a deemed trial for the purpose of Section 30. Evidence can now be acted upon against. That is my answer, sir.
Mr. Ranjit Chaudhary and Dr. Mosikame, perhaps. Yes, my lord.
See, Section 24 does not make any change to Section 30 of the earlier Act. It remains the same. But the explanation 2 has been added in view of Section 356 being brought into the BNSS. Because otherwise, 356 would become useless if you don't bring in the explanation 2. Now, let us read Section 24, which is Section 30. And if you see the judgment, I think, of the Constitution Bench in, I think, 1964, Harsaran Kurmi was the state of Bihar. It says that a confession of a co-accused is much weaker than a statement being made by an accomplice. And this is also being recently followed in the judgment of the Supreme Court in Surendra Kumar Khanna versus the Director of Revenue Intelligence, if I am not wrong. Now, one has also to correlate with Section 133 earlier, and now I think 138. 138 now, if I know. Now you see, there is a difference which is there. Earlier, it said that a conviction of a person on the evidence being given by an accomplice, even without uncorroborated statement of without the statement being uncorroborated, would be legal. Now this is being changed to corroborated, and it seems now that this is being done in tune with the earlier existing 112B, the presumption, and I think now it is 116B or something to there. The presumption, if we see, yes, 119B. Now, an accomplice is unworthy of credit unless he is corroborated in material particulars. So earlier, I think there was a cautious omissus of the legislature, which had been corrected now by putting it that corroborated statement, although there has been 2-3 cases wherein already on the basis of an uncorroborated statement of an accomplice, a person has already been convicted. Now, this is a welcome change being made by the legislature. Now, as I was saying about Section 24, the 24 is on the basis of a confession being made by a co-accused. One very important aspect is if you look into section 356, which I think in the next technical session, it would be duly dealt with. It is one of the most important sections which have come. And that is one of the major reasons why it has been brought in, because of the fact that there used to be a lot of people who have been proclaimed as offenders, and as such that either the trial is stayed or has not taken place. And under such circumstances, 356 has been brought in. Now this, in order to give effect to this 356, the explanation too is done. Now one thing has to be also, although it's a very weak piece of evidence, taking into account the judgments of the Supreme Court in section 30, even in my, what I feel from a reading, even if a confession is recorded, because the confession has to be recorded before a magistrate, it is not done at the time when it is before the court. So if a person who is being arrested, he records the confession of a co-accused, then this particular person gets a bail and is nowhere to be found. Now on the basis of this confession, the co-accused, not only him, the co-accused can also be tried and it becomes a relevant fact which is to be taken into account. So that is the thing which is there, and I think they will be requiring some judicial interpretation into this section. Thank you.
Thank you, my lord.
So far as the statement of co-accused is concerned, I would just draw your attention to a case of the Honorable Supreme Court in Shankar versus Tamil Nadu. And it was held that when an accomplice, he gives a statement and he becomes an approver that way, that statement can be used, that particular person can be used as a witness also. But there is a rider, that the evidence given by him does not have any evidentiary value until it is proven that the evidence is reliable. A second testimony given by him, again, that has to be corroborated. So only giving a statement without any corroboration would not do.
Thank you. So ultimately, going by the change of the materials to be placed before the courts, a burden lies, heavy burden lies on the courts also. And court cannot be a silent spectator in case of, to find the truth. It is the well-settled principle, and Honorable Supreme Court has from time to time has reiterated this thing. So my query is, 168 of the BSA gives power to the court, like earlier, power to the court to ask any question. But if we read with proviso to 165 of the BSA, which restricts calling for communication between minister and the president. So I would like to request the eminent panelists to kindly.
There is a subtle change, but not of much importance. Why I say not of much importance is that once this section says that court still retains the power to call for such document which it considers relevant for adjudication. The restriction imposed now by the statute is by insertion of a proviso where the Parliament lays down that any communication made by ministers to the President, that matter cannot be called for by the court. Now, if we read Article 74, sub-article 2 of the Constitution of India, this provision is a part of the constitutional law, which says that, language I may not remember, that any inquiry, any advice tendered by the Minister or Council of Ministers to the President of India shall not be subject to judicial review. The constitutional provision, perhaps that is why it has been brought in here. I would just like to add a few lines. In this Rafael case, in the Rafael case, second case, the review case, 2019 6 SCC page 1, Yashwant Sinha versus CBI. Now, the Supreme Court has laid down a principle of law. The Supreme Court says that if the state takes a plea that the disclosure of this document is not in public interest, this plea will be examined by the court. And if it is found that yes, the plea is justifiable, then only the document will not be open to the public. So, what the Supreme Court did in that case was call for the relevant document from the Defense Ministry, saw the document and said that no, these documents are not privileged, and disclosed it to the opposite party. So the principle remains, to the best of my understanding and subject to what Lordship says, that court will determine that whether the document, disclosure of the document is necessary, is in non-disclosure of document is in public interest or not. Secondly, one rider has been put, and that rider perhaps appears to be mandatory because of the constitutional principle that ministers tendering advice to the president, that matter, those documents shall not be called by court of law. That is my take on it, sir.
Thank you. My lord would like to add.
You asked about 168, if I'm
68 and 165 proviso. Proviso to 165.
You see, 168 was already there.
Already there, yes.
So there's nothing to that. There's no change to that. Now, as regards the proviso, this seems to be the legislative mandate to make it a form of a privilege document, which is already, it is already contained in many forms. Like, just for example, there was, but these were all, had some exceptions. For example, you had a person could be, an officer could be very well directed, cannot be directed to produce a particular document. But if his senior or his head of the department allows it, then that document can be produced.
Yes.
But this proviso to section 165 does not have an exception.
Yes.
That is what.
Yes, madam.
So this is, I think, the legislative mandate. It would have to be tested at the time.
Yes, madam. So everything is evolving. Law is evolving, as we all know, and those are subject to the interpretations. This is a very new law coming, and we must take it positively. It must be workable. We must make it workable. That is the intention. Other panelists would like to add a few words. Otherwise, the audience may be requested to put their questions to be very short and precise to the eminent panelists. We are running behind time. So I request the audience to put questions shortly. Yes, Mike, please.
Sir, I am Dr. P.P. Dev Sharma. I am Deputy Director in Forensic Organization here. My question is, first one, about the certification for electronic or digital data. Can it be, as per new legislation, can it be used retrospectively? That means, if it is not as per earlier act, if it was not submitted at the time of giving the report, can it be, it could not be submitted at the time of deposition of evidence in the court. But as per, what is the provision? Is there any change in that provision? May I ask my lord as well as the panelist?
Yes. Regarding the stage at which the earlier Section 65B certificate to be produced,
yes,
so there has been judgment from the Supreme Court. It has been clarified that it can be produced at any stage during the trial.
Yes.
So I think that law will hold good even after introduction of BSA.
But at some time, my experience is that it's subordinate judiciary. The honored public prosecutor has refused. Anyway.
Because this is the law. This is the law laid down by the apex
Supreme
court.
Supreme Court.
Yes. So it can be produced at any stage.
Yes, ma'am. And another thing about the biometric evidence, which is very much used now. Is there any provision in the new act? Biometric means about the voice identification of one person, about the DNA fingerprinting, about the retinal fingerprinting. These are the new domains. In fact, prior to Ritesh Sinha versus AP, State of UP, there was no judicial directive for taking the voice of a person, which is against Article 23, Article 20, subsection 3 of the Constitution.
It has already been there always that if you have to prove that it was somebody's voice, so you will get it proved.
Yeah, but
so
for taking
that
the
is
voice
why that is why I'm saying the law which has already been settled, that will still continue to apply whenever these new things come. And otherwise also, if we go by the definition of electronic record, right? So we go to the IT Act 2000. So whether you call it biometric, whether you call it CCTV coverage, whether you call it any other thing. So technically it would always fall into that definition. So whatever is the procedure prescribed to prove an electronic evidence, that will apply to everything.
No.
Because it gets basically covered in that definition.
Yes, ma'am. Yes, ma'am. I just want.
Yes, I think Professor Tiwari would like to respond. Let him.
No, biometric and electronic, these are two different things.
They will technically they will fall into the definition. Yeah.
Okay, thank you so much. Law is a dynamic entity.
Technically they will fall into the definition.
No, what is question is basically voice samples. Now they have been recognized in the law. Section 349, Bharatiya Nagarik Suraksha Sanhita, now makes it evidently clear that voice samples can also be directed by the magistrate to be taken by the accused. So I think earlier it was not part of that. After Ritesh Kumar Sinha case, it has been added in the law. So the new law makes that change. So voice samples can be very much directed by the authorities like magistrates to be taken by any person, and it is part of the law now.
Yes.
No, it requires to be taken with the direction of the court. Earlier section 311 capital A has been amended, and presently it is 349 where that has been added.
I think this question belonged to the next session, and the panelist for the next session is already addressed. Thank you so much. Thank you.
Thank you. Any other query?
If I may just add one thing, what the gentleman said, as regards the certification, can this new certification be used for any pending matters? The answer is there in section 172 of this new act, BSA, wherein it says that the provisions of this act shall not apply to any pending investigation, appeal, inquiry, anything. Under such circumstances, this certification would not work. You have to go to the earlier Indian Evidence Act. That's the answer.
Thank you, madam. Anyone?
Good afternoon, sirs and madam in the panel. My question is related to digital record. There is a case in which a video of the commission of offense is available with a person. That person received that video from the accused, one of the accused. He is willing to give the video in a pen drive, but he is not willing to be a witness, nor want his name to be taken into a record. So how to make it admissible in the court? That's my question, sir. Second, there is a viral video which was going around for a day or two. Later on, it was deleted. In the meantime, some people have downloaded the commission of crime. How to take that as evidence? Those two questions.
See, here I think the explanation will come to the aid of the LEAs. Because if you have downloaded something from the internet, from Facebook, so then the certificate will be given by the IO and it will be signed by the forensic expert along with it. The certificate will the certification that how it has been downloaded. So it can be led by the IO.
Okay, ma'am, thank you. First one is related to the video, which a person is willing to give in a pen drive, but he is not willing to be a witness. He don't want his name to come in record.
I'm just, thinking out of the box and giving you an example that in our system, we do not distinguish between how the evidence was procured, right? We do not follow that doctrine, the poisonous fruits of the poisonous tree. So in this case also, if it can be produced as secured from somewhere, and again it can be certified by the IO.
Okay, ma'am, thank you.
I will add to that the legal angle. In the Evidence Act, as we know, and in the new Bharatiya Sakshya Adhiniyam, there is a provision that judges and magistrate need not disclose their source. So if the pen drive is collected by the IO from Mr. X, and Mr. X makes a request, the provision will help. Court cannot ask the source of information of the IO as regard commission of a crime.
Thank you very much, sir.
Thank you. Now, I think we can close by one question only. Last question, yes. Perhaps he stood first.
Jain sir, I am Bikramjit. Now I am serving as Deputy JAG in SSB. Sir, many of the force personnel are now becoming victim that their money are siphoned off, that they receive a call through their phone, and the voice, the caller is a lady, and later on identified to be some male. So how will we deal with such cases? Thank you, sir. Regards.
When we are getting the electronic record under the formal means of international cooperation like LRMLED, is this your question?
Ma'am, rightly, but the force personnel become very much attracted to the voice, but the voice is not generated by artificial intelligence, not by any other. So this is a big challenge for.
No, please make it specific. What is your specific question?
The personnel serving in the force receive a call. The call is from artificial intelligence, not by any other. That is the big issues we have, sir. Regards.
So this is completely a new area,
yes.
Which we as investigating agencies will have to evolve our own means to do that. As of now, I can only say this.
Okay, thank you. Thank you. So I would like to request Honorable Mr. S.S. Devashish Borua to kindly make the closing remarks.
See, the most important change which has happened by this BSA is the bringing the digital records within the fold of evidence. You say, although we have discussed many things, I think this is a very important aspect which one needs to take note of. Earlier, if you see, the evidence was defined as all documents including electronic records produced for inspection of the court. Meaning, just for example, electronic records may be there in a pen drive or whatever may be. But now they have brought in the concept of digital records. Although the Act requires, in my feeling, an amendment or an insertion as to what do they mean by digital records, taking into account that the digital records is neither defined in this Act nor in the Information Technology Act or in the Bharatiya Nyaya Sanhita or the Bharatiya Nagarik Suraksha Sanhita. They have not defined. Now, when the legislature uses two words, electronic and digital records, and in certain places, as I was just mentioned, 63, they have used as regards electronic records. In my feeling, the legislature needs to also define what is digital records. So therefore, I search out what would be the difference between an electronic records and digital records in, if we could see certain books or certain journals out there. Now, I could make out that there are fundamental differences. Just for example, the gentleman out there said about a particular biometric test being taken of that person. This test result which is being taken, this resulted or the sample which is being taken now would be a digital record. Now this digital record being brought within the purview of evidence is of such an importance, and this is one of the most fundamental things which have happened, is because, you see, evidence is a thing which you need to give it to the accused. At the time, when you are giving the copy, which was earlier 207, when you are giving the copy, you have to give this entire evidence to that particular, to the accused. Now, the question is, can you give material evidence or material exhibits? Just for example, let us take up the question of a narcotic drug, an obscene book. The moment you give it to him, you are incriminating him, you cannot give it. Now, for example, let's take a CCTV camera footage. That's also a material exhibit. Now, this becomes, this is why this is very important. This particular material exhibits can be very well cloned into the form of a digital record and given, because now it becomes a part of the evidence. And as such, in view of 207, now I think it will be 209, you have to give this particular document today. So under such circumstances, this is the most fairest procedure which has been done. That is why the fairness, not only in the BNSS, as well as also in the BSA, is that, yes, certain material exhibits can't be given, which has a which is of the physical form. But as regards the all digital material exhibits, can be very well given to the accused. That is why this is the digital records now have been inserted. Thank you.
Thank you, my lord. Thank you, my lord, and thank you all the eminent panelists present here. Thank you all. With the permission of the chair, may I declare the session to be closed? Thank you, madam.
Thank you all for sharing your valuable thoughts, and we indeed had some outstanding questions, remarkable in their thoughtfulness. I'd now request our esteemed guests on the dais to kindly step forward for an official group photograph. Thank you all once again. Ladies and gentlemen, we will now break for lunch and reconvene at 2:30 p.m. sharp for the third session. I would most humbly request everyone to kindly stick to the schedule. Thank you once again. I request everyone to be seated. In just a short while, we'll start with the third and the final section. Thank you.
হ'ব গতিকে সকলোকে উদ্যোক্তাসকলৰ ফালৰ পৰা সেশনৰ লাষ্টলৈকে থাকিবলৈ অনুৰোধ জনোৱা হৈছে ধন্যবাদ
Ladies and gentlemen, welcome back. We will now proceed to the third session of the day, and the topic for this session is Bharatiya Nagarik Suraksha Sanhita 2023 BNSS, the new act that replaces the Code of Criminal Procedure 1973. We will dwell at some length on, first, the procedural changes to be introduced under the act with a specific focus on their transformational impact. Next, the administration of criminal justice grounded on scientific basis that enhances its reliability, and finally, delineate the victim-centric aspects of the new system. Our panelists, drawn from across judiciary and academia, collectively bring a wealth of experience and expertise in the criminal justice system, which would allow for a highly engaging exchange of ideas. The session will be chaired by Honorable Mr. Justice Arun Dev Chaudhary, Judge, Guwahati High Court. The moderator for the session would be Professor Muhammad Asad Malik, Faculty of Law, Jamia Millia Islamia University, New Delhi. I would request you both to kindly come forward and take your seats, please. Thank you. The panelists for this session are Shri Khondram Samarjit Singh, Deputy Solicitor General, Manipur High Court, Shri E. Chandrasekaran, Advocate, Madras High Court, and Shri Neeraj Tiwari, Assistant Professor, National Law University, Delhi. I request our panelists to kindly take their seats, please. I now hand over the session to Professor Mohammad Asad Malik, Faculty of Law, Jamia Millia Islamia University, New Delhi, our moderator for this session, to commence the proceedings.
Thank you very much. Respected Chair, Honorable Justice Arundev Chaudhary, Judge High Court, Guwahati, other panelists, Shri Khondram Samarjit Singh, Deputy Solicitor General, Manipur High Court, E. Chandrasekaran, Advocate, Madras High Court, Dr. Neeraj Tiwari. Of the chair, I will open the session. Respected judges of the different high courts, retired judges, deputy solicitor generals, IPS officers, public prosecutors, officers from the ED or other department, dear students, and all the officials from the Ministry Law and Justice. I welcome to all of you in this technical session 3. In the morning, we have already enjoyed 2 sessions, very fruitful discussion about the BSA and BNS. Now we are having your Lordship as the chair of the technical session 3 and 3 esteemed panelists. How I will conduct this session? First, we will take the opening remark of your Lordship, then the question will be asked to the panelists, and finally, we will open the session for questions. As yesterday in the inaugural session, it was discussed what was the need of these 3 laws. Honorable Minister Law and Justice Arjun Meghwal said in 1860, after 163 years, this IPC was replaced with the BSA, and then after 151 years, this Indian Evidence Act was replaced with the BSA, and after 51 years from 1973, that this Bharatiya Nagarik Suraksha Sanhita have been played. I would start with one of the poetry कि तुमने चाहा ही नहीं, हालात बदल भी सकते थे, मेरी आंख के आंसू तुम्हारी आंख से निकल भी सकते थे, तुम तो ठहरे ही रहे झील के पानी की तरह, दरिया बनते तो कहीं दूर निकल भी सकते थे. तो actually it was the enactment after the long time, but we think that it will be very useful. Now I am going to start the session. Thank you very much.
Good afternoon, everybody. All dignitaries on and off the diocese, and then judicial officers and all participants. I welcome you all to this 3rd session. The moderator has already introduced you. How will we proceed? Post-last session is always a difficult proposition. That too after 2 back-to-back sessions. But I am having full trust that our panelists, esteemed panelists, will keep you energized and alive. The Code of Criminal Procedure in India was first enacted, as you know, in the year 1861 by the British Parliament, following the passing of Indian Penal Code in 1860. Now, how it developed, the 1861 code made European natives immune from criminal court jurisdiction, except for High Court. The code was amended in 1872, then 1898 to ensure uniform application to British and Indian subjects. In 1982, the Act 10 replaced the 1861 Act. And it developed now. Law Commission in its report in 1958 made recommendation for changes, and it's 1973 the present CRPC was enacted. Now we are with this new law, where the word, instead of word code, the word, what you call it, Bharatiya, this word, what is that word? Sanhita. Sanhita, NSS, BNSS, has been Suraksha. That Suraksha word I am meaning. Instead of code, that Suraksha word is used, which will mean a Suraksha so far relating to criminal justice, dispensing of criminal justice system, relating to both the accused and the victim. So this has become a Suraksha, not a code. This is a leap. I think that name is having certain significance. All this will be deliberated by the panelists. So let me hand over the things to the moderator.
As your lordship highlighted that this is the 6th edition of the CRPC. Earlier it was the Code of Criminal Procedure. Now it is Bharatiya Nagarik Suraksha Sanhita. So I am asking first question to Shri K.S. Singh, Deputy Solicitor General Manipur. And we are starting with this nomenclature, that the title Code of Criminal Procedure has been modified, or we can say replaced, Nagarik Suraksha Sanhita. What has been the intention of the legislature behind this change, and how this new name will be helpful in protecting the Nagariks? I would appreciate your comment on this issue.
Yes, thank you. First, we go to that particular question. We need to have an overall outlook of overall scheme of the Act, which is a complete departure from the traditional way of dealing with offenses. So we had, prior to this Act, was mainly focused on finding guilt based on the mens rea and actus reus of the offender. So that is, in that retributive sense of criminal justice kind of a thing, and that is completely shifted towards the restorative kind of a justice delivery system. And the restorative kind of this thing theory has got its relevance with the kind of act that we have come up through our parliament, and that has been assented to by the Honorable the President, and it is coming into force from 1st of July. So this is a very watershed moment in our country's history, as we have just come out of the colonial past. And as to the name, this is entirely signified by the provisions that was already included. The use of word, the Suraksha, is the protection. Like it is mainly based on justice-oriented and a victim-centric kind of a thing. As we have seen in the definition itself of the victim and how we deal with such kind of victims. In a normal retributive system, we find the guilt and we talk in terms of giving a punishment so that that kind of offense does not recur. And it should act as a deterrence in future. That kind of an attitude, even though we maintain some of its provisions, I should say many of its provisions in the Sanhita itself, but the shifting of that particular thing makes some significance in this matter. And hopefully we put it into practice, and we'll get to know how it works, and hopefully it will work very well. And there are so many provisions where we are supposed to simplify the method of our trial, and we try to get those evidences through electronic modes, then filing of 0 FIRs, and the significant portion in this particular filing of an FIR is also we can file an e-FIR, and we can make our signatures within 3 days of such filing. And the most significant, I should say, is the progress of the investigation is always to be intimated to the victim or the informant. That is most significant. And this is something we never thought of. So that way, I mean, the very name itself would give us a good impetus in further going with this act. So I should.
Thank you very much. As this term Nagarik Suraksha Sanhita, as we know that the basic purpose of the law is the greatest happiness of the greatest number. Basically, the CRPC is considered as one of the most important law, being a procedural law, and many people come into the contract of this law. And there are 5 functionaries are involved in this criminal justice system, basically police, magistrate, prosecutor, defense counsel, and prison authorities. And ultimately, the objective of this law to protect the citizen from unnecessary exploitation, harassment, complication, to make the procedure easy. So basically, this is the objective of the Bharatiya Nagarik Suraksha Sanhita, to protect the Nagariks or the citizens from all kind of the procedural technicalities and make it more efficient or easy. This is the intention of the legislature. Now, as we know that our system, we are based on this most accused-centric and protection of the rights of the accused, because that person presumed innocent until proven guilty. So mostly we protect the rights of the accused person. Even in our criminal procedure, there was no reference before 2009 about the victims. First time the term victim was defined in 2009. Now in Bharatiya Nagarik Suraksha Sanhita, I am posing this next question to Shri E. Chandrasekharan, Advocate, Madras High Court. BNS has brought victim-centric reforms, and it also emphasized on more victim participation. And if yes, can you enlighten us about these reforms?
Good afternoon, everybody. Good afternoon, everybody. Thank you. With the greatest respect to the chair and my colleagues on the dais, at the outset, I want to thank Honorable Justice Ashwani Kumar Mishra and the Union Law Secretary Rajiv Maniji for extending their cordial invitation to me. With the blessings of my parents and my teacher, Mrs. Vrinda Mohan, an advocate of Pondicherry, I am here in front of you. Around 2016, one slogan of the Honorable Prime Minister Modi ji was thundering in the country: Make in India. I repeat, Make in India. But hardly do we comprehend at that time that this country is going to make the parliament also under the concept Make in India. In the year 2020, they started it. Then thereafter, in 2023, September, we made a new parliament. And the country has proudly made 3 laws, which are in normal, ordinary man's language called as major laws. Any student you go and ask, bring that major law book, they will bring a book which contains IPC, CRPC, and Evidence Act. Now this country, the greatest democratic country in the world, has made 3 laws which shows the country's self-sufficiency and also dignity. The question posed to me by the respected professor is that can we say that victim-centric approach has been made in BNSS? The parliamentarians, they do enjoy the concept of parens patriae like the all courts. For a government, both the accused and the victim both are kept at the same pedestal. However, in the CRPC, the protection that was extended to the accused was unfortunately absent to the victim. First of all, I have a mandate and I am duty bound to explain who is a victim. This august gathering consists of people from so many disciplines. So I will start from the section 2 and I will end with section 230. Don't get scared, I am not dwelling upon all sections. Sections which are relevant only to victims. Right? Then at the outset I will explain you who a victim is. Section 2Y of BNSS explains a victim as a person who has sustained a loss mentally or physically by an accused person, and the word victim also encompasses in it the victim's legal heirs. Point 1. And a victim is a person who feels or who has a grievance that her right to life and personal liberty was already assaulted by the alleged accused. The accused wants to sustain his rights before the court of law, and accused is always protected by two major doctrines. One is the presumption of innocence and another is the presumption of proof beyond reasonable doubt, the doctrine of proof beyond reasonable doubt, which the prosecution should prove. These concepts, as you all know, were propounded by Wilmington versus DPP on 23/5/1935 by the House of Commons. And this section 2Y, which defines victim, the concept of victim protection was embedded intrinsically throughout the code, and if I have to explain it by an example, if BNSS is presumed to be a long golden chain, then so many provisions which protects the victim, which rehabilitates the victim, which compensates the victim, are like embedded jewelries in that. So the next question is, who will protect the victim? In a democratic sovereign state, who will protect? Should the victim protect herself? No. The answer is in section 18 of BNSS. 18 says there will be a public prosecutor to appear on behalf of the victim for the state. Suppose the victim feels that the public prosecutor is not prosecuting her case properly, then she has got an option under section 18 subsection 8 to appoint a pleader of her own choice. This is one of the radical move in BNSS, section 18 subsection 8. Then comes this provision of section 19, which speaks about the duties of the assistant public prosecutor. 18 speaks about the public prosecutor, 19 speaks about assistant public prosecutor. 20 is another one radical provision which should further flush out the rights available for the accused, or setting up of an institution called as the Directorate of Prosecution. And this Directorate of Prosecution fixes the accountability, because all these three laws are envisaged towards transparency, accountability, and also time frame. Section 20 is the Directorate of Prosecution, which the mainstay of it is to govern all the prosecuting agencies of the country. Then comes another one question. In a crime, who should be medically examined? A victim says she or he suffers injury. Whether the examination of accused also by the medical person is important? The question is obviously yes. But even in grave offenses of POCSO, in offenses like group gang murder, gang rape, and many other grave offenses involving sexual offenses and also other IPC offenses also, many a times the investigating agency, they miss the bus by not examining the accused. The question will be in the minds of you ringing. What is the relevancy between examining an accused person medically vis-a-vis protecting the victim? The Honorable Supreme Court has condemned the practice of non-medical examination of accused, because we will take an example of a rape case. In a rape case, if a woman sustains a 12 o'clock injury or a 6 o'clock injury of her vagina, then law expects that medical science says if it is a penetrative sexual assault, then the man also will sustain reciprocal injuries. And the man also will have reciprocal injuries throughout the body. The lady would have resisted, and the man also will carry the secretions of the body of the woman. And so the Honorable Supreme Court, in the case of Kishan Kumar Malik versus State of Haryana, and Rajendra Prahlad Vasnik versus State of Maharashtra, Chodka versus State of UP 2022, Munna Pandey versus State of Bihar 2023, has insisted that invariably in all medico-legal cases and sexual offences cases, the investigation and prosecution should see to that the accused is medically examined. Those rights are fleshed out under Section 51, medical examination of an accused at the request of the police. 52 speaks of medical examination of an accused of rape. 53 court directing medical examination of the accused. So it is all fleshed out in 51, 52, 53 of BNSS. Then coming down is the great Section 173. The Honorable Law Minister also was yesterday dwelling on Section 173, which was also spoken by Union Law Secretary Rajiv Mani sir, and my Lord's Honorable Justice Rishikesh Rai of the Honorable Supreme Court also spoke about 173. For the interest of the participants, I am duty bound to explain what is this Section 173. This Section 173 speaks about registration of FIR. Now, an FIR can be registered by the victim or the witness from their residence by electronic means. For the first time in the country, a victim need not run hither and thither and wait in the police station for days together to get a FIR registered. And aram se he or she can sign it after 3 days. Then, concept of zero FIR was also introduced. The concept of zero FIR is registration of an information by the non-jurisdictional police station. You can report to any police station about an incident on cognizable offense, and that police station is duty bound to register that FIR without assigning a number, because they will send it to some other police station where they will give it a number. This is called as a zero FIR because a number is not provided for that. If you want to understand more on a zero FIR, you can read Neelu Srivatsav versus State NCT Delhi 2021 Delhi High Court judgment. Also, you can read the judgments in Satvinder Kaur versus State, and also the judgments of State of AP versus Punnati Ramulu 1993 Supreme Court as to after registration of FIR by a non-jurisdictional police station where it has to be sent. This is all envisaged in Section 173. 170, and another one important aspect in 173, because it is victim-centric, the copy of the FIR will be given to the informant or the victim. Previously, it was only to the informant. This is one radical move in Section 173. Coming down the line is Section 174. A victim of a non-cognizable offense can register an information with the police station, and the police is duty bound to send that NC report once in every fortnight to the magistrate, and magistrate will order for registration of FIR under Section 174. Coming to Section 175 subsection 3, we will imagine of an illustrious situation where the police declines to register an FIR under Section 173. You send a copy of that to the superintendent of police, and superintendent of police is also equally not acting upon that. 175(3) is the answer. You can make an application to the magistrate, and the magistrate will order for investigation. This is Section 175(3). Coming to Section 176, I was talking about DNA, importance of DNA. 176 subsection 3 says, the investigating agency should definitely involve DNA scientific forensic evidences. Even if it is not available in your state, you should take recourse from the neighboring state. This is what is mandated under Section 176(3). From 176(3), you should go to Section 183, which is also very important. 183 is important in the sense, a victim of a sexual offense, a woman, need not be examined by the police even. This was the concept, the strength of this section was derived from the judgment of the Honorable Supreme Court in State of Karnataka by Nonavina Keri versus Shivanna, alias Tarkari Shivanna. The Honorable Supreme Court said, under the present 183, a victim who is a sexual victim who is temporarily or mentally, physically or mentally deranged, police need not record 161 statements. Magistrate is duty bound to record a statement under present 183 of BNSS. That will be used as a chief examination, mind it. So victim need not be made to cry the same unsavory act for many a times, because the legislature has understood the pain. 183 subsection 6 is an innovative insertion in the present code. Then coming to 184, 184 is medical examination of rape victim. Gone are the days where the doctor certifies the character of the victim by doing the two-finger test. Now, the legislature in its wisdom and under section 184 of the Criminal Procedure Code has used the word, the victim will be medically examined only on her consent. Without the consent, you cannot. Right? And you can also read for gain 2 judgments, Lillu alias Rajesh vs. State of Haryana 2013, and the latest judgment of the Honorable Supreme Court, State of Jharkhand vs. Shailendra Kumar Rai of 2022, where, my lords, the Honorable Supreme Court said two-finger test is banned. If any doctors venture to do that, he will be subjected by the Medical Council of India for medical negligence. This is the dictum in section 184. I am reducing. I will reduce and finish. And after this 184, it comes to section 193, laying of charge sheet. Right? Charge sheet will be laid for any sexual offences or POCSO offences within 2 months. Right? Then traveling down, submission of free copies. It is section 230, submission of free copies. Previously, free copies were given only to the accused in the court. Now, as Sir has rightly said, the victim and the accused is placed at an equal plane. The victim should know where the bus is traveling. She will not be kept at darkness as she was kept in the CRPC. Now section 230 says she will be given the copies. She will have the right to protest before the court, as was mandated under Bhagwan Singh versus Commissioner of Police 1985. That this is not the case which I have projected. The charge sheet is not properly made and witnesses are not properly examined. This is what is made in section 230. 232 committal proceedings, there should not be any delay either by the accused or by the victim. Then coming down to 291, 290, 291 and 293. All these are with regard to plea bargaining. The victim will have a say. Accused should bargain with her, and what all the offences omitted in plea bargain is offences for which punishment is more than 7 years are omitted, offences against women and children is omitted, offences socio-economic is also omitted. Then coming down to section 356, morning also it was said it was very, very important, 356 and 360. 356 is proclamation of offender. If an accused chooses not to come to the court of law, like yesterday's, we will not wait for that man to come. We will proclaim him absent, set him ex parte, and the court will proclaim him as an accused. Then coming to section 360. 360 is equally important. Prosecution cannot withdraw the case without knowledge of the victim anymore. Her or his knowledge is very important. The listening to the victim also is very important. Then coming down is 396, 397 and 98. 396 speaks about victim compensation. 397 is treatment of witness, mentally and physically also at all stages. You can read Lakshmi vs. State. Then 398, Mahendra Chawla vs. Union of India. Witnesses Protection Scheme. Unless and until witnesses are protected, whatever the work investigation does and the court does and the prosecution does, it will not see the light of the day. This is 398. Coming to section 404. 404 is copy will be given to the victim now. Previously, accused alone will be given the copy. Now 413 flushes out the right further. The victim can prefer an appeal without permission from the state. Then coming to section 530, which is very, very innovative. That is, a victim need not go to the court. A victim can do all the processes right from registration of FIR till the process of appeal from her mobile phone by way of audio video means. Thank you so much.
Just I will add one important aspect, I think, that is 193, subsection 3, clause 2. That this is much more important, that the police officer shall within a period of 90 days inform the progress of the investigation. Progress of investigation by any means, including through electronic communication to the informant or victim. This is an absolutely new dimension which mandates the report of investigation, so that the victim gets a right whether the investigation is carried out properly or not. So this is, I think, another very important aspect in this regard.
Thank you, Your Lordship, for your intervention. And E. Chandrasekharan ji covered almost all the sections under the BNSS. And I would like to add two things. Actually, as he cited that victim can engage a lawyer. But so far as the role of the lawyer engaged by the victim, that is also limited because the two landmark judgment, number 1, Mallikarjun Kodagali versus State of Karnataka 2018, one of the best judgment on the victim's jurisprudence. Another judgment, Rekha Muraka 2019, where the Supreme Court of India said that the role of the victim's lawyer will be limited only to submit the written submission. It will not be allowed to oral submission. So you covered almost all the aspects. Thank you very much. Now we are coming to our another expert, Neeraj Tiwari, who also did very commendable job in this area, and he was also the part of the committee. And recently he wrote one of the very beautiful article on this content of the legislation. And my question to Dr. Neeraj Tiwari is, with respect to this proclaimed offender, how the BNSS deals with the proclaimed offender, and what do you think about the in absentia trial which has been incorporated for the certain offences under the BNSS, and do you think it will serve as an incentive for the prosecutor and the police officer? They will, without doing hard work, try to start the trial, or it will be successful to serve the purpose of the justice?
Thank you, Professor Asad Malik, for raising this very pertinent issue, because we just had a wonderful presentation on the victim. Now the question has been posed to a right to fair trial, which is available to every accused in a common law jurisdiction, every jurisdiction for that matter. So the question here lies at the very core issue of what if someone is absconding, someone is not turning up for the trial, willfully disobeying all the processes of law, what is supposed to be done? Now, if we look at the CRPC provisions first and try to appreciate what was the challenge before the lawmakers and how that challenge has been responded through Bharatiya Nagarik Suraksha Sanhita. So, right in section 82, subsection 4, the court was empowered to declare any absconder as proclaimed offender. Such proclamation, if you see, can only be passed in 19 offences per se. And what was the approach taken by the lawmakers back then? Was offence-oriented approach, what I say, because these 19 offences were the 19 sections of Indian Penal Code, out of which only 4 offences were touching upon the offences affecting the human body, and 15 offences were from offence against property. No other chapter of Indian Penal Code found a place in this entire setup of declaring any absconder as proclaimed offender. Second and most important reason for giving it the thought what can be done in this domain is section 299. In most of the Hindi belt area, it is known as Ferrari Chalan, where the accused is absconding, process cannot be taken forward. So a chalan is presented in the court, and what I have learned in the morning, that the case is known as adjourned, signed I hear, or temporarily adjourned or closed. So in these two situations, what happens? The case is paused, halted, it is not progressing forward. The witness's examination is done, but for the purpose that as and when accused will please to appear or compelled to appear before the court, then these witnesses' examination testimony will be used. Their deposition can be used in that trial. So this was the scenario in Code of Criminal Procedure 1973. Now coming to Bharatiya Nagarik Suraksha Sanhita 2023. First and foremost change was made in section 84, subsection 4, which is corresponding to section 82 subsection 4 of CRPC. What was the change made? Now if you read that section very beautifully, the specific offense approach has been changed or replaced with sentence or punishment approach. Now any offense of Bharatiya Nyaya Sanhita or under any other law having punishment of 10 years or more, life or death, right there the authority lies with the magistrate to declare any absconder as a proclaimed offender. What it brings, now more than 100 offenses only in Bharatiya Nyaya Sanhita comes within the purview of the jurisdiction of the magistrate to declare any absconder as proclaimed offender. That is one. Now if you move forward to find out what other changes have been made with respect to proclaimed offender, and why it was very important, I tell you, because thousands of offenders, or rather absconders, who have been declared as proclaimed offender, their cases are paused, halted, and they are not moving forward. And in a way, it is against the very justice philosophy, because right here, who is not given justice? The victim, the society, the resources of the state is also wasted. Because of what reason? That the person is not coming before the court. In the case of Hussain versus Union of India, the Honorable Supreme Court has also made this observation that this is high time that we should also think of something in line of in absentia trial. So that is precisely the very food for thought for the lawmakers, I believe, who have come up with 356 as a provision. But what is the second part of your question? I'll come to that with 356. What also came in between, if you just turn the pages of Bharatiya Nagarik Suraksha Sanhita, you will realize, is about section 86, another newly inserted section in Bharatiya Nagarik Suraksha Sanhita. It allows the court to identify and attach the property belonging to proclaimed offender outside India. So now what it does, it is in a way trying to compel, force the proclaimed offender to come and make himself or herself available for trial. So that is the second important change in the form of 86. Coming to the third change, and most pertinent one, of course, for many, is with respect to 356 in absentia trial. How it is drafted, that will always be an interesting part of it. Reason being, that will to a great extent answer the question, is it providing any kind of advantage to the prosecution and the investigating officer, or is it towards the direction of achieving justice for all? And when I say justice for all, I also consider accused as a party seeking justice, though he remains absconding. First and foremost, this process of in absentia trial can be initiated only when 90 days have lapsed from the date on which charges were framed. So 3 months' time will be given to the accused absconder to come appear before the court, knowing that charges have been framed. So it is not that the trial is commenced at once, no. Second, and very important, what we know in one of the chapters of CRPC and also in BNSS, there are multiple processes like summoning and warrant. The same has to be repeated in case of in absentia trial. Now, before proceeding with in absentia trial, the court has to issue 2 warrants in a gap of 30 days minimum. At the same time, information must be given to the accused family or relative that, look, if accused is not turning up, the court shall commence with the trial. Third, publication in the newspaper, daily newspaper, and a national newspaper. And fourth, it has also been pasted in the local police station and the court where the trial is to be started. So these are the first set of safeguards. What are other safeguards in this direction? So now what happens if the accused is not presented by or represented by a lawyer? State takes the duty now to appoint a lawyer for the accused. So it is not an ex parte trial in that sense. State fulfills this obligation to appoint a lawyer for the accused who has remained absconding and now a proclaimed offender. What else? Now, most importantly, if the accused appears any time during the trial, all the witnesses who have been examined, all the evidence which have been taken in the absence of the accused will be given an opportunity to get those witnesses re-examined or the evidence reappreciated in the court of law with the rider in the interest of justice. So all of these safeguards are aimed to provide a balance that victims, society's cry for justice is also addressed, and at the same time, the balance of fair trial is not tilted towards the prosecution or the investigation, but it is balanced so that accused, victim, society, they all achieve the justice which I think has been waited for so long and very well addressed in the new law in the form of 356. Thank you.
Thank you very much, Neeraj. Here, Your Lordship.
Just a caveat here. Whatever you have said is correct. This may reduce the time of litigation. One of our officers are here. One of the reason trials are delayed for awaiting that the person will appear, he will be produced, this, that. Now what will happen in an appeal? Okay, there is a blanket limitation of 3 years. So in case of trial in absentia. Now, how the appellate court will deal against an accused convicted in his absence? That questions, I think, time will answer.
So may I respond to that question, sir?
Yes.
So how this law has been drafted?
Fundamentally, a conviction is in his absence. And our appellate courts and constitutional courts are always saying that it is better to face the trial. So will it not, once again, there is a scope for delay. But of course, the provisions are progressive, no doubt about it. These all time will say with judicial pronouncements.
So just a quick response to Your Lordship's questions and concerns very rightly posed and very rightly answered in the same section 356 in one of the, I think, closing subsections, where it is provided that in case of a conviction, it is not, appeal can't be heard in absentia. So for that, the accused has to, or now the PO who has been convicted has to appear for the appeal, and the threshold which is prescribed is 3 years. So within 3 years, if he comes, he will be eligible to file an appeal against the conviction. If 3 years period lapsed, then of course his right to file an appeal is taken away, and that is not prescribed. So this is what has been prescribed in the law only, sir. Thank you.
Thank you very much. Thanks, Your Lordship, for your intervention. And Dr. Neeraj very beautifully answered this question. As he said, because the fair trial is one of the concepts, as we know that, but it is to be said, the fair trial does not mean only the protection of the rights of the accused, but also the protection of the rights of the accused and the justice to the society. And we are not supposed to wait for the person, as he said in 299, there was the provision of the recording of the evidence in absentia. About now this provision has been incorporated, and now in absentia trial can be conducted. One of the landmark judgment of the Ram Meher versus State of Haryana 2016, where the Supreme Court said that this fair trial is not an absolute concept, and we are not supposed to play in the hand of the prosecutor and the defense counsel. So actually this is not a fair trial is an absolute concept, and it can be waived accordingly. One more thing I would like to add here. As the term under section 84 of the BNSS, class 4 and class 1, proclaimed person and proclaimed offender. But section 356 cover the absconder plus proclaimed offender both. And now I am moving ahead. The next question, this is very important question, and since the morning it was discussed many times, that the question to Shri K.S. Singh. The BNSS is said to be in the line of the Digital India initiative and aims to give the greater importance to the use of the technology and allowing trials via video conferencing, use of the electronic communication. So do we have the sufficient infrastructure, equipment, trained personals, and how is this going to overhaul the criminal justice system? I need your comment.
Yes, thank you very much, Professor. In this regard also, my friend, the e-courts project on the lines of the Digital India, the Supreme Court of India, under the able guidance of the present Chief Justice of India, has insisted upon all the high courts of the country to establish that hybrid model of system And as rightly pointed out by other panelists, that all the trial proceedings are all is out only because of all these victims did not go to the police station for recording her statement, or in the courts also she can always be examined through video conferencing. And every other aspect of 105, videography of search and seizure, then forensic investigation of 7 years and above, audio video recording of search without warrant under 185, and such other provisions of the Act, the new Act, will definitely enhance the mode of this thing, justice delivery system, and it is making more easier. And in that regard also, I mean, I speak some of our initiatives taken in our small High Court of Manipur, and under the aegis of the Supreme Court E-Court Committee. Our High Court has completely transitioned to the hybrid mode from June 2023. And that upgradation was possible with the necessary financial assistance from the High Court funds, that is the government and the Department of Justice and the Ministry of Law. Then the district courts, we have 41 district courts, out of which we have completed 34 hardware installations for the hybrid mode of these hearings. And in view of the present turmoil, some other people cannot go to every court which is stationed at some other areas where they cannot go. So this hybrid mode of system had really helped in making them more easier, and there was no hiccups or problem for them to appear before the court, and we could not think of such thing without this assistance from the DOJ also. And in this manner, the implementation of the e-filing system in the high courts, it was done since 2022 November, and making it more mandatory since 2024 March this year. So that way, I mean, we have been using this technology to ease out the system entirely. So this will definitely help the system to come up to that position, and that really. Yeah.
Thank you very much. Actually, this is one of the best initiative of the government of India, particularly incorporating this provision. As we know, in India, the first case when this video evidence through the video conferencing was allowed in 2003, in the case of the Prafulla Kumar versus State of Maharashtra, it was the first judgment when this evidence of the witness was recorded through the video conferencing. As we know that Swapnil Tripathi versus Union of India 2018 judgment, which allowed the live streaming of the Supreme Court judgment. And this use of technology as per the section 530 of the BNSS, which clearly said that in the investigation, inquiry and trial, in all these three stages, the use of the technology will really be helpful when we'll see section 105 of the BNSS, which talks about the search and seizure. When it's going on, then it should be recorded. And the section 2 class A or section 2 class I, audio video, that is defined, and electronic communication, which is also defined. And issuing the summon, warrant, summon for production of document, recording of the evidence, recording of the witness statement, everything now will be allowed through the electronic communication or video audio recording, and EFIR also one of the initiative. So actually this is very good initiative, and the provision which have been incorporated in BNSS, particularly use of the technology, will be really fruitful in future. Now I ask the second question to Shri E. Chandrasekharan. Actually this is the question related to remand. As all we know that after the arrest, the person can be should be produced within 24 hours before the magistrate. And if the police want the custody, then they have to produce the magistrate and the order of the remand to be passed. Earlier it was the section 167, now it is 187. And according to the Anupama Kulkarni judgment, or many more judgments, the court said the police custody cannot be beyond 15 days. But under section 187 of the BNSS, the detention can be beyond the 15, means the police custody can be beyond 15 days. You don't think that it will undermine the right to life and the personal liberty guaranteed under Article 21 of the Constitution? How can we make a balance between the rights of the accused and the power of the investigating agencies? And be specific.
Yes. Firstly, any right without a corresponding duty will become anarchical. This is the basic of all fundamental laws. Even section 19, which we think that there are so many rights embedded in that, in 19.1 subsection A to G, 19.2 it provides for various reasonable restrictions. This is point 1. Then, as is rightly believed in Article 21 of the Constitution of India, what Article 21 says? No person shall be deprived of his right to life and personal liberty except in accordance with procedure established by law. You remove that word no and except, it will come like that. Every person's right to life and personal liberty shall be deprived in accordance with the procedure established with law, by law. So this is a democratic country where the country should follow strict laws in order to protect the human rights. Any man who claims that his rights are more than the other person, then it will lose its very fragrance of democracy. Section 167 of CRPC is almost pari materia with 187 of BNSS. What does section 167 says? 167 speaks of remand and also filing of charge sheet. Two things. Remand is of two types. One is police, remand in police custody and remand in judicial custody. And coming to the next part, the charge sheet part is, investigating agency is expected to file a charge sheet within 90 days if the offense is punishable for death, life, or for any offense for which minimum punishment is more than 10 years. Lesser than those offenses, investigating agency shall file a charge sheet within 60 days. Failure to do so will warrant a bail called as default bail or statutory bail. This is one part of it. If you want to read two judgments on that, it is Rakesh Kumar Pal versus State of Assam, 2017 full bench, Kasi versus State, 2021, Supreme Court, all Supreme Court judgments, where my lords, the Honorable Supreme Court Judge have said, on the expiry of the 60th or 90 days, an indefeasible right falls on the accused for moving a bail application under the default clause. This is one thing. Coming to the question is, it is believed that under section 167 of CRPC, the police custody period is or was 15 days, because it is going to become was by 1st July 2024. Right. I will take you for a moment a bit to the judicial imprimatur that was given to that. It all started in the state of Delhi administration versus Dharampal in 1981. The High Court of Delhi has held that under section 167 CRPC, police custody should not be given beyond a period of 15 days. Okay. Digressing for a moment and going to Article 22 and section 57 and 58 of CRPC, jointly read it says, a man should not be kept in police custody over and above 24 hours. He should be produced either before an executive magistrate or a judicial magistrate, who will pass further orders. Right? It is commonly believed that police custody under section 167 is only for 15 days because of the judgment of Delhi administration versus Dharampal. This judgment was given a stamping by the Honorable Supreme Court in Chaganti Satyanarayana versus State of AP, 1986. So the Supreme Court has declared whatever the Supreme Court says is the law of the land. As per Article 141, the Supreme Court has said police custody should only be period of 15 days. Then came the famous judgment of CBI versus Anupam Kulkarni. All law students will be knowing that. In 1992, two judges bench, speaking for the bench, Honorable My Lord Justice Natarajan, he also proclaimed, the Supreme Court held that police custody should not be given beyond a period of 15 days. This was followed by the Honorable Supreme Court in Kwasnapur Ram Reddy versus State of AP in 1992. What has happened in the year 2000? It received a further confirmation by a full bench in Budh Singh versus State of Punjab, 2000. A full bench said, whatever is said in Anupam Kulkarni, that police custody is not beyond a period of 15 days, is proper. Then came the judgment of Devendra Kumar versus State of Haryana in 2010. All these judgments starting from Dharampal till Devendra Kumar, univocally the Honorable Supreme Court has laid down that police custody should not be period of more than 15 days. The death knell to all these came in the case of CBI versus Vikas Mishra alias CBI versus Vikas Mishra alias Vikas Mishra. This happened on 10/4/2023. The Honorable Supreme Court doubted the law laid down by all these judgments and said the proper interpretation should be otherwise. Police custody should not be restricted for a period of first 15 days from the date of remand. Then once again what has happened in the month of November, I think it is 10/11/2023, V. Senthil Balaji versus State represented by Deputy Director ED, Enforcement Directorate. Two honorable judges of the Honorable Supreme Court have referred it to the larger bench, apart from giving a finding that police custody mandated for the period of 15 days in CBI versus Anupam Kulkarni may not be the proper law, and what should be the time where police can take custody? My lords, in Senthil Balaji says, it should be for the whole 60 days or whole 90 days. Now what is the law under 187? 187 is a balance of Anupam Kulkarni and Senthil Balaji. Now 187, the law of BNSS says, if the period of, if the police custody can be given within the first 40 days, for offences in which charge sheet has to be filed within 60 days. And police custody can be given in the entire period of 60 days if offences has to be charge sheeted within 90 days. So the present law BNSS is a balance of Anupam Kulkarni, CBI versus Anupam Kulkarni, where we all believe that the police custody shall not be given more than the first, it should be given only within the first 15 days. Now the BNSS has taken the mid path, and I feel that right of the accused and the duty of the investigation to bring out a culprit to the light, therefore doing justice to the victim, is always justiciable, and accused need not worry that police will trouble him, because any offering of police custody, ordering of police custody is done only by a judicial process. We all believe in the judicial system. Judiciary will definitely take care of that. Thank you so much.
Thank you. Yes, Your Lordship.
Just want to add one thing. Generally, when a ratio is holding the field, that may be doubted in subsequent benches, but that will not be a ratio. So it will not be a balance between this and that, because that will be a comment until and unless that judgment is reversed. So I think that cannot be a balance, to make a balance between the earlier judgment and subsequent. Subsequent is not a ratio, it is a comment. First. Second thing is that, in my view, that 15 days and giving beyond 15 days, I think there should have been certain qualifications. as Honorable Law Minister has yesterday expressed that we should also give the suggestions. This can be suggestions that when it's stringent, provision is stringent, and law of the land is that it should not be. Then when the legislature in its wisdom thinks that it should be given, that should have been some qualification that under these circumstances, this can be granted. However, the judiciary definitely will take care of any difficulties that is being faced by the citizens or any misuse of that.
Thank you very much.
Would
you like to add?
Yes,
Yes,
if I am
please.
allowed to add few comments. First and foremost, what needs to be clarified and very well explained in a very lucid manner about the period of custody. So what is to be appreciated by all law enforcement agencies, officers sitting here, it is not that the 15 days threshold has been increased to 40 or 60 days. What has been increased is the threshold of the number of days till which you can seek police custody. So police custody has not been increased from 15 days to 40 or 60 days. It is that till 40th and 60th day, you can seek police custody from the magistrate, and the magistrate cannot give police custody for more than 15 days in the whole. And within that also, the magistrate enjoys discretion, because the terms like in such custody from time to time, earlier in 167, has been retained in 187. Second clarification, if I am allowed to make that, Rakesh Kumar Paul versus State of Assam, a 3-judge bench ruling of the Supreme Court, which has interpreted the law that the offense where the punishment is extendable up to 10 years, the total period of custody shall be 60 days and not 90 days. That stands corrected in the new law. Now the new law makes a change, overruling the observation made in Rakesh Kumar Paul case. Now all the cases where the offense is punishable with 10 years or more, the total period of custody is 90 days and not 60 days. Third important change, because this is very much important for you to know, house arrest, which has come from Gautam Nalokha versus NIA case by the Honorable Supreme Court, has also been clarified in the new law. Now 187 makes it very clear that if a person is given to police custody, he will remain in police station. In judicial custody, he will remain in prison or any other place which has been designated as prison by the state or the central government. So that house arrest conundrum started with Gautam Nalokha case has also been put at rest by the new law. Thank you.
Thank you very much.
That is, one second. That is in 187 subsection 5, explanation 2, proviso 4. That in India there are only 2 custodies, one in police custody, another in judicial custody in prison, not in the house.
Okay, thank you very much. Actually, as panelists said that the total period will remain 15 days. It is not going to be extended, but only because of the misuse, as Vikas Mishra case he cited. What happened in this case, the person admitted in the hospital and the time is over and the people want to get the benefit. So that's why this judgment of the Vikas Mishra, where your lordship said this was the suggestion given by the Supreme Court of India, there is a need to reconsider the Anupama Kulkarni. However, now it has been incorporated in the BNSS by the legislature. Now the next question to Dr. Neeraj Tiwari, and he will expand this particular topic we were discussing because it is directly linked with this 15 days custody to bail. And my question is, do you think that this the bail jurisprudence means the changes in the bail jurisprudence under the BNSS, and how can it be beneficial to the accused, number one? Number two, as we are facing the problem of the overcrowded prisons, so then you have to make a balance between these two things, whether these new provisions will be helpful to reduce the number of the prisoners in the jail, number one. Number two, that this right of the accused, because bail is a rule and jail is an exception. So to what extent this Suraksha Sanhita is going to justify it?
So taking the discussion forward from the earlier question on police custody, one of the important changes which has been made in the Bharatiya Nagarik Suraksha Sanhita is in section 480, which is corresponding to section 437 of the CRPC. What pertinent change which has come and can be appreciated by everyone sitting in this hall is that the law provides that police custody alone shall not be a ground for denying bail of an accused person after the expiry of first 15 days. So if the first 15 days has expired, accused has moved a bail application, the prosecution cannot oppose the bail application simply on the ground that they are still having 25 days out of 40 days, and out of 60 days, I think it will come out 45 days of seeking police custody. So that will itself not be a ground for denying bail. That is a very important provision. Why? Because it balances the personal liberty guaranteed to every individual by the Constitution, and also effective and efficient investigation, which is again a prerogative of the state. So this is one I start with in the direction of reforms in bail laws. Second and most important reform which can be highlighted is with respect to defining the very term bail, bail bond, and bond. This was not done back then in 1973. It was not done when the earlier code of 1898 was there. But what has it led to? Those who have read the case of Motiram versus State of MP would appreciate that how Justice Krishna Iyer has highlighted one of the anomaly presented in the code with respect to bailable and non-bailable offense. For both the offenses, the term bail is used in CRPC. Justice Iyer was like, for petty offenses, less serious offenses, the threshold is same as of bail, which is there for non-bailable offense. So he interpreted to mean bail means release on personal bond with or without surety. Why he had to do that? Because Chapter 33 of CRPC on bail and bond uses multiple expressions at different places and not leading to any one uniform conclusion, but creating a lot of confusions. And that has been rectified in this law. The term bail, bail bond, and bond, they have been defined in Section 2. Also, they have been replicated and used at many places, including the Chapter 33 of CRPC, which is now a new chapter in the Bharatiya Nagarik Suraksha Sanhita. That is one. Second is with respect to pre-trial detention. And we all know why this problem of detention comes, because of arrest. Now, a part of it has already been answered by the Honorable Supreme Court in Anesh Kumar versus State of Bihar back then in 2014. A beautifully written judgment by the former judge, Justice Chandramouli K. Prasad, where he has said that 7 years and less than 7 years, checklist has to be followed, and the principle is not to arrest, but to serve a notice to the person. In Satyendra Kumar Antil versus CBI, this was further strengthened by saying that non-compliance of Anesh Kumar direction or 41 and 41A of CRPC will result in bail to the accused person. So that has been kept intact in the Bharatiya Nagarik Suraksha Sanhita. Earlier Section 41A on the notice is now 35 subsection 3. So that can be, I think, remembered by the law enforcement agencies that the Section 41A has not been deleted. It is part of the new law in Section 35 subsection 3. What other changes have been made to reduce the chances of arrest or number of arrests? Because once a person is arrested, then only the under trial problem comes. Second amendment has been made in Section 170 of CRPC, which is now 190 of the BNSS, which required earlier that if the police officer is going to file the challan, charge sheet, the person needs to be taken in custody. And many a times it has been experienced that the magistrate refuses to consider or accept the charge sheet if the accused is not taken in custody. In 2021, Honorable Supreme Court in Siddharth versus State of UP has already responded to this issue and concern by saying that if a person has not been arrested and those who have been served 41 in notice should not be arrested simply for the reason that police is going to file a charge sheet. Now with the proviso added to Section 190, this has been brought to the black letters of the law, so that is also preventing on the chances of arrest. Third, morning we have referred that section for 311 capital A, which is now 349, which talks about taking of specimen signature and handwriting. It required the person has to be arrested at some point of time. Now that was one of the mandatory requirement of the law. That has also been now diluted, and the discretion is vested on the magistrate. Even without getting that person arrested, the magistrate can allow for such specimen signature or handwriting sample. So these are some of the efforts made to reduce the chances of arrest Adding to this, one more is there which provides for partial restriction on the power of arrest of the police officer, wherein in section 35 only, if a person has committed any offense punishable with less than 3 years, and the age of the person is 60 or above, or he is an infirm, the police officer cannot arrest the person straight away, but has to seek prior permission of DYSP rank officer. So this is a partial restriction on the power of arrest. Coming to the bail issue now. So one I think very important change which I have already explained with respect to the defining the term bail, bail bond and bond, followed by the problem of under trials. Now one of the sections of CRPC 436 capital A, which was inserted back in 2005, and now it has been replaced with, in the new Sanhita, 479. 479 makes a very drastic change in the entire under trial detention problem. It allows the first time offenders to be released after completion of 1/3 period. So now existing provision is requiring half of the total term of punishment to be served by the under trial before being released on bail. For first time under trials, this period has been reduced from half to 1/3. So for a case of theft, suppose, where the punishment is up to 3 years, for others, the period should be 18 months before they can be released on bail. For a first time under trial, it is reduced to 12 months. So that is one of the changes in the law towards the decongestion of prisons, overpopulated prisons, how they can be decongested. So that is one. Second, how this right will be then enforced. The same provision makes the jail superintendent responsible for making the application of bail for all those who have been eligible for that after completion of 1/3 period or half of the period of detention. That is again a very great, I think, and significant contribution of the present Sanhita towards the direction of restoring the personal liberty at the earliest possible time. What else has been changed? One section was added in the form of 437 capital A, which required bail from an acquitted person. So a person who has been acquitted, he has to furnish a bail before he can be released from jail. Reason being, what if a state files an appeal where the state will go and find that person, so bind that person with a bail, and what is the nature of that bail? Surety bail. So a person who has been released, rather acquitted by the court, can't be released from prison because he has no means to arrange a surety. And that was the law, or that is the law till 30th June. From 1st July, the law says that it is a discretion of the police, the court, to release that person on bail bond or on his personal bond. So that is also another way of seeing how the new law is moving towards the direction of restoring the personal liberty, protecting the personal liberty, and also upholding the constitutional vision enshrined in Article 21 of the Constitution. Thank you.
Thank you very much, Neeraj, for citing the different judgment of the Supreme Court and the relevant provision of the BNSS. Actually, there is misconception that arrest is mandatory. As the section 35 used the term may, or section 41 also the term may. Even the case of murder or whatever the nature of, this is the discretionary power available to the police. And one of the landmark judgment delivered by the Supreme Court in 2014 with respect to the under trial prisoners, Bhim Singh versus Union of India. And this case, and when you will see, as Neeraj cited, this provision has been added the duty of the jail superintendent. In this judgment, Justice Lodha, that he issued the guidelines, it is the responsibility of the judges to visit the prison and the list to be prepared by the prison authorities, and that should be produced before the judge so that these people can be released on bail. वो कहते नहीं है, एक शेर था कि आपकी नजरों में सूरज की है कितनी असमत, हम चरागों का भी उतना ही अदब करते हैं. So these are the poor people, those are languishing in jail for the long period of time. So they are also having the right. So keeping in view the rights of these prisoners, these provisions has been incorporated. Now that is, we have only 30 minutes, and because at 5 the valedictory session will be commenced. So my request to my panelists that please, the third question which I am posing, that give it answer in brief. And my question to K.S. Singh sir, that is related to, in the morning session, that discussion was with respect to the community service. And I am also asking the same question with respect to the power of the magistrate under section 23 of the BNSS, that the magistrate of the first class and the second class may pass the sentence of the community service. So my question is that what is the significance of the community service sentencing in Indian criminal justice system?
Yes, thank you. Community service being an alternate to the incarceration, and it is also related to my friend Tiwari's, Neeraj Tiwari's subject of decongestion of jail. It is correlated. So for small petty offenses, many offenders are languishing in jails for years together. So this is a means where initially mooted by the Supreme Court in Babu Singh's case in 1978, that we should search for some alternative form of punishment. So that has culminated to this particular provision contained in kept in this new acts, and it acts as a form of punishment. This is an alternate to incarceration, and for unnecessary and petty offenses, we should not make the people to languish in jails. So in that regard, as my friend moderators has already said, like this is the judicial magistrate of first class and second class who can really order community service as a form of punishment. So for the time being, community services are confined to only 6 forms of offenses or conditions. That is under 202, that public servants involving illegal trade. Then under 209, non-compliance and proclamation. Then 226, attempt to commit suicide to influence a legal authority. So then 3032, then the type of property valued of less than 5,000. And the 355, public misconduct by a drunken person. And the 356, defamation. For the time being, this community service kind of a punishment can be ordered in 6 conditions. So this is a form of punishment which is aimed at restorative kind of a justice system. So there is a very good inclusion in these new acts.
Thank you very much. Actually, as he cited that there are a number of the provision specific offenses when the community service as a sentence can be passed by the magistrate. As we know, initially the theories of the punishment, there were 5 theories of the punishment. Expiation theory, which was based on the religion. माफ करने वाला बड़ा होता है पाप करने वाले से. वो कहते नहीं मैं अपने दिल को जहन के खिलाफ कर देता, मैं अपने दिल को जहन के खिलाफ कर देता, वो सर झुका के जो आता तो मैं उसे माफ कर देता. So this is the expiation theory based, and then preventive theory, deterrent theory, punitive or reformative. So basically this community service as one of the last theory, reformative, and it is one of the example of the restorative justice. Already we are having some other laws like the Probation Offenders Act, and as we know that man is social animal, so it is expected the people when come and mix with the society, there is a possibility of the reform. Once the person who committed the crime, it does not mean throughout life the person suffer. So because of that reason, this community service as a punishment has been incorporated in the BNSS. I think this will be a good move. Now the next question with respect to this adjournment. सब जानते होंगे वो एक फिल्म थी कि मिलती है तो सिर्फ तारीख. So my question is that actually unwarranted adjournment affect the criminal trials and resulting injustice to the victim. How do BNSS address this issue?
Yes. Section 309 of CRPC is pari materia with Section 346 of BNSS. Before explaining, I will ask you one question. When we were in childhood, a brother beats a sister. Sister who receives the beating will go and complain to the father that she has bitten me. If father says we will see this issue next year, will the sister have confidence in the father? Like that, there is an inherent craving in every human being to see the result. A victim who has sustained an assault from the accused will definitely want to see the result. But what happens in reality in court is, Section 309 provides for adjournment. It has got powerful engine without brake. 309 doesn't have a teeth. That is, it does not have a time limit in that. So what has happened is that Supreme Court has made far-reaching cries through various judgments to enforce 309 CRPC. There are some 5 to 6 judgments which law college friends may note it. It is in Talab Haji Hussain versus Madhukar Purushottam, 1958. Supreme Court said, a concomitant of fair trial, there should not be any dilatory tactics from the accused. Then comes the judgment of Raj Dio Sharma versus State of Bihar, 1998, Roman 1. What does Supreme Court says in that? It reminded all the high courts that there is one provision called as Section 309, whereby the prosecution can be controlled and the accused can also be controlled. How prosecution can be controlled? You impose fine on the witnesses who doesn't come. How accused can be controlled? You remand the accused to custody once again and he will get along with the trial. This Rajdio Sharma was given once again an explanation by the Honorable Supreme Court in 1999 once again. Swaran Singh was a state of Punjab in 2000 also just said adjournments will kill criminal justice. After Swaran Singh is the famous case of state of UP versus Shambhunath Singh, 2001. Then Gurnaib Singh is a state of Punjab. Then another one famous cases, Surya Baksh Singh was a state of UP. Then Vinod Kumar was a state of Punjab, is a famous judgment. Supreme Court went up to the extent of telling that when a man is examined in chief witness, the accused is not cross-examining. Why? He will wait for some time, go and do some bargaining with him, win over him, then after a year he will cross-examine. Supreme Court said, if an accused is won over by cross-examination and he has deposed in chief, that cross-examination can be done away, chief should be relied and court should convict. So to fight the adjournment trick of the defense and the accused, the Supreme Court has designed so many designs, and having failed in that almost, it has made another one mechanism like pre-trial conference. I do not know how many of you are aware. Law students may not be aware. Other dignitaries will be aware of that. Pre-trial conference. What it is, Supreme Court said, you make a calendar. The accused counsel, prosecution, the complainant and the judges, you make a pre-trial conference. This was laid down by the Honorable Supreme Court in Mallikarjuna Kodahalli versus State of Karnataka in 2018, followed by State of Kerala versus Rashid. Then two other important judgments where Supreme Court said calendar should come, time frame should come, because 346 ultimately has prescribed time frame. In two other judgments, it is as in reassessment of criminal justice system in response to sexual offences, 2019. Another 2021 is in for issuance of certain guidelines with regard to inadequacies and deficiencies in criminal trial as a state of UP 2021. So all these judgments have culminated into 346 subsection 2 fourth proviso, which says whatever the reason be, court should not grant adjournment beyond 2 times. Okay? So now the present 346 has got effective teeth and break. So advocates like me on the defense side, it will be very difficult to prolong the trial. Thank you so much.
Thank you very much. Yeah, your last.
So now a huge responsibility for the judicial officers in a lighter sense, so that the filmmakers will not be able to satire on us that Tariq fe Tariq.
Yes, thank you very much. Actually, as the Supreme Court of India take the initiative in the case of the Imtiaz Hussain versus State of Uttar Pradesh, 2012 and then 2017, when the court suggested the national court management system. And then thereafter, you know that national judicial data grid, which is available to keep a check on this particular pendency of the cases, and adjournment was one of the reasons. And we know that the 3 basic considerations were kept in mind at the time of the formulation of the old CRPC, which is still kept in mind by this legislature. Number 1, the fair trial. Number 2, that is the speedy justice. Or number 3, fairer deal to the poorer section of the society, that is the legal aid. So the next question or the last question to Dr. Neeraj Tiwari with respect to the very good changes in the BNSS. So do you think that this timeline which have been prescribed under the BNSS for the purpose of the investigation, inquiry and trial, and how it will result the speedy justice?
Answering this question on timeline, so first let's understand where these timelines have been prescribed. And it's like 45 places in the new Sanhita, Bharatiya Nagarik Suraksha Sanhita, where you'll find that timeline has been prescribed. Now, as my previous speaker has already said about the teeth, not having teeth in the adjournment provision, then it also required teeth to somehow make it possible that timelines are being adhered to by different functionaries, agencies of criminal justice administration. How that has been achieved? And that has been achieved by introducing electronic means, audio, video, electronic means in 39 provisions. So 45 places you'll find timelines, 39 places you'll find that audio, video, electronic means have been used. What does it mean actually? Let me explain a bit on this. Now, a charge sheet can be filed to the court in an electronic form. That is one. The same charge sheet is good enough for the magistrate to take cognizance. Third, it is also prescribed in the law that the magistrate can supply the documents, earlier 207 of CRPC, now 230 of Bharatiya Nagarik Suraksha Sanhita, allows the magistrate to provide the supply of copies to accused in electronic form. And this, it has led to now, what is the number of days fixed for supply of copies? 14 days. Within 14 days, from the date of appearance, the magistrate has to supply the copies to the accused, which has already been submitted, supplied in electronic form by the police, on which the cognizance has been taken. Similarly, once it is done, what comes next? The process of committal, if the case is triable court of session. The timeline is 90 days, extendable up to 180 days. Not more than 6 months time is prescribed for committing the case to the court of session. Once this process is also over, then comes the process of moving discharge application and also framing of charge. For both the processes or stages, 60 days timeline has been prescribed in law, and this 60 days timeline has been prescribed qua all accused, and accused cannot take benefit of, if there are multiple accused in one case, moving the discharge application one after another, delaying the process of law. No, not allowed now under the new law. Then moving forward, what is prescribed within the timeline is pronouncement of judgment within 30 days and extendable up to 45 days. Uploading of the judgment on the e-portal of the court, 7 days after the judgment has been pronounced. So these are the timelines which has been prescribed towards speedy justice consideration. Now this has been achieved by also providing AV mode, that is audio video electronic means mode, to make it realistic, and it will happen. I'm very confident on this. It may take some time because the courts are to be equipped with electronic means. And just to apprise you, in the state of Madhya Pradesh, Khandwa is the first district court which has completely gone on electronic mode, and it has become a first court, paperless court in the country. So we are moving in that direction, where one day all the courts in the country will become the paperless court. So I think I'm very sure that through this, speedy justice can be achieved by these timelines, also coupled with audio video electronic means in the process of summoning, service of summoning, issuing of summoning, also supplying of copies, and otherwise extended to various processes and stages. Thank you.
Thank you very much. From the registration of the FIR till the pronouncement of judgment, or even uploading the copy of the judgment under section 392, everywhere the timeline has been fixed. Now, with the permission of your lordship, I will invite the question. Before inviting the question, I have to invite Justice Mr. Mir Alfaz Ali. He wants to say something. Please.
I have a little bit confusion with regards to section 187. Two of the learned panel member has said that the duration of the police remand is 15 days and magistrate has no power to pass a police remand beyond the duration of 15 days. See, there are two aspects. One is, earlier the CRPC was very clear that the police, after the first remand, there can be a further remand, but no police remand, because not being in police custody. So there was a express bar on the power of the magistrate with regard to the duration of the police remand, that magistrate cannot pass a remand for a police remand beyond the 15 days, right? And all these debates and deliberations going on, this Balaji, Kulkarni and all these things, all these debates are based on the CRPC 167. 167 CRPC, one thing is clear, the magistrate's power for police custody, duration of police custody is 15 days, not beyond. He cannot give 16 days. The another thing which has been doubted, that the police custody should be given during the first 15 days, not beyond. So that has been deliberated. Why during the first 15 days? Why not, suppose in the first 15 days, 7 days has been given, after during the second or third remand, the police comes and finds that further remand is necessary, why he will not be given? That are the debated upon. Now, coming to section 187, I am reading these provisions. Whenever any person, subsection 2, the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, these are all same, after taking into consideration, etc., etc., bail has been cancelled, etc., authorize, from here important, authorize from time to time the detention of the accused in such custody as such magistrate thinks. This is very important. The power of the magistrate is, it is the discretion of the magistrate with such custody. So by my understanding, it may be police custody, it may be judicial custody. Then goes on, such custody for a term not exceeding 15 days in the whole or in part at any time during the initial 40 days or 60 days, as the case may be. So if we can mean that during first 40 days or 60 days, as the case may be, the power is open to the magistrate either to grant police custody or judicial custody. Nowhere it says that police custody duration cannot be more than 15 days. Now come to subsection 3, which is the proviso of the CRPC. The magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate ground exists for so and so. Now see, please remember the proviso of 167. It says, the language was, magistrate may authorize the detention of the accused person beyond the period of 15 days not being in police custody. So there was an express bar put by the legislation that the duration of the police custody of the magistrate cannot be more than 15 days. But I do not find anything in this new 87 that the power of the magistrate is restricted to 15 days. So that I just want a clarification from the panel members, learned panel. You have said that the magistrate magistrate power is 15 days, not beyond. Just a clarification, because I have a doubt on this section.
Yes, my lords is right in that. The question was exactly that which was asked by the chair. And what I have answered also is, I said that the law laid down in Anupam Kulkarni, CBI versus Anupam Kulkarni, starting from state of Delhi administration, Dharampal Singh versus all these judgments, it was believed by us that, because my lords have also read section 167, where there is an express bar that police custody cannot be given more than 15 days. However, I have cited two judgments of the Honorable Supreme Court, one in CBI versus Vikas Mishra and another in Sendil Balaji. They have doubted, and in the concluding para of V. Sendil Balaji, they have summed up like this, that investigation period under CRPC 1988, sorry, it is 1898, investigation period was only 15 days. This was stated in Sandil Balaji. My Lords of the Honorable Supreme Court, speaking for the bench, Honorable Justice M.M. Sundaresh, along with Sanjay Kishan Kaul, my Lords, they have summed up it like this, that the interpretation of Anupam Kulkarni is itself wrong in giving the police custody for first 15 days, and they have just said that it should be extendable up to 60 days or 90 days. In the present code also, 187 subsection 3 says, magistrate may grant police custody beyond a period of 15 days. That is the reason, while summing up, I said the present BNSS and the interpretations of 167 along with all CBI versus Anupam Kulkarni, a balance was struck down here, because here at least in BNSS it is said it is for 40 days. The word used is beyond 15 days, and the upper limit is 40 days if the charge sheet has to be filed within 60. And if the charge sheet has to be filed within 90 days, then the upper limit is beyond 15 up to 60 days. This is also what my understanding is. And we will wait for some judicial interpretations in this. Thank you.
Yes, Your Lordship.
Yes, my Lords.
The first period, magistrate grants a police remand for 15 days, right?
Yes, my Lords.
And during the second part, again police come with an applications. Yes, give us 10 days police custody. Now this law does not put up express cap of 15 days. If the magistrate grant again a 15 days custody, meaning thereby 30 days, will it be illegal under this law?
187, in the teeth of 187.3, it may not be legal.
That is what I am saying. So therefore, all these judgments we are referring, if this law remains as such, because the sections are not parameteria.
Yes.
The Parliament has taken cognizance of
all the judgments. Yes,
and made this law.
Yes, my Lords.
These judgments may or may not be binding, I tell you.
Yes.
Because if both these sections are parameteria, no sense, of course will be binding. But when the sections does not remain parameteria,
yes,
there are radical changes, then these judgments, whatever the decisions come in the larger ones even, this referral judgment, that also may not be binding.
Yes, may not suit
so
for
that,
this.
That is my anxiety is that if now a magistrate goes on granting police remand, first 15 days, second 15 days, third 15 days, and up to 40 days, right, or 60 days, that will be legal under this act. That will not be illegal, because statutorily that is not barred.
Yes.
So that because we are saying all these protections, right, protection of the citizens, the right of the citizens, does it come with, in consonance with the constitutional principle?
May I draw my Lord's kind attention to the chair?
that is my anxiety.
Yes.
So my suggestions, the authority to consider whether these sections require some reconsiderations.
That is what anxiety I have expressed, because it gives a power beyond, not only beyond 15 days, maybe in staggered manner or even in continuation till the search sheet is filed, 60 days. So therefore, if this stringent power is given by the legislature, then there should have been some qualification or conditions of granting such, even if, because the law is well settled in the meantime. And so far coming to the subsequent judgment, if that matter is referred to a larger bench, now larger bench, which in my considered opinion, will have to take cognizance of the change in law. Otherwise, this will be an unnecessary exercise of exercise. So that was the view I have expressed also, that this is a stringent provision. Magistrate is given power up to 40 days.
Good evening. Good evening, Your Lordship, our revered panelists here and our esteemed participants today. My name is Pooja Sharma and I am a judicial magistrate currently posted in Kamrup Metro. My question today addresses a cloud of confusion that I have over the new BNS regarding section 223 and 225, which talks about examination of complainant and postponement of issue of process. One is the pre-cognizance stage and the other is the post-cognizance stage that we already know. The question here is that in that section 223, I would like to draw your kind attention there. In Proviso 1, which speaks about that provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, my question here is that, let us assume that the accused is someone who is not from this place. Let us say he's from Bihar. And I've sent him a notice to come over and I listen to him, I give him an opportunity and I take cognizance. Now, regarding postponement of issue of process, now the question here is that which speaks that if I draw your attention to sentence number 3, which says that a magistrate shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused. Now, the accused has already been called for. I have listened to him. I've taken cognizance. And after hearing him, I take cognizance, calling him from a place, let us say Bihar, as I have already mentioned. And then I postpone the issue of process, postpone the issue of summons because he's living in somewhere else. So what is the necessity of postponing again when he has already come before, he has given his statement, whatever he has to say. And then postponing the process just because I have to issue a summon, I make an inquiry or make an investigation to be, I order an investigation to be made. So my confusion here is that, what is the necessity of this provision again? Where there is already that I hear him first, and then again I for issuing of process, I delay it because he's living somewhere else, and then make an inquiry again.
Thank you.
So if you read the proviso, actually the proviso now makes it a mandatory duty in all the cases which have been initiated in complaint mode. It now directs the magistrate not to proceed with the case unless the opportunity is given to the accused to be heard. Now this may be seen in two ways. One, it protects the right of the individual against any false or frivolous litigation which may be emerged out of the process of law, which is complaint procedure. Second, it may also be seen as delaying the process because now here the accused is heard first and then cognizance is to be taken, which was earlier 204 after issuance of process actually, which was there after the taking of cognizance. Because the wording of 204 was the magistrate taking the cognizance. Then the process issued. So right here, if you see that the conflict between the section 223 proviso and subsection 2, right there where the process to be postponed because the accused person resides outside your jurisdiction. Now the proviso itself makes it very clear that in all cases you have to serve a notice to the accused for the purpose of hearing. And I think the earlier provision, which only demanded you to postpone the issue of process, gets subsumed in the proviso itself, which is now part of the first provision. And I think the cases will not be then taken to the second provision, where the process to be postponed for that very specific reason. So whether the accused resides within your jurisdiction or outside your jurisdiction, what is the law, the new law prescribes, what we can see, is that every accused has a right to be heard and notice to be served on that accused.
Subject to what the other panelist says, say a case is to, or it is to be first, the complaint is to file under 212, isn't it? It is to be under 212. Look into 212. Now, when a complaint is made under 212, and now she is referring to 223 and 24, because her question is that what will happen if it is 225. So when an application under 212 is filed, here word is any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance. So he receives a complaint authorized to take cognizance and finds that the accused is residing at a place beyond the area in which exercise of jurisdiction postponed the issue of process. So stages are two stages are different. And other is, it's a general proposition where it says a magistrate having jurisdiction while taking cognizance. One is when an application is filed, you are authorized to do take cognizance, and you will have to do when it is outside. And when it is you take cognizance, what should be the procedure? Yes, you want to say something?
In the CRPC, which is going to be old, it was said magistrate taking cognizance in 200 CRPC. And 204 is when there is sufficient material. 204 is common for GR case, there is a police report case as well as the complaint case. And now the alternate provision, similar provision has been made. What Madam Sharma has emphasized is that we issue a notice to an accused, because we cannot issue summons to her. Law says that we have to hear the accused, provide him an opportunity of being heard. So we issue a notice to the prospective accused or suspect. He comes, we hear him, we are satisfied as court of law, no, there is sufficient material. So why we should again adjourn the process? Why fix another date, then re-summon him? That is the question that she was asking. That is perhaps the question, no, Pooja?
Yes, sir. Exactly that question, that why do we need to delay the process
once he has
again?
appeared, you have satisfied that we can proceed immediately on that day only. Yes.
May I say?
No, because it mandates it. Earlier provision also was also
Yes,
clear.
Lordship,
When it is outside, it will be different.
Yes,
so what you will have to do? To make an inquiry on herself or through something. So after that, there will be two situations. One is accused resides within, then notice for hearing and all. When accused resides outside, then the procedure under 220.
Yes, madam. That's why, my lord, I agree.
Actually, as you are asking, if you will see that the judgment of the Mona Panwar versus High Court of Allahabad 2011, or Nupur Talbar, or many judgments where the court always said the judicial mind to be applied by the magistrate at the time of taking the cognizance, and there should be prima facie case. Actually, there is a concept of the filtering in some other countries. Filtering, basically, this is the process to be followed by the magistrate to avoid the unnecessary harassment of the complainant or accused. However, in India, in the case of the Devendranath Pandey versus State of Orissa, the Supreme Court clearly said the no precognizance hearing should be given. However, this provision in that perspective is good. As your Lordship and Neeraj and also cited, so far as the 225 is concerned, in the 2005, in section 202, this was added, the person reside beyond the jurisdiction, and it is mandatory. And number of the judgment delivered by the Honorable Supreme Court, Arun Shourie, Birla Corporation, where it is mandatory. So as he said, that it is not, again you are supposed to give the benefit, this particular proviso which was added in the BNSS, basically here to satisfy whether there is a prima facie case, because one of the judgment of the Allahabad High Court, Naval Day, Bharti, versus State of Uttar Pradesh 2019. It is very interesting judgment. In this case, what happened, one of the UPSC examination was going on, and one of the aspirant who appeared in the examination, and then the FIR was registered against her, investigation completed, charge sheet filed that you have taken away the sheets, answer scripts from the back door of the room. When she got the summon, then she challenged it. And the law under which the case was registered, that Examination Act, which never exists in our country. And then the High Court said it is very unfortunate, mechanically the magistrate exercised this power, and there is a need to apply the judicial mind to see whether there is a prima facie. Basically, so this proviso has been added keeping in view the abuse of the process of law and unnecessary harassment of the complainant or the accused. Yes, any other question?
There's a question.
Yes, please.
Good afternoon, all the dignitaries on the dais and off the dais. I am Kanishk Chaudhary. I am DC in Ministry of Home Affairs and the Union Territories Division, sir. So my question is two quick questions regarding the implementation of these three criminal laws. They come from the backdrop of the direction given by the Honorable Prime Minister that UTs, Union Territories, should become role models in implementation of these laws, sir. So the first question is the definition of the state government or the government under the BNSS. We are not able to find the definition of the state government or the government in this Sanhita, sir. It says words of or expressions used herein and not defined but defined in the Information Technology Act 2000 and the Bharatiya Nyaya Sanhita 2023 shall have the meaning respectively assigned to them in that act. Now this has not been defined in any of the Sanhitas in the act and also not defined in the IT Act 2000, sir. So that is one question. The second question is regarding the trials that are going on and will be taking place in the special laws like NDPS Act or PC Act or Electricity Act. It categorically says that the procedure should be followed as given in the CRPC, sir. Now, Section 531 of the Repeal and Savings saves the proceedings which are undergoing in this Act, but not in the other specialized acts. So some light upon these two issues will help us in better implementation of the laws.
Yes. The question of special law doesn't come now because BNSS says under Section 531 Repeal and Savings, it is with BNSS is with regard to only application of IPC offences, and so the question of special law will not come. And whatever it is, special laws are governed by special laws. Unless and until special laws says that CRPC is also taken in course, special law, that question doesn't come.
Okay. That has been mentioned in certain special laws.
If that special law says that CRPC is also inclusive of that, and if it is a pending proceedings, then pending proceedings will be governed by the CRPC. New proceedings after 1st July will be governed by the new BNSS. Okay, thank you.
So 531 gets extended to special laws also. If a special law provides a provision that these CRPC provisions earlier are extended to special laws. Answering to your first question, if they are not, the term state has not been defined anywhere, we also fall back on General Clauses Act. If it is defined there, so the definition is taken from that. So I think that will not create much of the difficulty in finding a definition of state. Yes, this is right that the UTs are to be role model before 1st of July, and I think the Chandigarh has achieved that in what we have discussed in the last meeting also in the ministry, that Chandigarh has achieved in all senses, and they have already provided training to all the 5 verticals, forensic, correctional authorities, police, courts, as well as the prosecution. So I think that is what the Honorable PM has visioned, that let the UTs be first the role models and then replicated by different states in the coming days. Yes.
Yes, please.
Sir, I am DYSP Utpal Majumdar from Tripura, sir. Sir, I would like to clear myself one thing from the panelist about Section 173 of the BNSS. Here, in case of recording of FIR, in Section 173, subsection 1, clause 2, it is written, the information in cognizable cases, it is written like that, by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it, and the substance thereof shall be entered in a book to be kept like that. My question is that, sir, who will be held responsible to take the signature of the complainant or the informant? So whether police is liable to take the signature or the complainant himself or herself is liable to give his signature within 3 days. In case of other states or long distance, after 3 days, if the 3 days have already crossed, then what will happen about the FIR? Please, sir.
See, we all are aware that procedural law is a handmaid of justice. So if we come on the 4th day, there is no hard and fast rule in provision 167, which says that we will not allow you to put your signature. Okay, he will definitely be permitted, and it is his responsibility, who has set the law into motion, that he will definitely come and sign. Thank you.
Good afternoon, my lord and respected panelists. As we know that the BNSS has been replaced the old CRPC, which is going to be old. If we translate the BNSS, Bharatiya Nagarik Suraksha Sanhita, so it seems like that Indian Citizens Protection Code. There's certain provisions in old CRPC, even BNSS also, that applicable to non-citizens. That means arrest, detention, bail, etc., that can be applied, that is applicable to non-citizen also. So my question is that why it is only confined with the Nagarik Suraksha? As the non-citizen has also right over the same BNSS, then why it is been called as Bharatiya Nagarik Suraksha Sanhita? And my second, there is another query.
We will answer one by one.
Okay.
Have you seen the word Aditi Deva Bhava?
Yes.
Yes, we treat others also as Nagarik here.
Non-citizen?
Yes.
Thank you.
You don't understand?
Yes, I understood. But
yes, in a lighter sense, I am telling. See, basically laws are made for our citizens. Anybody who comes and makes any offense here, commits any offense, they are tried by Indian laws. So that is the answer.
Now, I am inviting Honorable Justice Arundev Chaudhary for concluding remarks.
We are running out of time. I think we have already exceeded 10 minutes. So I will not lengthen this closing. Only thing is that this enactment of 3 legislation is in a positive direction. No doubt about this. It was a long due. Now, criminal law in fact requires time to time overhauling. Because nowadays what happened, the technology has improved and the modern technologies are being used by the criminals. And how the old colonial law will handle all this situation. So therefore, in fact, new norms of evidence will come in modern times. Societal concept will change. So therefore, it was a long overdue, and this has been done, maybe at delayed stage, but better late than never. Oh, then only thing is that we had an elaborate discussion, and the panelist has rightly highlighted the points, the changes in technology, that it is a victim-centric law. It aims at reducing the overcrowding of the jails. And in fact, as overall, it is a very positive law. However, all laws will have to be tested in time. As Justice Retired Alfaz Ali has said that regarding the provision, there are some other provisions are there, attachment of properties, etc., which are stringent, which of course it will be tested in time. So thank you for this.
Thank you very much. Thank you, Lordship. So I would like to thank to all the panelists and Honorable Justice Arundev Chaudhary for chairing this session. And this is the, I think, first time I saw that we used to read in the law graduation or in being a law student, the ignorance of law is no excuse. And this is the first time before implementation of the law, so much conferences are being organized, and credit goes to the Ministry of Law and Justice Legal Affairs Department, because the law is going to implement on 1st July. But most of the time the program organized after the commencement. So this is the first and very good initiative by the Ministry of Law and Justice and Legal Affairs Department, and the credit go to the Government of India and ministers. And I would like to thank to the huge gathering and all the officers from the different part of the country, and since the morning you are sitting here and listening. So I would like to thank to all of you, all the panelists, participants, teachers, lawyers, prosecutors, and the officials from the Ministry of Law and Justice. And I would like to thank for giving me this opportunity to moderate this session. And finally, I would like to say one of the poetry about this conference as well, कि टहनियों पर याद का एक सिलसिला रह जाएगा, लौट जाएंगे परिंदे घोंसला रह जाएगा, तुम भले ही बंद कर लेना अपनी यादों का घर, कोई रोशनदान फिर भी अध खुला रह जाएगा. Thank you very much. With the permission of the chair, I would like to close this session. Thank you.
Our sincere thanks to all for an extremely informative and thought-provoking session replete with learnings. We would now like to present mementos to our esteemed guests on the dais. I'd request Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, to kindly come forward and do the honors. First, we would present the memento to Honorable Mr. Justice Arundev Chaudhary, Judge, Guwahati High Court. Thank you. We would now present a memento to Professor Muhammad Asad Malik, Faculty of Law, Jamia Millia Islamia University, New Delhi. Thank you. We would now present the memento to Shri Khomdaram Samarjit Singh, Deputy Solicitor General, Manipur High Court. Thank you. We would now present it to Shri E. Chandrasekaran, Advocate, Madras High Court. Thank you. We would now present the memento to Shri Neeraj Tiwari, Assistant Professor, NLU, Delhi. Thank you. I would now request our esteemed guests on the dais to kindly step forward for a group photograph, which will help preserve the memory of this event. Thank you. Ladies and gentlemen, this brings us to a close of the technical sessions of the conference on India's progressive path in the administration of criminal justice system. Thank you all once again. Ladies and gentlemen, as you are aware, we have the valedictory session scheduled for 5 p.m. I would request all present to kindly reassemble here on time. Thank you all once again. I'd request all present to kindly be seated. In just a short while, we'll start with the valedictory session. I would request you all to kindly take your seats, please.
Hello, 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 shake hello, hello, hello. Shake hello, 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 hello.
Ladies and gentlemen, we are deeply honored to announce the arrival of our esteemed chief guest, Shri Gulab Chand Kataria ji, Honorable Governor of Assam. I would request all present to kindly rise for the national anthem. Thank you. We are also honored to have with us Honorable Mr. Justice Vijay Bishnoi, Chief Justice, Guwahati High Court, Honorable Mr. Justice Manokh Ranjan Pathak, Judge, Guwahati High Court, Dr. Rajiv Marni, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, Honorable Mr. Justice Retired Mir Alfaz Ali, Vice Chancellor, National Law University and Judicial Academy, Assam, Professor Dr. V.K. Ahuja, Director, Indian Law Institute, Delhi, and Dr. Anju Rathi Rana, Additional Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India. Namaskar. Ladies and gentlemen, on behalf of the Department of Legal Affairs, Ministry of Law and Justice, Government of India, I would like to extend a warm welcome to you all to the valedictory session of this conference on India's progressive path in the administration of criminal justice system. Namaskar. Param Shraddha Bhajan Khudhibrinda, Bharator Aparadhik Nyaya Pranali Prashashan, ek প্ৰগতিশীল খোজ বিষয়ক গুৰুত্বপূৰ্ণ সন্মিলনখনি আজি সফলভাৱে সমাপ্ত হৈছে। উক্ত সন্মিলনৰ এই সামৰণি অনুষ্ঠানলৈ আয়োজকসকলৰ হৈ মই আপোনাসবক আন্তৰিক সম্ভাষণ সহ আদৰণি জনাইছো। We would now like to present mementos to our esteemed guests on the dais. I would request Dr. Rajiv Marni, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, to kindly do the honors. First, we would present the memento to our esteemed chief guest, Shri Gulab Chand Kataria, Honorable Governor of Assam. Thank you. We would now present the memento to Honorable Mr. Justice Vijay Bishnoi, Chief Justice, Guwahati High Court. Thank you. May I now request you, sir, to kindly present the memento to Honorable Mr. Justice Manokh Ranjan Pathak, Judge, Guwahati High Court. Thank you. I would again request you, sir, to kindly present the memento to Honorable Mr. Justice, retired Mir Alfaz Ali, Vice Chancellor, NLUJA, Assam. Thank you. We would now present the memento to Professor Dr. V.K. Ahuja, Director, Indian Law Institute, Delhi. Thank you, sir. I would now request Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, to kindly deliver the welcome address.
Good evening to all. We are honored today with the gracious presence of our chief guest, Honorable Governor Assam Shri Gulab Chand Kataria ji, our guest of honor, Honorable Mr. Justice Vijay Bishnoi, Chief Justice of Guwahati High Court, Honorable Mr. Justice Manash Ranjan Pathak, Judge, Guwahati High Court, other honorable judges of the Guwahati High Court in the audience, Tripura High Court, and honorable retired judges in the audience, Honorable Mr. Justice Retired Mir Alfaz Ali, Vice Chancellor, National Law University and Judicial Academy, Assam, Professor Dr. V.K. Ahuja, Director, Indian Law Institute, Member Secretary, Law Commission of India, Dr. Rita Vasist, Deputy Solicitor Generals, law officers of the state governments, judges of the district judiciary and members of the academia, central government panel councils, advocates, members of the law faculty, other members from the legal fraternity, all the esteemed guests here, representative of various law and order enforcement agencies, officers of the state and district administration. And we are now at the valedictory session of the two-day conference on India's progressive path in the administration of criminal justice system. As the representative of the Department of Legal Affairs, Ministry of Law and Justice, we are delighted to see such an immense participation of various stakeholders in the conference. The conference is just not only an exercise of the dissemination of the new criminal laws, but also a reminder of doing away with the colonial era mindset, which does not suit to the needs and requirements of the people of our sovereign nation. The importance of this conference in Guwahati becomes relevant considering the important facet of the criminal justice system, foundation of which has been laid down here in the two-day conference at Guwahati. That is, of course, one of the important factors which I have come to know is that the National Forensic Science University is being established at Guwahati, and it is the world's 11th campus and the country's 10th campus that has been established here. The establishment of this institution will not only act as a catalyst in seeking the objectives of the new criminal reforms, but also promptly aid in the dispensation of justice. The two-day conference has enlightened us all with the technicalities and advancement in the new criminal law reforms. It is abundantly clear that the new criminal law reforms have been adopted considering the technical advancements and the need for quality forensic studies to implement the processes. The nation has undergone remarkable transformation, a transformation that extends from beyond the economic growth to various other areas, including the area of governance. It is a transformation rooted in the principles of justice, fairness, and equality, a transformation that may reshape the very fabric of our society. The implementation of the three new laws, aided by technological advancement and the time-bound procedures prescribed therein, reflects the proactive thinking to achieve the goal of Viksit Bharat. These comprehensive reforms demonstrate India's sovereign commitment to security, to justice to its people, and not mere bureaucratic, technical, or any other sort of activity. The inaugural session of the conference, which was held yesterday, was a great success. We had Honorable Mr. Justice Hrishikesh Roy, Judge, Supreme Court of India, as the chief guest. Shri Arjun Ram Meghwal, Honorable Minister of State, Independent Charge, Ministry of Law and Justice, Government of India, also graced the occasion. Honorable Mr. Justice Biswanath Somadar, Chief Justice, High Court of Sikkim, Dr. Rita Vasist, Member, Law Commission of India, Chief Secretary, Government of Assam, Shri Ravi Kotaji, were also the dignitaries on the dais. Honorable Justice Hrishikesh Roy, in his address, pointed out to President Draupadi Murmu's speech on the Constitution Day celebration in November 22, wherein she had highlighted the problem of overcrowding of prisoners and stated that if we are progressing as a society, we will have to mull over and why we need more jails. We should in fact shut down the existing ones. Therefore, in the light of this and the vision of our Honorable Prime Minister, we have come a long way from retributive and punitive approach to reformative and restorative forms of justice. Justice Roy also emphasized that the new criminal laws not only seeks to dispense justice to victim, but also propose measures to reform and reintegrate the offender into the society. Honorable Law Minister Shri Arjun Ram Meghwal ji, he cited the example of IPC as not anything which is based on any original thought as enacted during the British period or any research, but it was an imposed act by the colonial masters against the Indians. The Honorable Minister highlighted that we are very thoughtfully used the word nyay rather than the dand in our new reform criminal law system, and the approach is not to punish, rather to respect, reform and restore the justice in the society. While delivering his address, Honorable Chief Justice of Sikkim High Court, Mr. Justice Biswanath Somadar, underscored that the new Bharatiya Nagarik Suraksha Sanhita, BNSS, provides a holistic approach to deal with the crimes in the digital age. He particularly mentioned that BNSS allows all trials, inquiries and proceedings to be conducted in the electronic mode, in the audiovisual, and helps in clearing the vast backlog and delivers faster delivery of the justice in pending cases. He was also appreciative of the introduction of the measure of community service and also suggested certain reforms in this regard to make it as a non-penal measure. Dr. Rita Vasist, Member Secretary, Law Commission of India, she provided an extensive overview of the comprehensive research and effort undertaken in drafting the new criminal laws, ensuring their relevance to the evolving needs of the society and the nation. Shri Ravi Kota, Chief Secretary, Government of Assam, also highlighted the potential of this new laws for having a peaceful and a just society, not only for the state of Assam, but for the entire region and the country. The technical sessions, we had 3 technical sessions today. The first was on the Bharatiya Nyaya Sanhita, wherein valuable observations were shared by Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court. The other panelists were Ms. Sangeeta Pradhan, Deputy Solicitor General, Sikkim High Court, Ms. Ipsita Borathakur, Special Judge, POXO, Nagaon, Assam, and Shri Amol Dev Chavan, Associate Professor, NLUJA, Assam. The deliberations at the technical sessions brought attention to several key elements of the Bharatiya Nyaya Sanhita. It underscored the evolution from a punitive approach to a justice-oriented with the legal framework and focus on both deterrence and societal reform. Notably, the restructuring of the offences, including specific sections dedicated to crimes against women and children, were aimed at to enhance the accessibility and comprehensibility of the law for all. Honorable Justice Soumitra Saikia also commented on Section 69, emphasizing the cases where consent is obtained through deceit. The chair also added his valuable viewpoints on the issue that in UAPA there is a presumption of guilt, whereas in BNS there exists a discretion in various matters. Of course, the deliberations were wide and quite comprehensive, and of course it was followed by a question-answer session, and many of the doubts of the participants were also cleared. During the session, of course, focused on the introduction of the community service as a punitive measure, alongside a careful consideration of the balance between increasing and decreasing criminalization and shifting to a more equitable and reformative and restorative legal stance. The mediator, Professor Vageshwari Deshwal from the Faculty of Law, Delhi University, conducted the session brilliantly with her probing questions on various facets of the Bharatiya Nyaya Sanhita. The technical session 2 was on the Bharatiya Sakshya Adhiniyam. It was chaired by Honorable Mr. Justice Devasis Barua, Judge, Guwahati High Court. The panelists were Sri Ranjit Kumar Dev Chaudhary, Deputy Solicitor General, Guwahati High Court, Dr. Nitesh Mozika, Deputy Solicitor General, Meghalaya High Court, Sri Roshan Lal, District and Session Judge, Karbi Anlong, Assam, Ms. Monica Sharma, Special Director Enforcement, Directorate of Enforcement. The technical session offered a thorough examination of India's newly enacted Bharatiya Sakshya Adhiniyam, which modernizes evidence law by acknowledging electronic and digital records as valid documents and evidence. Honorable Mr. Justice Devasis Barua, Chair of the technical session, highlighted that the most important change was inclusion of digital record as an important evidence. As reiterated by Sri Ranjit Kumar Dev Chaudhary, Deputy Solicitor General, that the landmark judgment in Arjun Pandit Rao Khotkar held that Section 65B of the Indian Evidence Act and the current Section 63, subsection 4C of the Bharatiya Sakshya Adhiniyam, the requirement of filing certificate has to be substantially complied with. Ms. Monica Sharma, Special Director, also gave her deep insights and the practical aspects of the certification required under the Bharatiya Sakshya Adhiniyam, which talks about the examiner of electronic evidence being an expert. Sri Raktim Dura, District and Session Judge, Kamrup, Assam, conducted the discussion in a structured manner and various issues were got clarified by the panelists on questions put by the audience. The third technical session focused on Bharatiya Nagarik Suraksha Sanhita 2023 with a very insightful discussion in the presence of Honorable Mr. Justice Arun Dev Chaudhary, Judge, Guwahati High Court, who was the chair of the session. Sri Kondrum Samarjit Singh, Deputy Solicitor General, Manipur High Court. Sri E. Chandrasekharan, Advocate, Madras High Court. And Sri Professor Neeraj Tiwari, Associate Professor, NLU, Delhi. The Bharatiya Nagarik Suraksha Sanhita signifies a notable shift towards a criminal justice system that prioritizes the need of victims and holds offenders accountable. The incorporation of accountability mechanisms for prosecutors, victim-centered provisions, and a focus on digitalization demonstrates a concerted effort to improve transparency, efficacy, and equity in dispensation of justice. In fact, this session on the Bharatiya Nagarik Suraksha Sanhita was the longest technical session held today, and a lot of questions which the audiences had were very ably clarified by the panelist, Sri Professor Muhammad Asad Malik, Professor, Faculty of Law, Jamia Millia Islamia University, Delhi, conducted the panel discussion in a thoughtful and insightful manner, and various issues were elaborately discussed and responded to. The technical sessions and the insights shared during this conference have highlighted the significant changes that India has made in reshaping the criminal justice system, and I think our efforts to hold this conference at Guwahati has been a great success, not only for the state of Assam, but with the participants coming from all the northeastern states. It has been a very heartening feature for all of us, and we think we have greatly achieved our objective. Of course, with the blessings of the Honorable Governor today on the dais and the state administration, which has cooperated in its fullest to make this conference a great success. In highlighting India's forward-thinking approach in administering criminal justice, we believe that the three new criminal laws have adapted to the current advancements of our society, which will benefit all the stakeholders as well as the judges, policymakers, legal professionals, law enforcement personnel, civil society organizations, and notably the citizens of our country, in leading towards a more just, fair, and progressive society. The new criminal laws are built for the modern India with focus on ever dynamic legal landscape. The esteemed guests and the panelists contributed rightly in this important discourse, and especially with the audience engaging with the panelists. I am confident that together we will continue to make great strides in promoting the understanding of the three criminal laws, which upholds the idea of justice, equality in the criminal justice administration system. We had a successful and a fruitful conference. I again thank Sri Ravi Kotaji, Chief Secretary, Government of Assam, Director IIT Guwahati, and Director ILI, and Professor and Director NLU JA, Assam, and convey my heartfelt thanks to them and all the esteemed guests who took time out to be present here with us. Jai Hind, Jai Bharat.
Thank you, sir. I would now request Professor Dr. V.K. Ahuja, Director, Indian Law Institute, Delhi, to kindly share a few words.
His Excellency Shri Gulab Chand Kataria ji, the Honorable Governor of State of Assam, Honorable Mr. Justice Vijay Bishnoi ji, the Honorable Chief Justice Guwahati High Court, Honorable Mr. Justice Manas Ranjan Pathak ji, Judge Guwahati High Court, other judges from Guwahati High Court, Tripura High Court, and other high courts, Honorable Mr. Justice Mir Alfaz Ali ji, Vice Chancellor in charge National Law University and Director Judicial Academy Assam, Dr. Rajiv Mani ji, Honorable Secretary Ministry of Law and Justice, Dr. Rita Vashish ji, Member Secretary Law Commission of India, Dr. Anju Rathi Rana, Additional Secretary Ministry of Law and Justice, Dr. Kalyan Chakravarti, Principal Secretary, Director IIT, all other government officials, dignitaries of the dais, lawyers, prosecutors, budding lawyers, ladies and gentlemen, a very good evening. We have come to the grand finale of this mega event, which has been graced by honorable judges of Supreme Court and various high courts, law minister, academicians, legal experts, and other eminent personalities. Ladies and gentlemen, society never remains static. It keeps on evolving. Law has to keep pace with the development in the society, be it economic, social, political, cultural, or technological. Practices which were acceptable yesterday may not be acceptable today, or the vice versa. It is therefore sine qua non to address the challenges in legal domains which are being faced by the society from time to time. It is pleasant to see that the criminal laws of British era, which suited Britishers rather than Indians, will be a part of the history of Indian legal system very soon. We are witnessing a transformative shift with the enactment of 3 new criminal laws. The efforts of legislature to modernize and Indianize these laws is laudable. The enactment of these criminal laws marks a significant milestone in our legal landscape, promising a future where criminal justice is more accessible, efficient, and equitable. Ladies and gentlemen, the enactment of Bharatiya Nyaya Sanhita, Bharatiya Sakshya Adhiniyam, and Bharatiya Nagarik Suraksha Sanhita is the progressive step in the administration of criminal justice system. However, there remains some challenges also. Challenges in the sense of providing technology-based infrastructure to all the courts and police stations in India, effective court management, financial support, additional manpower for the disposal of cases in a time-bound manner as proposed in the new laws, training of police, advocates, judges, and other stakeholders, opening up forensic labs in all parts of the country for the effective and timely disposal of cases, digitization of process, and cyber security to keep the entire data safe and secure, to name a few. There may be many more challenges which we are likely to face once these legislations are implemented. Friends, community service has been incorporated as a new type of punishment, which is being considered as a welcome addition in the category of punishment. I would like to say a few words about the community service from the point of view of Bharatiya Nyaya Sanhita. Making convict to do community service for committing certain type of offenses rather than imposing fine on him or putting him behind the bar will provide a golden opportunity to such person to repent and reform. There is no definition of the term community service in the legislation. There is a need to define this term to give it some certainty, and the certainty is to be given by the legislature. In my opinion, however, it may include rendering services at religious places by assisting the priests and managers of religious places, as well as devotees who visit those places, participation in the cleanliness drive, serving at orphanages, serving at old age homes, rendering services at public hospitals, plantation of trees under the supervision of local authorities, helping police to manage crowd, assisting traffic police, serving at animal shelters, helping homeless people, participation in various schemes and campaigns of the government, participation in relief works of the government, etc., etc. So this is what I thought, that these may be part and parcel of the community service, but of course a definition is required as to what exactly the community service is. The court may assign the punishment of community service to a convict looking at his background, qualification, and the suitability for a particular type of community service. The punishment of community service will serve several important purposes. Number one, the person given the punishment will not carry the social stigma of being imprisoned, and that social stigma is not only confined to the person concerned, it goes to the family members, it goes to the children also who may be studying and who may be bullied by the classmates. Now, second is that the society will be benefited by his community services. Third, jail will not be overloaded and the government will save substantial money. Number four, the possibility of such person coming in contact with hardcore criminals will be ruled out. Number five, such person will not face any problem in resuming his professional life after the completion of his term of punishment. Number six, by serving in community, he may develop the habit of empathy towards others and remain involved in such community services even afterwards. Friends, the punishment in real terms has been Indianized, where a convict of petty offense will be reformed, not punished. We need to understand that criminal justice is not about laws, it is about compassion, equity, and human dignity. Well, friends, there is some other observations also. Now, the community service, when I read this term in Bharatiya Nyaya Sanhita, I find it to be a form of punishment. But when I read this term in the National Education Policy 2020, it is being considered a part of holistic education, a value addition education system. NEP says, value-based education will include the development of humanistic, ethical, constitutional, and universal human values of Satya, Dharma, Shanti, Prem, Ahimsa, and participation in community service programs. And these are being considered as integral part of holistic education. Now, here comes the problem. I become slightly uncomfortable because when I read community service in BNS, it is a punishment, but when I read it in NEP as a part of the education system, it is being considered as a holistic service being rendered to the community. Now, the question here is, do we really need to call community service as punishment? Is it really a punishment? Community service has an overtone of spirituality also. Each one of us, we do community service. Last evening when I was listening to Honorable Chief Justice of Sikkim High Court, he gave a wonderful suggestion. He said that the people who have been convicted and awarded the community service as punishment, they should not be called as convicted people. So, I mean, it should be assumed that they are not convicted. So they will remain in the mainstream and of course that will give an opportunity to them to reform. So my only submission is, I mean, a view which came to my mind is that do we really need to have community service as a part of punishment under section 4, I think it is section 4 of Bharatiya Nyaya Sanhita, or should we take it out from there and put it in a different section, because it is not a punishment in the strict sense, it is a service which is being rendered to your own community. Friends, it's worth mentioning that we should continue to build on this momentum by ensuring effective implementation, continuous monitoring, and periodic reviews of these laws so that these laws could achieve their intended goals. Additionally, fostering legal awareness and education among the public will play a vital role in empowering individuals to seek and obtain justice. The conference by Ministry of Law and Justice is second, which was meant to cover the entire northeastern region. We tried our level best to cover all the 8 states of northeast regions and to cover people who are the stakeholders, be it police, be it the members of enforcement agencies, the students, the teachers, the public prosecutors, the judges, the high court judges. So we tried to reach out to each one of them. Though it is important to sensitize and educate judges, advocate, police officers, and enforcement agencies and other government officials, at the same time it is also important to educate people from NGOs, medias, both electronic and print, people who take up pro bono work for victims, and civil society at large about these 3 new criminal laws. I think our law schools and universities should come forward to share this responsibility by organizing seminars, conferences, and panel discussion to sensitize and educate more and more people. Ministry of Law and Justice cannot reach out to each and every corner of the country. So we will have to involve the law schools and universities, and I think the Ministry of Home Affairs and Ministry of Law and Justice should motivate the law schools and the universities in this regard. With these words, I conclude. Thank you very much. Namaskar.
Thank you, sir. May I now request Honorable Mr. Justice, Retired Mir Alfaz Ali, Vice Chancellor, NLUJA Assam, to kindly address this august gathering.
So, very good evening. Honorable Governor of Assam, Sri Gulab Chand Kataria ji, Honorable Justice Bijoy Vishnoi, Chief Justice, Guwahati High Court, Honorable Justice Manas Ranjan Pathak, Judge, Guwahati High Court, Sri B.K. Ahuja, Director, Indian Law Institute, Delhi, Dr. Rajiv Mani, Secretary, Department of Law and Justice, Dr. Anju Rothi Rana, Additional Secretary, Honorable Justice Arundev Chaudhary, and other distinguished guests sitting of the dais, judicial officers, police officers, public prosecutors, advocates, students, ladies and gentlemen. We are at the valedictory sessions after a marathon deliberations on the 3 criminal laws. So I propose not to speak anything on the laws, on the 3 laws, and I also do not feel myself to be competent also. But I just want to share one aspect with all of you, more particularly the key role players of the criminal justice system. That is the judicial officers, police officers, public prosecutors, advocates. Because a good law, how it is implemented, it can be, implementation can be good, implementation can be bad. it depends how the implementing stakeholders understand the law, understand the philosophy behind the law. A good law also may be bad while it is implemented. I just want to share a story. The names are symbolic. Timur Long was a, very mighty king. He invaded a neighboring kingdom, very small one. He was not in a position to combat. Lot of his soldiers were killed. Ultimately, he bowed down and made a treaty on the conditions that there will be no further bloodshedding. And the war subsided. The poor king subjected to the Timur Long. After the next day of the treaty, the soldiers of Timur Long started buried all the generals and soldiers alive. Then they raised objections. What are you doing? That was not the understanding. That was not the covenant. No. This is very good according to the agreement. Where is there? We are not shedding simple drop of blood. It is very much in accordance with the agreement, covenant. So they are implementing the law. If we take this covenant as agreement, law, they are implementing it. Does that agreement means what they are doing? Obviously no. The principle or the philosophy or the principle was that there would be no violation, no killings. So this is also implementation of the law. That is why I say a good law can be badly implemented, and sometimes a bad law can also be implemented in a very good manner. We have been discussing since yesterday regarding these 3 new legislations. What I can gather, broadly 2 aspects I find. One is philosophical aspects. That's we are saying, that the retributive to restorative justice, then colonial to Indian, and, making the law in consonance with the constitutional principles, so on and so forth. And the another part is the functional aspect. Functional side is, because law is a social subject, with the development of the society, with the evolution of the society, with the growth of technology, science, the society needs sense, law needs to be sense. So there is huge sense to keep pace with the scientific development, technological development. And another aspect of this functional side is to speed up the justice. We have been discussed that various schemes, various provisions have been enacted, laying down timelines for various steps. So these functional aspects of the legislations is very much scripted in letters in the statute. When we read the law, we can find it. But the philosophy, which is the principal thing, who is rather I can say the soul. If we functional part, we said the body, this philosophy part is the soul of these 3 legislations. If we don't understand these 3 souls, then we will not be able to implement the law. Now, is it for the first time we are talking about retributive justice? Is it for the first time we are talking about justice? I may say no. Because if we see the preamble of the constitutions, what it says, we the people of India, having solemnly resolved to constitute India into a secular, etc., and to secure to all its citizens justice, the first word, justice, then liberty, fraternity, so on and so forth. The constitutional vision of justice is to do justice to the citizen of India. If we see the criminal procedure code, there has been various changes. Prior to 1955 amendment, which was the law of the British time, I am giving just one example. For the capital punishment, death was the rule, death sentence was the rule, and exception was the life imprisonment. You have to award the death sentence. If you don't, and you go for life imprisonment, you will have to assign reason. Then the law was amended in 1955. Now the law says it is the discretion of the court. You can go for death sentence, you can go for life imprisonment. So, one step forward from retributive to restorative. Then comes the 1973 amendment. 1973 says life imprisonment is the rule, death sentence is exception, that too with special reasons. Thus a paradigm shift from the retribution to the restoration. Juvenile Justice, the Probation of Offenders Act was enacted in 1958. This is a important, fantastic law to accomplish the object of restorative justice. Now, I have been in the judicial system for last 36 years. I can confess today how many times, I say myself also not exception to that, this is for the judicial officers, we have applied this Probation of Offenders Act. We award sentence for 15 days, we award sentence for 1 month, we award sentence for 3 months. Does this sentence is consonance with this Probation of Offenders Act or with the constitutional principle? But we are doing this. 30% cases if you find, which are basically sought to have been dealt with Probation of Offenders Act, but not being dealt with. Why? What is the problem? The problem is perhaps with our mindset. Though the law is there, scripts is there, our mindset is still we perhaps carry somewhere in subconscious stage that the colonial mindset. कुछ किया है तो उसको जेल में भरो. We even bother to see that we are not in that stage. We are going to restorative stage. There is a legislative enactment before us. We don't further it. So unless we change our mindset, see, Probation of Offender Act was enacted in 1958, and now almost 70 years we are not applying. I don't say not applying at all, but we are not applying in many cases where it is supposed to be applied. So, to understand the philosophy, perhaps we need to change our mindset. We have to do some exercise consciously that no, we are now the citizen. We are not subject of the British. We have adopted these principal constitutions, right of the citizens, all these things. Then perhaps we will not be victim of these colonial mindsets we are carrying with us in our subconscious mind. Another important aspect which is directly related to the very cherished fundamental rights, Article 21. Right to life, right to liberty. Say arrest. CRPC say, you say CRPC, BNSS, police has the power to arrest in a cognizable case without magistrate's order. Now, is the power of arrest and the necessity of arrest is the same thing? There was, this term necessity was no longer there in the CRPC, but if we go by the constitutional principle, though we have power, we are not supposed to go for an arrest because which has a very, very stringent effect on the fundamental right of the citizens. We are talking about making the law citizen-centric, making the law in consonance with the constitutional principle. We are making the law reformist, restorative. In 2009 amendment, in 41 CRPC, this necessity has been incorporated. That unless there is necessity, there should not be any arrest. I can say, in spite of that word included in the CRPC in 2009, specifically that there is no arrest when there is no necessity. At least 30% arrest which are not necessary is being done. That I am saying from my own experience, from the magistrate second class to the judge of the High Court. There are later judgments, Anesh Kumar, etc. The plenary session also discussed about the Siddhartha, section 170, 190, all these things. So if we implement the law, want to implement the law in a good way, in a manner the legislature intended, legislature wanted, then we cannot be oblivious of the constitutional provisions, of the right of the citizens. Because when we arrest a person, it freezes his most cherished right given by the Constitution under Article 21. So we must assess, because it can be restricted, but how? Reasonable restrictions. There has to be reasons. We are not only in this era of procedure established by law, we are in the era of due process of law. Even the procedure established by law, something is done and the procedure is found to be unreasonable, court can strike down that. So we are in the era of due process of law. So even if, whenever we apply the law, apply the process, we cannot be unmindful, we cannot be oblivious of the constitutional provisions. I should give you two examples. So my friends, we are judicial officers, police, etc., who are the key players in implementing this law. If we, unless we get ourselves free from the colonial mindset, तो क्या है FIR लॉज है कि अरेस्ट करो, पहले अरेस्ट उसका बाद investigations. That is the things. This law does not permit, I tell you, does not permit. So far we are concerned, the implementing stakeholders, we must be very cautious. We must make ourselves capable to understand the principle of law, the philosophy of the law, the intention of the legislature with which the statutes have been brought. So my request to all the stakeholders that whenever we implement the law, we should not forget our constitutions, because constitution is supreme. Every law, including the criminal law, is subject to constitutions. No law is above constitutions. So we have to inculcate the habit of removing that, remnants of colonial mindset in our, what it's called, it's hard disk or soft disk. If we cannot do that, the fate of Juvenile Justice Act, which has been done in 1951, the same legislation may also face the same fate. With these few words, I conclude because perhaps I have exceeded my time. With these few words, thank you very much. Jai Hind, Jai Bharat.
Thank you, sir. এতিয়া মই গুৱাহাটী উচ্চ ন্যায়ালয়ৰ মাননীয় ন্যায়াধীশ শ্ৰীযুত মানস ৰঞ্জন পাঠক মহোদয়ক তেখেতৰ ভাষণ প্ৰদান কৰিবলৈ অনুৰোধ জনাইছোঁ।
You have heard Justice Ali, his experience in judiciary for more than 26 years. His Excellency, Sri Gulab Chand Kataria ji, Honorable Governor of Assam, Honorable Mr. Justice Vijay Vishnoi ji, Chief Justice of the Guwahati High Court, the High Court of Assam, Nagaland, Mizoram and Unnatural Pradesh, Honorable Mir Alfaz Ali, retired Judge of the Guwahati High Court, presently serving as the Director of Judicial Academy, Assam, and the in-charge Vice Chancellor of National Law University, Assam. Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice. Professor Dr. V.K. Ahuja, Director of Indian Law Institute and former Vice Chancellor of National Law University, Assam. Dr. Anju Rathi Rana, Additional Secretary, Department of Legal Affairs, Ministry of Law and Justice. Honorable judges, the dignitaries, the guests, learned panelists, the moderators, dear participants, and students present here. Namaskar and a very good evening. On behalf of the Guwahati High Court, our respects and greetings to all who gathered here in this valedictory session of the 2 days conference on Bharat ki Nayi Aparadhik Nyay Pranali, Ek Pragatisheel Kadam, India's progressive path in the administration of criminal justice system, being organized by the Government of India, Ministry of Law and Justice, Department of Legal Affairs, on the occasion of the 3 new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam, that will come into force from 1st of July this year, replacing the existing British-era criminal laws that are in force since its inception, namely the Indian Penal Code, 1860, Code of Criminal Procedure 1898, amended in 1973, and the Indian Evidence Act 1872, respectively. Yesterday evening, we had the inaugural session of this conference in presence of the distinguished guests and august gathering, and we are sure that all the participants have enjoyed and enlightened from the 3 technical sessions held today. Law is not static. As the society develops and progresses, the framers of the law used to frame the laws as required and brings them into force. When such laws are allegedly to be in violation of constitutional provisions and not meant justice on being challenged, the competent court of law either upholds the same or struck down such law or its provision on due consideration. From history to the present stage, we can trace the development of the criminal justice system in India, such as in the Vedic age, period of Delhi Sultanate, Mughal Empire, and then the days of Crown, and thereafter on obtaining independence from British rule. During such development of the criminal justice system, it can be seen that various principles and laws influenced determination of punishments and maintenance of orders in society, like Smriti during the Vedic era, Shariat law during the Delhi Sultanate era. During the period of Mughals, it created the Mahakuma-e-Adalat that dealt with civil as well as criminal matters under Islamic law, but faced many challenges. During the colonial period, the first Indian company introduced court system establishing the High Court. These developments set the foundation for the enactment of the codes in the 1860s. The first law commission during British Raj produced a draft penal code in 1837. We have also heard punishments like Hulot Dia, Garam Telot Dia, Ango Khud Kora during the Ahom days in Assam. As per its premise, the socio-political factors, evolving societal values, demand for justice, prioritizing the victims, the need for tech regulations due to the digital revolution are the key roles for creation of these three new criminal laws. Acknowledging the potential for improvement, emphasizing the importance of understanding and implementation, and feeling that there is a need for transition towards a modern legal system, the framers have framed these new laws. The contention of the central government, as it can be seen, is that these new criminal legislations lay emphasis on Indianness, the Indian constitution, and the well-being of the people, encouraging the use of technology, giving importance to forensic science in investigation, prosecution, and judicial system. The framers viewed that the philosophy of the three new laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha, and Bharatiya Sakshya Adhiniyam, are to provide restorative justice focused on rehabilitation and victim-centric, whereas the philosophy of the existing laws under the Indian Penal Code, Code of Criminal Procedure, Indian Evidence, were to provide punitive and retributive justice. As per the framers, these three new laws have been built for the modern India, focusing on ever-dynamic legal landscape where the IPC, CRPC, and Evidence Act were developed by the Britishers under their perspective and ideology. With regard to sentencing in the new criminal laws, we have seen that there are provisions for fixed punishments as well as restorative justice provisions like imposition of community service or rehabilitation, more fines and punishments, whereas in the old criminal laws, there are fixed punishments and penalties specified for various kinds of crimes. The new criminal laws aimed at expediting the trial process by implementing time limit and leverage technologies to enhance efficiency, whereas the existing criminal procedure is lengthy in process for which the relief is delayed to the victim. Pertaining to the admissibility of evidence in the new Act, its scope has been expanded to take into account digital evidence and records, strengthening the investigations, whereas in the existing Evidence Act provided strict and rigid rules for testimonies of witnesses with limited admissibility of electronic evidence. Recently, in April this year, while speaking at Raising Day of the Central Bureau of Investigation at New Delhi, His Lordship, Honorable D.Y. Chandrachud, the Chief Justice of India, termed the three new criminal laws passed by the Parliament as a significant step towards modernizing the justice system, stating further that the new laws encompass substantive crime, procedure, and evidence, and keeping a digital record of every stage of criminal investigation ensures a seamless flow of information. As the three new criminal laws, Bharatiya Nyaya Sanhita, BNS in short, Bharatiya Nagarik Suraksha Sanhita, BNSS in short, and the Bharatiya Sakshya Adhiniyam, BNS in short, from 1st July 2024, will replace the existing British-era criminal laws, namely the Indian Penal Code 1860, Code of Criminal Procedure 1898, that was amended in 1973, and the Indian Evidence Act 1872, respectively. Revamping the criminal justice system, there is a requirement to sensitize the provisions of the three new laws to public and for special training to the judiciary, as well as the law enforcing agencies and authorities, including the police official and the public prosecutors. Keeping that in mind, the central government in its Ministry of Law and conceivably has scheduled this conference at Guwahati. As desired by the Honorable Chief Justice of India, the Honorable Chief Justice of our High Court, Honorable Bisnoyji, being its patron-in-chief to the Judicial Academy Assam, have already started 3 days training on these three new criminal laws for the judicial officers of Assam, Nagaland, Mizoram, and Arunachal Pradesh, batch by batch from 13th of May 2024 to be completed within June 2024, much ahead of 1st July 2024. With regard to these three laws, the respective states are required to do the needful and to train their law enforcing agencies, police officials, and the public prosecutors on priority. Section 356 of the Bharatiya Nyaya Sanhita repeals the Indian Penal Code with the replacement of the former legal framework, preserving the past actions and legal consequences while incorporating the new legal framework of the BNS, safeguarding the existing rights, privileges, obligations, and liabilities, ensuring the continuity of the legal aspects under the IPC. Penalties and punishments for offenses under the repealed IPC will remain in force, along with the continuation of investigations, remedies, and legal proceedings. Thereby, all actions under the old law will be deemed as having occurred under the corresponding provisions of the BNS. Moreover, the repeal doesn't prejudice the application of Section 6 of the General Clauses Act 1897, maintaining consistency in legal principles during the transition. Though these three new criminal laws will come into force from 1st July 2024, despite the repeal, the provisions of the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act will be in use for some period for the said reasons. To understand and know well the provisions of the new criminal laws, the ingredients of each section, as well as the corresponding laws, the interested persons should go through good reference book that contains the objection reasons for each of the sections or the publications of the Government of India in that regard. With this, I express my sincere thanks to you all. I am also thankful to the Department of Legal Affairs in the Ministry of Law and Justice for giving me this chance to share my views. Namaskar and Jai Hind.
Thank you, sir. I would now request Honorable Mr. Justice Vijay Bishnoi, Chief Justice, Guwahati High Court, to kindly deliver his valuable speech.
His Excellency Honorable Governor Governor of Assam Shri Gulab Chand Kataria ji, Honorable Justice Manas Ranjan Pathak and Justice Arun Dev Chaudhary, other judges of the High Court of Tripura, Manipur and Meghalaya, Honorable Mr. Justice Retired Mir Alfaz Ali, Director Judicial Academy, Assam, Dr. Rajiv Mani, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Professor Dr. V.K. Ahuja, Director, Indian Law Institute, Delhi, Dr. Anju Rathi Rana, Additional Secretary, Department of Legal Affairs, Ministry of Law and Justice, Union of India, all other dignitaries who are present here, the participants who have participated in today's sessions, ladies and gentlemen, a very good evening to all. I am very thankful to the Ministry of Law and Justice, Department of Legal Affairs, Union of India, for holding this conference on India's progressive path of the administration of criminal justice on the impact of new criminal laws, that is Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, which will come into force after 1st of July 2024. I am also grateful for getting this opportunity to address this august gathering and express my views. At the outset, I would like to convey my regret for not being able to present amidst you all yesterday in the inaugural session, as I could not reach Guwahati from Aizawl due to bad weather. However, I am grateful that I am able to address you in the valedictory session today as we drew to the end of this conference. The existing laws of Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, which the new laws will soon replace, have been the backbone of our adjudication system of criminal offences for so many years. However, our experience would tell tell us that these laws are not perfect. As a matter of fact, no law can be said to be perfect because the efficacy of any law can be tested only when it is applied to the varied facts and circumstances, all of which cannot be visualized beforehand. Moreover, law never can be static but has to remain relevant in the contemporary situations. Hence, necessary changes were made in the IPC, CRPC and Indian Evidence Act through amendments from time to time. But it was realized that those changes were not sufficient to make these laws more effective and relevant in the new age, and hence a holistic change was a need of the hour. The need for a holistic change must have been propelled the Parliament to enact the new laws, so to bring about an overhaul in the criminal judicial system in our country, so that the substantive laws as well as the legal procedure can be made more simpler, more citizen-centric, more holistic, more reformative, capable of delivering speedy justice and more relevant to the new age. The changes were deemed necessary to modernize the criminal judicial system, aligning it with the evolving societal needs and technological advancements. In other words, it is expected that the new criminal laws will bring positive, substantial changes while addressing contemporary challenges. To my mind, this exception is not misplaced because if we study the new laws, we will see that these laws have many positive aspects. I do not wish to go into the details of the new laws, as the same must have been dealt comprehensively in the working sessions. Hence, I express my sincere gratitude to all the honorable judges who has chaired the technical sessions, all the panelists, moderators, as well as the participants whose collective wisdom and expertise must have graced this discourse on the new laws. As I said earlier, once a new law are put in operation, their effectiveness will be tested. Problems in the application of the new laws may arise, but they should not deter us from applying the laws in their true letter and spirit. If any change is felt necessary, required changes can be incorporated through legislative amendments to make the laws more effective. Having said that, it goes without saying that for an effective implementation of new laws, capacity building measures are necessary so that judiciary, public prosecution, forensic experts, lawyers are well equipped. Training or seminars on the new laws is an essential component of such capacity building measures. In this sense, conference like which we are having today will go a long way in making all the stakeholders understand the notions of the laws in their proper perspective. At this juncture, I would like to highlight the steps taken by the Guwahati High Court, as already mentioned by Justice Pathak, in such capacity building under the initiative taken by the Honorable Supreme Court. In the Judicial Academy, Assam, we have initiated the process of imparting orientation programs to the judicial officers, so to sensitize them about the nuances of the new laws. I am hopeful that such orientation programs may be extended to the other stakeholders also in future. Besides imparting necessary training as a part of capacity building measure, I am of the view that it is also essential to upgrade physical infrastructure in courts, police stations, forensic labs, etc., so as to equip these establishments to support the extensive use of technology. Further, the general public should also be made aware of the new laws so that they can make the best use of the laws. Unless the benefits of the law percolate till the last man standing in the queue, the purpose of bringing the laws will never fulfill. Towards this end, Legal Services Authority can play a major role in spreading awareness about the new laws among the masses. In conclusion, I would like to say that we all need to put in our best efforts in the interest of effective and judicious administration of justice, which is necessary if we want to see our nation progress leaps and bounds in all spheres. We should remain hopeful that the new criminal laws will positively contribute towards a robust system of the administration of justice. On behalf of Guwahati High Court, I extend my heartfelt gratitude to all of you for making this conference a grand success. Thank you. Jai Hind.
Thank you, sir. I would now request our esteemed chief guest, Shri Gulab Chand Kataria, Honorable Governor of Assam, to kindly deliver the valedictory address.
नमस्कार। भारत की आपराधिक न्याय प्रणाली पर आयोजित इस सम्मेलन में समापन अवसर पर उपस्थित आदरणीय चीफ जस्टिस विजय बिश्नोई जी, नेशनल लॉ यूनिवर्सिटी के आदरणीय कुलपति असम श्री रिटायर्ड जस्टिस मीर अल्फाज अली जी, गुवाहाटी हाई कोर्ट के माननीय न्यायाधीश जस्टिस मानस रंजन पाठक जी, भारतीय विधि संस्थान दिल्ली के निदेशक डॉक्टर वीके आहूजा जी, कानून और न्याय मंत्रालय के कानूनी मामलों के विभाग के सचिव डॉक्टर राजीव मणि जी, उपस्थित सभी अधिवक्तागण, जजेज, विद्यार्थी, पुलिस ऑफिसर्स, इस सम्मेलन में उपस्थित सभी बंधुओं, मीडिया के सभी साथियों, देवियों और सज्जनों, भारत की इस नई आपराधिक न्याय प्रणाली एक प्रगतिशील कदम है और मुझे वास्तव में उस दिन बहुत ही आनंद का अनुभव हुआ जब 21 दिसंबर 2023 को पहली बार देश के गुलामी के इस कलंक को हटा करके भारत तो अपना संविधान 50 में लागू कर दिया, लेकिन अंग्रेजों के कानून से हम मुक्त पहली बार होने का प्रयास अगर कहीं हुआ तो 21 दिसंबर 2023 को हिंदुस्तान की लोकसभा में इस कानून को पास किया है। उसके लिए मैं उन सब प्रतिनिधियों का आपकी ओर से, मेरी ओर से बहुत बहुत धन्यवाद और आभार ज्ञापित करता हूं। इस 2 दिवसीय सम्मेलन के समापन के अवसर पर आप सभी के बीच मुझे यहाँ आने का सौभाग्य प्राप्त हुआ। इस महत्वपूर्ण सम्मेलन का आयोजन करने के लिए भारत सरकार के कानून एवं न्याय मंत्रालय और मेरी असम सरकार को हार्दिक धन्यवाद देता हूँ। ब्रिटिश काल से चली आ रही हमारी देश की आपराधिक न्याय प्रणाली में आमूलचूल परिवर्तन किए गए हैं। भारतीय दंड संहिता 1816 जब हम जनप्रतिनिधि के रूप में विधानसभा में जब कभी भी विषय पर चर्चा करते थे तो लोग हमसे सवाल पूछते थे कि 1860 का अंग्रेजों के सरकार चलाने के कानून को आप इसे कब ठीक करोगे। तब मन को एक वेदना होती थी कि देश संविधान निर्माताओं के आधार पर हम एक तरह से अपने संविधान के आधार पर 1950 से आज़ाद हो गए, लेकिन कानूनी दृष्टि से ये आज़ादी का अनुभव पहली बार इस अवसर पर हुआ और उसका श्रेय देश के प्रधानमंत्री जी को उस 15 अगस्त के भाषण को जाता है कि देश में ऐसे बिंदु जो हमारी गुलामी के निशान हैं उनसे देश मुक्त होकर के स्वतंत्र वातावरण में सांस ले, उस प्रक्रिया के आधार पर जो प्रयत्न हुआ है, लगभग 2 साल के निरंतर प्रयास, चर्चा, सब विद्वानों से डिस्कशन करने के बाद इन 3 कानूनों की रचना जो हुई है उसके लिए उन सभी का मैं बहुत बहुत धन्यवाद करता हूं। मैं सोचता हूं भारतीय दंड संहिता 1860 आईपीसी की जगह भारतीय न्याय संहिता विधेयक 2023, दंड प्रक्रिया संहिता सीआरपीसी 1973 के स्थान पर भारतीय नागरिक सुरक्षा संहिता 2023 और भारतीय साक्ष्य एक्ट 1872 की जगह भारतीय साक्ष्य अधिनियम 2023 कानून में लाया गया। ये आपराधिक कानून अगली 1 जुलाई 1924 से इस देश में पूर्ण रूप से लागू हो जाएगा। इसके लिए भी सबको बहुत बहुत आभार और धन्यवाद। मैं सोचता हूं कि पहली बार आतंकवाद की व्यापक परिभाषा इसमें हुई है। यहाँ डिजिटल रिकॉर्ड्स, ईमेल, सर्वर, लॉग्स, कंप्यूटर्स, स्मार्टफोन, लैपटॉप्स, एमएस वेबसाइट, लोकेशनल साक्ष्य, डिवाइस पर उपलब्ध मेल मैसेजेज को कानूनी वैधता दी गई है। एफआईआर से केस डायरी से चार्जशीट और चार्जशीट से जजमेंट तक की सारी प्रक्रिया डिजिटलाइज करने का प्रावधान इस कानून में किया गया है। सर्च और जब्ती के वक्त वीडियोग्राफी को अनिवार्य किया गया है, जो केस का हिस्सा होगी, और इससे निर्दोष नागरिकों को फंसाया नहीं जा सकता। पुलिस द्वारा ऐसी रिकॉर्डिंग के बिना कोई भी चार्जशीट वैध नहीं मानी जाएगी। मैं सोचता हूँ इस प्रकार की जो व्यवस्था की है, जिसके कारण से जिसको न्याय की आवश्यकता है उसको ये भरोसा होगा कि वास्तव में मुझे न्याय मिलेगा। यही सबसे बड़ी उपलब्धि मानता हूँ। नए कानून में केस वापस लेने के लिए पीड़ित का पक्ष सुना जाना अनिवार्य है, क्योंकि मैं भी गृह मंत्री रहा हूँ। हमने हजारों केस लोगों के पुराने वापस ले लिए। न तो हमने उससे पूछा जो इससे पीड़ित था, केवल हमने और हमारे विवेक के आधार पर निर्णय लिया, जिसमें हम सही भी हो सकते हैं, जिसमें हम किसी व्यक्ति के प्रति सहानुभूति रख करके भी ले सकते हैं। हमने कई केसेज ऐसे लिए हैं जो गंभीरतम अपराध थे। तो मैं सोचता हूँ ये जो एक छूट थी, इसको समाप्त करने का काम जो किया है, उसके लिए मैं बहुत धन्यवाद देता हूँ कि पीड़ित पक्ष को बिना सुने आप किसी भी केस को विड्रॉ नहीं कर सकेंगे। यह नागरिक अधिकारों की रक्षा की मदद मिलेगी। नए कानून में आरोप पत्र दाखिल करने के लिए जो 90 दिन का समय दिया जाता है, इसमें अगर आपको आवश्यकता हो तो इस अवधि को बढ़ाकर 180 दिन भी किया जा सकता है रीजन के साथ, ताकि चार्जशीट कई बार समय पर चार्जशीट पेश नहीं होने के कारण या तो जानबूझ करके या अपराधी को मदद करने की दृष्टि से जो 90 दिन में चार्जशीट पेश करनी चाहिए वो नहीं की जाती है, जिसके कारण से कई बार वो बेल आउट हो जाता है। इसी आधार पे इसको भी रोकने का प्रयास किया है। इस बदलाव के लिए अब 180 दिन के अंदर जांच समाप्त होगी। जांच के फौरन बाद अदालतों में ट्रायल शुरू होगी। अदालतों से आरोप तय करने का नोटिस 60 दिनों में देना अनिवार्य होगा। बहस या सुनवाई की पूरी होने के 30 दिन के अंदर अदालत को फैसला जारी करना होगा। मतलब केवल और केवल इस सिस्टम को भी सुधारने का प्रयत्न किया है, एक तरह से सीमा में बांधने का प्रयास किया है, जिसके कारण से व्यक्ति को न्याय मिल सके। फैसले की प्रति 7 दिन के भीतर ऑनलाइन उपलब्ध कराने का नियम भी इस कानून के तहत जोड़ा गया है। महत्वपूर्ण बात है कि आपराधिक न्याय प्रणाली में यह बदलाव समय की मांग थी। प्रधानमंत्री नरेंद्र मोदी ने 15 अगस्त को अपने स्वतंत्रता दिवस के संबोधन में ये प्रसन्नता व्यक्त की थी कि हमारी सरकार के न्याय प्रदान करने की व्यवस्था के तहत आरोप पत्र दाखिल करने की दर किसी भी अन्य सरकार की तुलना में सबसे अधिक है। मैं सोचता हूं कि निश्चित रूप से इस कानून के द्वारा जो कुछ मैं समझ पाया उसको मैंने चित्रित करने का प्रयास किया है। भारतीय न्याय संहिता 2023, यह संहिता 1 जुलाई 24 से लागू होगी। परिवर्तन करते हुए कई विषयों को कानून में पहली बार स्थान मिला है। नई संहिता में कुछ पुरानी धाराएं पूर्णतः निरस्त की गई है, कुछ परिवर्तन की गई है तथा कुछ में शब्दावली संशोधित की गई है। ऐसे मुख्य परिवर्तन निम्न है। इसमें उनको आतंकवाद को, जो अब तक हमारे 1860 के कानून में आतंकवाद शब्द नहीं के बराबर नहीं था, इन्होंने बहुत स्पष्ट किया है। अब तक आतंकवाद को दंड संहिता में परिभाषित नहीं किया गया। अब इसे परिभाषित करते हुए उल्लेख किया गया है कि भारत की एकता, अखंडता, सुरक्षा और आर्थिक सुरक्षा के संकट में डालने का भारत में या अन्य विदेशों में जनता में आतंक फैलाने का प्रयत्न आतंककारी कृत्य की परिभाषा में आएगा। इस परिभाषा में आने वाले विभिन्न तरह के कृत्यों के लिए अलग अलग सजा का प्रावधान रखा है, जो मृत्युदंड और आजीवन कारावास तक का है। संगठित अपराध, मैं सोचता हूँ बढ़ते संगठित अपराधों को रोकने के लिए धारा 111, 111, सेक्शन 1 से लेकर 7 तक इस अपराध को तथा धारा 112, 112 में छोटे संगठित अपराध को परिभाषित किया गया है, जिसमें लूट, अपहरण, भूमाफिया के अपराध, पेपर लीक मामला। मैं सोचता हूँ अब तक इस पेपर लीक के बारे में कभी सोचा भी नहीं था कि यह भी कोई एक नई समस्या खड़ी होगी। मैं सोचता हूँ इस कानून में इस विषय को, जिसके कारण से लाखों करोड़ों बच्चे अपनी ज़िंदगी के साथ एक खिलवाड़ महसूस करते हैं, उसको भी इसमें डालने का प्रयास किया है। वाहन चोरी, हत्या के लिए सुपारी देना, साइबर अपराध, मानव तस्करी, मादक पदार्थ, हथियार, देह व्यापार आदि शामिल किए गए हैं। ऐसे अपराध अधिकतर एक व्यक्ति के बजाय एक समूह द्वारा भी किए जाते हैं। इससे आर्थिक अपराधों के लिए अलग उपधारा जोड़ी गई है। इसमें हवाला, विनियमन, करेंसी नोट, सिक्कों की कूट रचना, पैसे कमाने के फर्जी स्कीम चलाना आदि है। इसमें न्यूनतम सजा का प्रावधान करते हुए आजीवन कारावास की सजा प्रस्तावित है। आर्थिक अपराधों के लिए जुर्माने की 10 लाख, 5 लाख और 2 लाख तक की सीमा की है। महिलाओं और बच्चों के विरुद्ध अपराध, मैं सोचता हूँ इनको जितना स्पष्ट किया है 99 तक, धारा 63 से लेकर 99 तक अपराध की कही गई श्रेणी, गैंगरेप, अभिरक्षा, बलात्कार आदि के संपूर्ण शेष जीवन तक जेल रहने की सजा तथा कुछ में मृत्यु दंड का भी प्रावधान किया गया है। हमने इस पुराने कानून में जहाँ जहाँ आवश्यक हुआ उसमें परिवर्तन किया है, कहीं बढ़ाया है, कहीं घटाया है। तो वाहनों से होने वाली मृत्यु संबंधित, मैं सोचता हूँ आप और हमने सबने जीवन में अनुभव किया है कि वाहन के एक्सीडेंट के कारण से सामने वाला का परिवार बर्बाद हो जाता है, लेकिन जो करने वाला व्यक्ति है उसे किसी प्रकार की चिंता ही नहीं है कि मेरे हाथ से कोई जान जा रही है, तो इसको उन्होंने ठीक करने का प्रयास किया है। इसमें उपेक्षा द्वारा मृत्यु कारित करना, हिट एंड रन कैसे नाम दिया गया है। गत संहिता की धारा 304 में वाहन दुर्घटना से मृत्यु कारित करने पर केवल 2 वर्ष की सजा का प्रावधान होने के कारण उसका दुरुपयोग होने लगा। कई रिपोर्ट, अध्ययन, शोध और सर्वोच्च न्यायालय के निर्णय से प्रकट हुआ कि वाहन दुर्घटना में 46% वाहन अवैध रूप से रजिस्टर्ड थे, जिसके कारण से पीड़ित पक्ष को किसी प्रकार की कोई मदद नहीं मिलती है और वो इतनी बड़ी हादसा सहन करने के बाद भी अपने बच्चों के भविष्य के लिए किसी प्रकार की कोई सुविधा नहीं है, क्योंकि गाड़ी रजिस्टर्ड ही नहीं थी और जो आदमी था वो ड्राइवर उठ कर के भाग गया। उसके बाद ये भी पता नहीं गया कि इसका ड्राइवरिंग कौन कर रहा था। इस प्रकार की जो घटनाएं होती थी उनको एक तरह से इसमें उन्होंने अतः नई न्याय संहिता के प्रावधान किया गया है कि यदि वाहन चालक दुर्घटना के बाद पुलिस मजिस्ट्रेट को सूचित किए बिना भाग जाता है तो पकड़े जाने पर उसे 10 वर्ष तक की सजा दी जा सकती है। तो मैं सोचता हूँ वास्तव में ये जो एक्सीडेंट जो सबसे बड़ी चुनौती है आज हिंदुस्तान में लगातार, मैं सोचता हूँ कोई राज्य ऐसा नहीं है कि एक्सीडेंट से होने वाली मृत्यु की संख्या, हमारे सब प्रयत्न करने के बाद हम बार बार घोषणा करते हैं कि इस साल हम 10% घटाएंगे, लेकिन हमारे सब प्रयत्न फेल हुए। मैं सोचता हूँ इस कानून की कठोरता के कारण से निश्चित रूप से एक्सीडेंट में कमी आएगी, ऐसा मेरा। राजद्रोह संबंधित धारा का अंत, मैं सोचता हूँ अंग्रेजों ने केवल राजद्रोह इसलिए बनाया था कि उनके खिलाफ आंदोलन करने वाले लोगों को सेलुलर जेल में डाल करके 2 जीवन कारावास की सजा दी जा सकती है। हिंदुस्तान के कितने देश प्रेम लोगों को ने, किस प्रकार के लोगों ने अपने जीवन की कुर्बानी दे करके इस देश की आज़ादी को जंग लड़ा, उनको उन्होंने देशद्रोही 124 के तहत एक तरह से सजा देने का प्रयास किया। मैं सोचता हूँ अर्थात मात्र सरकार प्रति घृणा और अवमानना का कृत्य दंडनीय नहीं होगा, उसकी जगह धारा 152 में प्रावधान किया गया कि यदि कोई व्यक्ति भारत देश के संप्रभुता, अखंडता को अलगाववादी क्रिया, कलापों की भावना से खतरे में डालने का प्रयास करेगा तो वह देशद्रोह कहलाएगा और उसे आजीवन कारावास के दंड से दंडित किया जा सकता है। सर्वोच्च न्यायालय ने कहा है कि लोकतांत्रिक देश में सरकार के विरुद्ध कथन जनता का अधिकार है। सरकार की आलोचना करना कोई अपराध नहीं है, लेकिन मैं देश के विरुद्ध आलोचना करना अपराध है और उस अपराध को उन्होंने इसमें एक तरह से जोड़ने का प्रयास किया। कथन जनता का अधिकार है, परंतु देश की अखंडता को नुकसान पहुंचाने का प्रयत्न चिंताजनक है। अंग्रेज सरकार द्वारा इस धारा का दुरुपयोग के कारण हमारे स्वतंत्रता सेनानी लोकमान्य तिलक, वीर सावरकर आदि कई नेताओं को कठोर कारावास और देश के निकालने की सजा भुगतनी पड़ी। पर इस प्रावधान में परिवर्तन को उन स्वतंत्रता सेनानियों को पहली बार श्रद्धांजलि दी है, उसके लिए भी मैं धन्यवाद देता हूँ। मॉब लिंचिंग एक नया प्रकार का अपराध इन वर्षों में खड़ा हो गया, उसको भी इसमें समाहित करने का। भीड़ द्वारा किसी व्यक्ति को बर्बर हत्या की घटनाओं को देखते हुए इसे प्रथम बार पृथक अपराध की श्रेणी में रखा जाकर कठोर दंड, मृत्यु दंड का प्रावधान भी किया गया है। सामुदायिक सेवा नामक नए दंड का प्रावधान, जिसका आपने वर्णन किया, कि मैं सोचता हूँ दंड का यह पहली बार इसे एक नया प्रयोग हुआ है जो वास्तव में सुधारात्मक भी है और मैं सोचता हूँ कि उसे दंडित करने का भी है। पूर्व दंड संहिता 5 तरह के दंड, मृत्यु दंड, आजीवन कारावास, संपत्ति की जब्ती, कठोर और साधारण कारावास और जुर्माना का प्रावधान था। पर वर्तमान समय की आवश्यकता और समाज में रहकर अपराधी को सुधार करने की भावना को ध्यान में रखते हुए सुधारात्मक न्याय व्यवस्था के अंतर्गत दंड सामूहिक सेवा का प्रावधान किया गया है। यह दंड प्रथम बार में 6 तरह के छोटे अपराधों पर दिया जाएगा। इसके लिए कोर्ट आदेश दे सकेगा कि वह समाज सेवा के कौन कौन से कार्यकर्ता हुआ अपना दंड भुगत सकता है। यद्यपि संहिता के सेवाओं का उल्लेख नहीं किया है, किंतु माननीय सर्वोच्च न्यायालय के निर्णय से प्रकट किए गए विचार विदेशों में न्यायालय द्वारा अनुप्राधिक सामुदायिक सेवा से अंतर्गत किए जाने वाले कार्यों को दृष्टिगत रखते हुए दंड में अस्पतालों में सेवा, सड़क सफाई, कचरा बीनना, अनाथालय, वृद्धाश्रम, विद्यालय आदि में सेवा के द्वारा भी उनको दंडित किया जा सकता है। अप्राकृतिक दुष्कर्म और जार कर्म, मैं सोचता हूँ कि माननीय सर्वोच्च न्यायालय के निर्णय को लागू करते हुए पूर्व नई न्याय संहिता की धारा 377 377 अप्राकृतिक दुष्कर्म और धारा 495 जार कर्म एडल्ट्री को अपराध की श्रेणी से हटा दिया गया है। चोरी की परिभाषा का विस्तार किया है। मैं सोचता हूँ केवल जो भी कुछ होता था उसको एक तरह से आप धारा 379 में डाल देते थे और उसके कारण से सब एक सरीका बराबर हो जाता था। देखते हुए चोरी शब्द के अर्थ को विशेष अंतर्गत किया है। अब तक धारा 379 अनुसार चोरी केवल चल संपत्ति वस्तुओं के होने का प्रावधान था। अब इस चल संपत्ति की परिभाषा को डाटा चोरी, पेटेंट चोरी, नॉन लाइन चोरी, क्रेडिट कार्ड, बैंक अकाउंट हैकिंग आदि ट्रिक थेफ्ट को भी शामिल किया गया है। इन सबको भी चोरी में सम्मिलित किया और उसके कारण से इस पर जो सजा का प्रावधान 5 वर्ष तक किया गया है। ये जो चेन स्केचिंग होता है उनको भी आपकी चोरी की धारा में डाल दिया जाता है। मैं सोचता हूँ इसको उन्होंने साफ करने का, रास्ते चलते वस्तुएं छीनने, मोबाइल, चेन स्नेचिंग आदि घटनाओं में हो रही वृद्धि को रोकने के लिए ऐसे अपराधों के लिए झपटमारी नामक नई धारा 304 जो 304 पहले एक्सीडेंट में थी उसको यहाँ उस धारा को डाला है। अब तक ऐसे मामलों में चोरी और आपराधिक बल जैसी धाराओं को शामिल कर दर्ज किए जाते हैं, इसमें कार्रवाई नहीं हो पाती। रास्ते चलते ऐसे कृत्य करने वालों के लिए 3 वर्ष तक कठोर दंड की व्यवस्था की है। इसी तरह नई भारतीय न्याय संहिता के लोकतांत्रिक व्यवस्था के साथ ही जन सुरक्षा हेतु समयानुसार नए वैज्ञानिक तरीकों में जनहित न्याय के प्रावधान जोड़े गए हैं जो प्रजा सुखे। मैं सोचता हूं कि प्रजा के हित में ही उसे अपना हित देखना देश के लिए पूर्ण होगा। यही नहीं, जितने भी रिकॉर्ड रखने के जो तरीके हैं आज के डिजिटल इस युग में जो व्यवस्थाएं हुई है उन सबको भी एक कानूनी रूप देने का प्रावधान किया है, जिसके कारण से सारी एविडेंस को ठीक प्रकार से प्रिजर्व किया जा सकता है। तो मैं निश्चित रूप से समझता हूँ कि पहली बार एक ऐसा प्रयोग हुआ है जिसने हमारा गौरव और सम्मान बढ़ाया है। मतलब हम कम से कम उस गुलामी के बिंदु से बाहर निकले हैं और अपने कानून को अपने लोगों के द्वारा, जो आज के समाज की आवश्यकताएं थी, जिस प्रकार का परिवर्तन हुआ समय के साथ, उसमें कानून और कानून के धाराओं में भी परिवर्तन करके निश्चित रूप से न्याय को ठीक तरह से नीचे तक पहुंचाने का प्रयत्न किया है। आप सब लोग जो यहाँ उपस्थित हैं, आप सारे इस कानून को जमीन तक पहुंचा करके न्याय दिलाने का काम करने की सबसे बड़ी जिम्मेदारी आप सब पर है। मैं सोचता हूँ इस सेमिनार करने के पीछे, दिल्ली में भी सेमिनार हुई थी जिसमें चीफ जस्टिस साहब स्वयं उपस्थित थे, उनके वर्षन भी हमने पढ़े हैं, बाकी लोगों के पढ़े हैं, आज अभी आप सब लोगों के भाषण हुए हैं वो भी इस बात की है। लेकिन कानून बन जरूर जाएगा, कानून को जमीन पर सही ढंग से उतारने का काम हम सब लोगों का होगा। हम उसमें कितने प्रभावी ढंग से इस कानून को नीचे तक उतार कर जिस न्याय की अपेक्षा हर व्यक्ति को रहती है उसके साथ न्याय हो सके, इस मंशा से ही कानून में ये जो 3 नए कानून बनाए हैं, ये आने वाले भविष्य के लिए भारत को दुनिया में और भी आगे बढ़ाने की दृष्टि से एक माइलस्टोन का काम करेगा। हम वास्ते आर्थिक दृष्टि से प्रगति कर रहे हैं, बाकी कई दृष्टि से हमने प्रगति की है, पर मैं सोचता हूँ कि वो न्याय जिसके लिए एक सामान्य व्यक्ति हमसे उम्मीद करता है कि उसको सही न्याय मिले, मैं सोचता हूँ इस और बढ़ने में ये तीनों कानून मदद करेंगे। और दिल्ली के लॉ डिपार्टमेंट ने, जस्टिस डिपार्टमेंट ने इन वर्कशॉप के आधार पर आपने ठीक जनता तक इस मैसेज को पहुंचाने का जो प्रयत्न किया है, उसके लिए आपको बहुत बहुत धन्यवाद। और यहाँ के सभी अधिकारियों ने मिल करके ये नॉर्थ ईस्ट में यह जो वर्कशॉप आज यहाँ हो रही है, मैं और नॉर्थ ईस्ट के लोग आपका बहुत एक तरह से आभार व्यक्त करते हैं कि आपने हमारा ये स्थान चुना और हमारे वाइस चांसलर साहब और हम सब लोगों ने मिल करके प्रयत्न किया है कि हम इस कार्रवाई का अच्छी करें। मैं सोचता हूँ जिस मंशा से 2 दिन का डिस्कशन हुआ और जो अभी उन्होंने सारे 2 दिन में क्या क्या हुआ उसका डिटेल आप और मेरे सामने रखा, मैं सोचता हूँ हम इसको ठेठ नीचे उस तक पहुँचाएँ जिसको इसकी आवश्यकता है। धन्यवाद।
Thank you, sir. The successful overhaul of the criminal justice system is predicated on a seamless transition to the new order by the legal fraternity as much as civil society. To that end, we most sincerely appreciate your deeply insightful perspectives. I would now request Dr. Anju Rathi Rana, Additional Secretary, Department of Legal Affairs, Ministry of Law and Justice, to kindly deliver the vote of thanks.
Honorable Governor of Assam, His Excellency Shri Gulab Chand Kataria ji, all the dignitaries on the dais and off the dais, Namaskar and a very good evening, ladies and gentlemen. As we conclude this enlightening national conference on Bharat ki Nai Aparadhik Nyaya Pranali, Ek Pragatishil Kadam, that is, India's progressive path in the administration of criminal justice system, it is with great honor and gratitude that I extend a sincere vote of thanks on behalf of Department of Legal Affairs under the aegis of Ministry of Law and Justice, Government of India, to each one of you present here today. In this distinguished gathering, we are privileged to have legal luminaries, experts, policymakers, legal practitioners, judicial officers, public prosecutors, police officers, academicians, and other stakeholders from across the northeastern states. Your diverse backgrounds and expertise collectively represent a comprehensive spectrum of perspectives crucial to the advancement of our shared goal, the pursuit of justice and the strengthening of our criminal justice system. The theme was carefully chosen to acquaint everyone with the 3 new criminal laws, that is Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023 and Bharatiya Sakshya Adhiniyam 2023, and to elevate awareness amongst legal minds. When we first envisioned this conference in Guwahati, we hoped it would be a forum for profound change and collaboration. Today, as we conclude, I can confidently say that our hopes have been exceeded thanks to the incredible effort and passion each of you has brought to this gathering. I expect and I extend my utmost gratitude to the dignitaries sitting on the dais today who took out their precious time to preside over our valedictory session, to grace us with their presence today. Your wisdom and encouragement have profoundly enriched this conference, and we are deeply honored by your support. I would like to extend our heartfelt thanks to the Honorable Governor of Assam, His Excellency Shri Gulab Chand Kataria, for his esteemed presence, which underscores the significance of our collective efforts in advancing the cause of justice and upholding the rule of law. I would also like to mention special thanks to Honorable Mr. Justice Vijay Vishnoi, Chief Justice Guwahati High Court, Honorable Mr. Justice Manas Ranjan Pathak, Judge Guwahati High Court, Honorable Mr. Justice Arun Dev Chaudhary, Guwahati High Court for their gracious presence today. I also wish to express our gratitude to Honorable Mr. Justice Mir Alfaz Ali, Vice Chancellor in Charge, Naluja, Assam, and Director of the Indian Law Institute, Professor Dr. V.K. Ahuja, for their invaluable support and partnership in organizing this landmark conference. I would also like to extend my sincere gratitude to Honorable Mr. Justice Rishikesh Roy, Judge Supreme Court of India, Shri Arjun Ram Meghwal, Honorable Minister of State for Law and Justice, Independent Charge, Honorable Mr. Justice Biswanath Samadar, Chief Justice, High Court of Sikkim, Shri Ravi Kota, Chief Secretary Assam, and Dr. Rita Vashisht, Member Secretary Law Commission of India, for their gracious presence during the inaugural session. Deepest gratitude is extended to our respected Minister of Law and Justice, Independent Charge Shri Arjunram Meghwal, and Union Law Secretary Dr. Rajiv Mani, whose visionary idea paved the way for this remarkable event, showcasing exceptional leadership and foresight. My speech would be incomplete without conveying gratitude to the Office of Chief Minister Assam, Shri Ravi Kota, Chief Secretary Assam, Shri B. Kalyan Chakravarti, Principal Secretary to the Government of Assam, and their entire team for their seamless coordination and unwavering support, which have been instrumental in the successful organization of this conference. I extend my special thanks to all the officers present at our last meeting on the 16th of May 2024, whose meticulous efforts and commitment ensured that no stone was left unturned in making our conference a grand success. I am deeply indebted to the Judicial Department of Government of Assam, and I acknowledge the uncountable meetings which we have with Shri Bharatiya Hazarika, Shri M. Barbuya, Shri Nilam Kaleta, Shri Hitler Pegu, Shrimati Purbi Kaleta. Your tireless work and cooperation have been the backbone of this event. Furthermore, I would like to express my sincere gratitude to all the principal secretaries, and particularly my special mention to the Director General of Police Assam, Shri G.P. Singh, for sending 500 officers of Assam Police to attend this conference. Your dedication and efficiency have ensured that this event was conducted with the highest standards of professionalism. आपका बहुत बहुत आभार और दिल से धन्यवाद. I extend my gratitude to the Director of IIT Guwahati, Professor Devendra Jalihal, and his team. Thank you for graciously hosting us. To our esteemed delegates and participants representing a diverse array of background and expertise, I extend my sincere appreciation for your active engagement and enthusiastic participation. To all the attendees, whether here in person or joining us virtually, your active participation and keen interest have been the driving force behind this conference. Thank you to the ITBP, police officers, public prosecutors, CBI, NCB, NIA, BSF, SSB, CISF, CRPF, and ED officers from all over the northeastern states. To the CBI prosecutors, NEPA, and the prison officers from the various states who have attended this conference. And all the officers coming from the 8 northeastern states, Tripura, Mizoram, Nagaland, Arunachal Pradesh, Manipur, Sikkim, Assam, and Meghalaya. You traveled all the way from your respective states to this venue, and that means a lot to us. A heartwarming acknowledgement to all the faculty and students from various law schools who have joined us today, and to the media partners, including PIB, for giving a wider coverage to this event. Last but not the least, I wish to acknowledge the efforts of our organizing committee and extend my gratitude to all the officers of Ministry of Law and Justice, all my young professionals and interns, support staff and volunteers who have contributed to the success of this event. Your hard work and dedication have been instrumental in making this conference a resounding success. Thank you once again, esteemed guests and participants, for taking out time from your busy schedule and attending this conference. अंत में मैं उन सभी का आभार प्रकट करती हूँ जिनका नाम मैं समय के अभाव के कारण नहीं ले पाई। कानून एवं न्याय मंत्रालय विधि कार्य विभाग की तरफ से मैं उन सभी का दिल से धन्यवाद करती हूँ। आप सभी ने जो मेहनत और समर्पण दिखाया है उसके लिए हम आभारी हैं। ये कॉन्फ्रेंस हमारे देश के क्रिमिनल जस्टिस सिस्टम को सुधारने की ओर एक महत्वपूर्ण कदम है। एक बार फिर से दिल से आप सभी का धन्यवाद और शुक्रिया। I would like to end by mentioning a famous quote, "Injustice anywhere is a threat to justice everywhere." Signing off with that thought, may the principles of justice continue to guide and inspire us as we navigate the path ahead. Let us carry forward the spirit of collaboration and enlightenment fostered during this conference as we continue our collective journey towards a more just and equitable society. Thank you all. Jai Hind, Jai Bharat.
Thank you, ma'am. Ladies and gentlemen, with this, we have come to a close of the valedictory session. I would now request all present to kindly rise for the national anthem. Thank you. I would now request our esteemed guests to kindly proceed for high tea. Have a very pleasant evening. The right exit is not to be used right